Good morning, Mr. Ali.
Good morning, Chief Justice.
Did I pronounce your name correctly?
Ali is correct.
Ali, all right.
I have cousins that say Ali, but I'm Ali.
Okay. I always worry. I don't like it when people mangle my name, which is the bane of African names. I see that you and I share a birth date, and I mentioned this because not many people are born. Well, I don't know. Maybe you're the third person I've come across who was born on that particular day. So I'm excited about that. Are you well?
Nervous,
Nervous,
Chief Justice.
but comfortable enough to
Yes.
start with the interview?
Yes.
All right, let's get to it then. Uh, you hold 2 degrees. You did a BA, then did an LLB.
That is correct, Chief Justice.
The BA at the University of the Western Cape.
That is correct, Chief Justice.
Then you went to Rhodes.
That is correct, Chief Justice.
You started out as a teacher.
Chief Justice, if you recall, in those days, we had bursaries, and in some way you had to pay back the bursary. My BA had teaching subjects, so I was able to teach as a category C, and then I returned to Rhodes to complete my LLB.
Oh, I see. What subjects did you teach?
Science, biology, and then the whole school vocational guidance.
Oh,
Because one of my majors at UWC was psychology.
all right. So you did that for 2 years,
That was from
1984.
84 to 86, so 3 years.
No, 3 years.
Yeah.
And you then decided to pick it up and become an advocate.
Yes, I returned to complete the LLB, which I completed, and then admitted in August of 89.
Okay. What did you practice as an advocate? Your questionnaire does not
Gqeberha.
state. Sorry?
Gqeberha, formerly
Port Elizabeth. All
Yes.
right. For 7 years.
Yes.
Then you left, and well, the Department of Education called you back,
Yes, Chief Justice.
and you worked there as a legal advisor for how long?
I left in 2001, so that is more or less 4 years, Chief Justice.
And then you left the Department of Education and joined the Secret Service.
Yes. As a legal advisor, and then later on a director in one of the departments.
And you remained there for 11 years. I counted.
Yes, because I returned to the bar in 2012.
In 2012.
Yes.
Yeah, and you are still there to date.
Yes.
Where? Here in Johannesburg?
Yes, Chief
All
Justice.
right. You mentioned in your application form that your practice centers mostly around personal injury law.
That was here in Johannesburg. Personal injury as well as public, in the sense of claims against the Minister of Police, where I acted for the state attorney.
Yeah. And you state that you have not done any administrative law work that involves administrative law, constitutional law. And the only areas of civil law you've worked in is divorce and personal injury law.
That is
That is the
correct.
case.
I do indicate later in the documentation that I dealt with those matters as an acting judge.
Yes,
But
yes, you
yes,
do. All right. You've acted intermittently since 2020, you say,
that is correct, Chief Justice.
and for how long do you total up those stints to?
It appears to be around 61 weeks.
And you've written judgments.
That is correct, Chief Justice.
Any idea how many those could be?
Chief Justice, it could be uh, because of the nature of the proceedings that I presided over, it could be over 20,
Any reported?
none reported.
Okay. Well, I'll leave it to Judge President Mlambo to flesh out what kind of work you have done during your acting stints. What I want to ask you about are the reserve judgments you list in your application form. Have you delivered them yet?
But not all, Chief Justice.
Which ones have not been delivered?
The,
You list them at page 15 of the bundle. Although one of the professional bodies says they found more, 3 more to add
yes,
to your list.
the ones that are there now, Chief Justice, is at page 15 at 9.5. The one still outstanding is the one of Alexander.
Sorry, which one?
The first one,
The first one.
yes,
All right. The others have been delivered.
yes.
Okay. That judgment was reserved on 10 July last year. What has been going on there?
Yes, Chief Justice, this is one that has had me busy, and I'm trying to my best to deliver it, and I know I've said previously it will be delivered this time, that time, that time. But it must be done and will be done, Chief Justice.
When do you hope to have it delivered?
Well, finally, it must be done by the end of this month.
The end of October.
Yes. If it's there's if it's sooner, the better.
Yes. The worrisome thing, Advocate Ali, is that all these reserve judgments were reserved months ago. Well, when did you deliver Foster and Lebitze, which were reserved in August and October 2023?
Recently, Chief Justice, the dates I can't give you
No, it's
at the
fine, but you
moment.
say recent. How
Yes.
recent?
It could be 2 months ago.
About 2 months ago.
Yes. But it was after the submission of the application.
Then the remaining 3 on your list were reserved in February, which is several months ago. Were they also delivered about 2 months ago?
I would think so, Chief Justice.
Yeah. Well, the the General Council of the Bar reports that they found at least 9 outstanding judgments. So which are the other 3? Well, they say at least 9. They don't say 9, so there could be more. But let's focus ourselves on the three, the extra three. They specifically mention. Which judgments are those?
Chief Justice, I can't off the top of my head remember which ones those are in respect of, I thought the documentation of the General Bar Council would have been here, and I thought they would have, but the ones, as I understood their comments and objections, it had to do with the length of time, as you have already also expressed, Chief Justice. But off the top of my head, I can't think of the other three.
Do you deny that there are more than the 6 you have listed? This is what I'm concerned about.
No, I don't.
You don't?
No.
But are you working on them?
Yes, Chief Justice.
This is extremely worrisome, Advocate Ali. You would be aware of the existence of norms and standards that enjoin judges to deliver judgments within 3 months of the hearing of the relevant matter, and certainly no later than 6 months from the hearing of the matter. And
Yes, Chief
here you
Justice.
are, you have a whole pile of late judgments, some over a year, by over a year. And now we have professional bodies. In fact, I want your comment to what the GCB, which I assume you remember of, it says it would send an acceptable message to the public at large if you are appointed. What would you say to that?
Chief
And they
Justice.
point out that the ability to deliver judgments expeditiously lies at the heart of dispensing justice.
Yes. Chief Justice, all I can indicate, I acknowledge, because it's factual what they say in terms of the delivery. All I can indicate is that it will be my endeavor, and it must be, that the judgments get delivered within the norms and standards policy.
What has been your challenge? Why have you delayed these judgments?
Chief Justice, in some instances it would have been, but it wouldn't have been that long. This is why in some instances it was an issue of ill health. In other issues, it's a matter of I type my own judgments, but to me that doesn't really necessarily explain away the fact of the lateness of the judgments, Chief Justice.
And what guarantee does the judiciary have that if you are appointed, you will not continue on this track?
Chief Justice, I can today then express myself to say that I would. And furthermore, the JP is a hard taskmaster in respect of matters of this nature.
Well, he has not been able to crack the whip hard enough, because here we are, hard taskmaster as he may be.
Yes, I accept that.
All right, thank you, Advocate Ali. I'll hand over to JP Mlambo.
Thank you, Chief Justice.
Thank you, Chief
Questions to you.
Justice. Good morning, Advocate Ali.
Good morning, JP.
Thank you for availing yourself. I just want to touch on a few issues. Let's start first with your exposure and familiarity to the work in the Gauteng division. You've admitted you've acted for a period of 61 weeks totally.
Yes, JP.
And in that time, according to the spreadsheet in front of us, you've done 7 weeks in the opposed motion court.
Yes,
And you'd agree with me that that's one of the areas where judges accumulate reserve judgments.
that is correct,
Because
JP.
in a week, if you are in that role, you are lucky if you get less than 12 opposed motion matters for that week.
That is correct,
Right.
JP.
The other area where you would generate reserve judgment is the special motion role. There, you've done 2 weeks there.
Yes,
That's also,
JP.
in fact, it's the most difficult because that has the most complex opposed motions, isn't it?
Yes, JP.
Yeah. And then the other area, I see you've done 2 weeks of urgent court.
Yes, JP.
Yeah, and I can tell you and the commission, well, you know it. I don't easily put acting judges in the urgent court week because the Gauteng urgent court week, you need to smoke something to be allocated there.
Yes, JP.
Right. But I think, to be honest with you and the commission, having done 61 weeks, one would have expected you to do more work in that role because you would have got familiar with the work of the division, seeing that you only were allocated to the last year to the urgent court week, having acted since 2020. But the fact that it's only 2 weeks should be something that you need to explain. I know I do the allocations, but as I say, I've explained to you that I need to have the confidence that the acting judge will deal with the work if I put them there.
JP,
Yeah.
the issue of the urgent court, as you say, you do the allocations. And in 2022, 2023, and this year, I think I started the urgent court last year and again this year. So
Yeah.
that's the 2 weeks.
Yeah.
I am available and I have been available. So I can't really answer it differently,
Yes.
but to say that I am available.
Yes.
Whether because your question somehow seems that you indicate you want to be confident in the people you put there. So I was of the view that that I would get more,
Yes.
but I didn't.
No, I'm not blaming you. I'm just saying it's my confidence. And I think partly the issues the CJ raised with you
Yes.
informed my decision why. Because
Understood.
in a normal agent court week alone, there's 2 judges there alone, you are lucky to get less than 30 opposed agent motions that week. Am I correct?
Correct.
Yeah. So it's a heavy work area.
Correct, JP.
Right. Now, that's the exposure you've had. So I want to tell you now, I have my own scoring metrics as to how I score candidates. So the allocations themselves and the work you've done I also will have to score you, but it will be informed by the number of weeks you've done in each particular week, especially the difficult work areas. You understand that?
Yes, Jay.
I want you to know that. Right? Now, let's come to the judgment you've written. You've listed 16 judgments. Check the list there in front of you.
Yes.
The reason I'm mentioning this is someone because we've got some of your competitors today who've acted probably half of the time you've acted, who've written a lot more judgments than that. Are you not shortchanging yourself here? I mean, you've acted for 61 weeks. You've done 7 weeks in the opposed motion court. That's a lot of work. Where are the other judgments?
Yes. JP, if I can just explain.
Yeah.
There are more than these judgments.
Yes.
There was a computer crash, my own, and you will recall in 2020,
Yes.
the case lines hadn't really started
In
2020. When
started.
at the beginning of 2020, some matters were on case lines and
Yes.
others not.
Yes.
And so when I was going through the judgments that should have been somewhere, you wouldn't find them on case lines.
Yes.
Because they weren't uploaded on case lines and we would have had the files. Same with opposed motion court in 2020. I would have had the files with me rather than on case lines. And what did help us post or during March is that, if I'm not sure, there was a directive that all matters would be on case lines. This is during the COVID period,
Yes.
which assisted us greatly.
Yeah. Okay. Look, I understand your explanation, but we give you a bench book, don't you?
Yes,
We give you a bench book, and that's where you record all the matters you hear. And if the matters were done in paper form, your bench book is the first go-to source to check which matters did I hear, where's the judgment, isn't it?
yes, JP.
Yes.
I must indicate, in my first stint,
Yes.
I didn't take my bench book with me.
Okay. Okay. Now, let's come to your judgments. The CJ has already traversed that area. You know that my division is the first one to have had judges being disciplined for failure to reserve judgment. Do you agree with me that that is the overall primary existential basis for a judge to decide the matters that come before them?
I agree with you, JP.
Yeah. So, don't you think, I think, let's just debate this. You are here, and I've actually been open-handed and give you acting stint. Do you think you could benefit some more if you are given more acting time, and then to see if these judgments that keep on cropping up and taking long to come out becomes a thing of the past?
Yes and no, if I can
Yes.
put it that way,
Yes.
JP. I'm not 50 anymore, and time is moving on.
Yes.
It is so that more time will be beneficial,
Yeah.
but that time as a judge also would be, and as I've indicated to the Chief Justice, that if given the opportunity, there would be great improvement in that area.
Yeah, yeah. So, as I indicated to you, I have my own scoring matrix that looks at particular areas. It's four areas. One is about judgments, one is about exposure, those two. If I were to ask you sitting there, your performance in reserving judgments and in handing down judgments, out of 5, how much would you score yourself?
2.5.
2.5. Okay. Well, thank you very much. CJ, I'm done. Thank you.
Thank you, JP. I'm sorry, in the rush to start the proceedings, I forgot to welcome Judge President Tlaletsi, who represents the heads of court in Judge President Mlambo's place this morning, and Premier Lesufi, Gauteng Premier, who is here to make sure that we don't bring back judges to his courts. Good morning and welcome, JP and Premier. Premier, on that note, do you have any questions for the candidate?
Thank you so much, CJ. Truly appreciate. Thank you. Let me also greet fellow commissioners. Good morning, Advocate Ali.
Good morning, Premier.
Thanks. Just to belabor the point of allocating yourself 2.5 on outstanding judgment, is it lack of capacity or is lack of support?
Definitely not capacity, because capacity would mean that you are unable to come to, my understanding of, you are unable to come to grips with the matter that is before you. The support part is, as I indicated to the Chief Justice, is one of the areas, but shouldn't be the main area of justification.
Question is, I saw when you listed your experience and background in legal matters, you literally listed everything rather than the part of support that you're providing at the South African Secret Service. I assume it was also related to legal work, but I wonder why you didn't list it as part of the work that you've done that is related to law or legal work.
It's probably but it is contained in my CV. I'm not sure why at the present time I didn't list it then. But I did do legal work at the Secret Service also.
Thanks so much, CJ. Thanks.
Do you have questions, colleagues? JP Tlaletsi?
Thank you, Chief Justice. Mr. Eli, I just want some clarification from the answer that you gave to the Chief Justice regarding the fact that the GCB seems to have picked up more judgments outstanding than you disclosed. And the answer you gave is that you do not deny that, but you cannot remember them on top of your head. But later you said that you are working on them. Is that a fair understanding of what you said? And if that is the case, will you kindly explain that?
I thank you, JP Tlaletsi. When the question was posed, I said I do not deny it, and I said I am working on them. The two don't seem to marry when I think of it, you having posed the question.
I see. Thank you.
Yes, no.
Continue, sorry.
What I was was meaning, if I had sight of them now, I could tell you they actually have been delivered or they haven't been delivered. And therefore I would be working on them. That's the best way I could explain it.
I see. And then my second question is, there is this problem of practitioners who are acting both in the high courts and the magistrates' court, not delivering judgments either timeously or at all. Now, if you remove yourself from the fact that you could be one of those and look at things objectively, what advice would you give us to the heads of court and the JSC as to how to deal with this problem?
I think the issue has already started in the sense that my JP has started the ball rolling in respect of issues of this nature. And the more that one implements the policy, I would believe that down the line you'd get less and less deficiencies.
Do you see the LPC having any role to play in this regard, and what role can it play?
I'm not sure how, although the LPC can play a role when matters of that nature are reported to them. If memory serves me right, where acting judges are remiss or misconduct themselves, those matters would be reported to the LPC.
See. Well, I'm asking this also because you'll find that practitioners owe judgments, but they appear almost on a daily basis before the same courts in which they owe judgments, be it in the lower courts and the high court. And if I follow up on the suggestion that giving a further acting stint would resolve the problem, will that not be tantamount to rewarding someone who's not able to deliver?
JP, it's not, you give the person the chance, and further acting stint presents itself to improve that particular person. And that's the best way I would answer it.
And would you agree that you should also balance that against the interest of the litigants and the public in general?
Absolutely.
Whether not to expose them to such a situation.
Absolutely.
And make them guinea pigs in that regard.
I agree.
Thank you, Chief Justice. Thank you, Mr. Ali.
Thank you, JP. The DP zone.
Thank you, Chief Justice. Good morning, Advocate Ali.
Good morning, Commissioner.
I've just gone through your questionnaire. And more especially, I just want to refer you to page 9 of the paginated bundle. It's a section dealing with the court experience. Now, based on the information that we have provided in this questionnaire, surely it's difficult for one to assess your suitability, whether we could, at the conclusion of this session, recommend you. I'm not sure if, based on the information that you have provided, because you are marketing yourself, you should have given us more information that will sort of guide us in interviewing you. Would you agree with that statement?
I agree.
The other thing that concerns me, paragraph 6.2.4, labor law experience. You said as an assessor, as an assessor in the labor appeal court, I've sat in that court on a number of occasions, and we have never used the assessors. Where does it come from?
In the Eastern Cape, the Labor Appeal Court, if I could, I'm not sure of its citing. I was, Judge Kruan invited myself and Professor Grogan to assist in the appeal. I called it assessor because at the time, I was an assessor in the criminal courts and I was invited to assist Judge Kruan in one of the appeal matters he was dealing with.
I'm not aware of that practice because we would do Johannesburg, Cape Town, Durban. I also did labor appeal court cases. I also sat on the labor appeal court cases in the Eastern Cape. So we have never used the assessor.
JP, I'm not sure whether the term could be described as correct, but I did preside with Judge Kruan. And this would have been around about 93, 94.
Unless maybe it was an industrial court, but not the labor court. Thank you. No further
Thank you.
question.
Thank you.
CJ.
Minister.
Thank you, CJ. Good morning, fellow commissioners, and good morning, Advocate Ali.
Good morning, Minister.
Thank you very much. I know CJ touched on the issues of outstanding judgments. I'm just finding it hard to be convinced on how you will improve given the reviews that have been outstanding and how you have handled them previously. It doesn't suffice to me to say I will definitely do them better. What is the plan that you have? I mean, for example, in the case of Alexandra, the one you say is still outstanding. It's a very painful matter, actually. It involves a minor child, and there's a long history in when the matter said 3 times you have set deadlines for yourself. Even at the intervention of the Deputy Judge President, you committed that you will give a judgment on the 29th of March. You did not meet that deadline. The Office of the Deputy Judge President tried to intervene, and you undertook to finalize the same judgment on the 22nd of April 2024, which is a month later from the first commitment you made. You also did not meet that. And then the matter was escalated to the Judge President himself on the 3rd of July 2024. And you addressed the letters to the parties who are the attorneys and the family, the complainant, on behalf of the minor child. And you said the judgment will be dealt with on the 5th of July 2024. You are apologizing. You still did not meet this deadline. And today we are in October. We are still without this judgment, and you are saying to the commissioners here, you will improve on this matter. I think really right up to the office of the judge president, including the deputy judge president, this matter should have been resolved by now. At least it should have been finalized from your side. Do you have any comment there?
I can't comment further than what I have indicated, Minister. And I indicated to the Chief Justice when I would be finalizing, and I understand the frustration with that statement, taking into account what you have just read out. And I cannot put it any further than what I have, Minister.
So would you agree with me if I really question your commitment to the rule of law on the basis of all these chances you have been given? Look, this is a minor child with cerebral palsy. Rightly or wrongly, whether the case that has been put forth uh, uh, for the payment for future medical expenses. So a legitimate question will be, currently what is the state of this child if we are unable to assist, at least from the handing down of the judgment? Do you think you have acted to the best of your ability in this matter, at least in trying to give justice to the minor child?
Minister, I don't want to justify the issue regarding when it will be delivered. In this matter, it's one that is somewhat different. There are matters that have been dealt with, and the ones that are outstanding now is dealing with the issue of the public health defense and so forth. So there are other medical expenses, and if I remember correctly, the hospital itself is providing, and the child still goes to that. But that doesn't take away the issue, Minister.
Thank you, Minister. You may ask a follow-up question. Please.
Just to end this quickly, who nominated you? Who nominated you for as a candidate?
I nominated myself.
Who accepted the nomination?
I just nominated.
You nominate? Okay.
I really don't.
No. Okay. Let me assist you this way. You nominated yourself, and then you accepted your own nomination. So, what is it that the advert requires that persons must be nominated? Did you read the advert?
Yes.
Does it not require that a person must be nominated for the position, rather than persons nominating themselves?
I'm not going to debate it, because the nomination doesn't say by whom.
No, I just want
But it is what it is, as it's there, and I can't take it any further than that.
no, just so that we don't go further with your interview. Look, correct yourself, correct me if I'm wrong. You are not supposed to be here because you have not been nominated. You are not supposed to even be here. Thank you, Chief Justice. I think at this stage we should end with your interview, but you can convince me. That's what I'm going to argue, that you are not supposed to be here.
Chief Justice, all I can say is I applied, there was the nomination, I was shortlisted, and that is why I'm here. I cannot say I'm not coming.
Yeah, the question is how, how did you get shortlisted?
Unfortunately, Chief Justice, I'm not in charge of that particular process. And I think it's a bit unfair
No,
for,
I have no quibble with. I'm not expecting you to answer that question. You did not shortlist yourself.
yes,
But I'm just quipping myself because I did look at your nomination and I did, because there's a consent. You nominate yourself, then you consent to the nomination. That's what I did not look closely at this because I saw your consent. And I completely missed that you were consenting to your own nomination of yourself. That's quite bizarre, to say the least. And anyway. Okay, Commissioner Kunyan, your hand was up first.
Good morning, Chief Justice. Good morning, fellow commissioners. Morning, Council Ali.
morning, Commissioner.
Mine is one question only. You know for a fact, as Council, of the often quoted expression, justice denied, delayed is justice denied. Just for a second, remove yourself from that chair and put yourself in my chair. Would you be justified to recommend to the president the appointment of a person who has delayed justice, in dispensing justice, who has delayed dispensing justice for over a year? Would you do that? Would I be justified to do that?
Commissioner, it's difficult for me as the candidate to answer you regarding your prerogative. What I can indicate to you only is that on the objective facts before you, you will make your decision as to whether I am worthy of appointment to a permanent post as a judge.
Thank you, TJ.
I'm not happy with that answer, Advocate Ali. One of the hallmarks of a judge is impartiality. You should be able to divorce yourself from the fact that you are a candidate and give an honest answer to the question. You should be able to do that. And I'd like you to answer Commissioner Nkonyana's question honestly.
Chief Justice, what I was trying to impart was that there are judgments here and there are other judgments which obviously are not before you, which have been delivered on time. And I'm saying one must have a holistic view on what that particular candidate has done. Rightly so, there are those judgments which are factually correct, that they have been reserved for a long time, but there are others that have been delivered on time. And hence I was saying that one would look objectively and say, do you penalize for the whole or only for the part?
Chief Justice, perhaps to help, can you answer my question yes or no? That's it. That's what I want. I heard your explanation, and you have tried to explain before. All I want, would you do it yes or no? That's it.
Chief Justice, I find it difficult to answer the question yes or no, having given an explanation. You asked me to explain, and I
It's all right if
explained.
you're struggling with doing what he's asking of you. We can move on. Commissioner Lekhanyan?
No, Chief Justice, just to make a follow-up on the questions that were asked by Commissioner Simelan, Commissioner Minister, and Commissioner Premier. I want to refer you to Section 28 of the Constitution, which is contained in the Bill of Rights, which speaks on the rights of children and related national legislation. And you can also include other international conventions. Where you stand as a candidate, do you think that what the minister asked you about a minor who has a specific health condition, doesn't that constitute a violation of the rights of children or substantial injustice on the part of that child? Having delayed that judgment for over a year, what is your judgment on that matter? If we have to make a judgment on your failure, what becomes your judgment? Doesn't that constitute gross violation or substantial injustice?
I can indicate to you, Commissioner, as I indicated to the Minister, the nuance in respect of this case. And I would answer yes and no to your question.
Your answer is yes and no.
Yes, because of the explanation.
Okay. Let's leave it there. If you were one of the drafters of the Constitution of the Republic of South Africa, why would you think that the drafters allocated themselves ample time to decide that the rights of children must be included in the Constitution?
Commissioner, the rights of the children being included in the Constitution speaks to the vulnerability of that of those or that section of the population and needs protection.
Okay. The last would be what Commissioner Lesufi has asked, whether the problem on your part is with regard to capacity or lack of support. And you have been asked several times here, you are unable to come clearly before this commission to say, I have 20 outstanding judgments and I'm planning to deliver 16 of them on the following dates or in this period. And the remaining number will be delivered in the period that will follow. You have been very dithering and very reluctant to respond to this question. Just to give the exact, a judge, remember, a judge is not an ordinary person in society. You cannot behave yourself like a person who has not seen the inside of a book. You have to be very honest with us if you think that you are a fit and proper person for these positions that have been advertised to. Tell the Chief Justice or the JP, who are your supervisors? How many outstanding judgments are there? And what is your plan to deal with them? If you can't account to your supervisors, must we call you before Parliament to come and account before Parliament? When your immediate supervisors are here, they want answers from you. Why aren't you giving them those answers? How many outstanding judgments do you have, and what is your plan to deliver them?
Commissioner, when answering the Chief Justice in relation to the one matter, I indicated when I would be doing that. In respect of the others, which I indicated off the top of my head, I don't have, I can't indicate to you the number off the top of my head. But I indicated to the Chief Justice that I am working on them. And in respect of your specific question as to when those would be delivered, I would indicate the timeline of end of November.
You know, I did not want to be hard with you earlier, but I have to mention to you that from my experience, and I know that I speak for all judges, nothing is as heavy, as burdensome as a reserve judgment. It haunts you until you have delivered it. It is extremely worrisome that you can't even remember. You say you are working on them, but you don't have any detail. You can't remember. You can't give us any detail on these judgments you're supposedly writing now. I find that strange. I find that very, very strange. Do you have a comment?
Chief Justice, as I indicated, the ones that were in here, that the one is outstanding in the
Yes,
questionnaire.
you have, and you've given an undertaking to deliver it by the end of October. But we're talking about this, the at least 3 that the General Counsel of the Bar has mentioned.
And what I was indicating to you, Chief Justice, is at present I don't see the judgments that they're indicating, and I'm indicating that they could have been delivered already, but that was my only reservation with the 3 that you had mentioned that the General Counsel of the Bar had mentioned.
But then you had said you don't deny that there are such outstanding judgments, that is the problem.
Yes, Chief Justice.
So what do you mean you don't deny that there are such outstanding judgments, and then in the same breath, they could have been delivered?
Yes, I understand. I should just remain with my answer that
Which is?
which I had given you previously, that I am working on them. Because you can't have both answers.
All right. Commissioner Hassan? Where did she go? Any questions? Commissioner, Commissioner Gotzel.
Thank you, Chief Justice. Good morning, Advocate Ali.
Good morning, Commissioner.
With reference to news reports that civil claims in Gauteng's courts might only be heard in 2028, it was recently reported that legal professionals are at their wits' end over the longest backlog in history. Now, in your view, what is a judge's role in ensuring expedience in the administration of justice? And I don't want you to go back to reserve judgments. This is a general question.
The statement of the backlog, in my view, doesn't speak to the expedience of the court, because the expedience of the court is about how many matters come before that particular division. And are you able to have your matter heard? That is one issue completely, and which is different from the judgments that are reserved after the matters have been heard. As I see it, the backlog is that claimants or litigants are not able to get to court because of the backlog. Not that they have not had judgments on matters. I'm not sure if I explained the issue, because when you read out the backlog, then you asked about the expediency.
No,
Leaving out reserve judgments, you said.
Yeah, and I think you misunderstand me. My question is, what is a judge's role in ensuring the expedience in the administration of judges? I understand what you're saying, but there are obviously many factors that contribute to a delayed court roll. But what could you do as a judge to assist that problem?
Well, I know in the Gauteng division, in Johannesburg and Pretoria, there's meetings upon meetings regarding how we can get the backlog down. And I think the JP answered in the media also that we have pro bono counsel and attorneys that have been taking it upon themselves to make themselves available so that matters can be cleared. And I think that is a good initiative.
Thank you.
Are there any questions from the virtual platform?
Thank you very much, CJ. Good morning, Advocate Ali.
Good morning, Commissioner.
I want to traverse a different line of questioning with you. As you know, that Gauteng is the place where usually the state will be sued, and some of the state departments will be sued on the basis of administrative law. I just want to ask you this question. Should you be successful, you will be expected to have a good grasp of administrative law generally. My question to you is, can an organ of state utilize the provisions or utilize PAJA generally for the purposes of reviewing and setting aside its own decision?
Can you just repeat the last part? I think there was a distortion at the end.
All right, let me repeat the whole thing. Can an organ of state utilize the provisions of PAJA for the purposes of reviewing and setting aside its own decision?
My answer would be yes, that they would approach the court to have a decision set aside on the basis of the unlawfulness of that decision.
No, well, the answer seems to be contrary to what the Constitutional Court said in State Information Technology. Let me ask a different question. What is the difference, if any, between a review process under PAJA and a review process under the principle of legality?
The review process under PAJA is dealt with in terms of Section 6, memory serves me right, and deals with the processes that would be against the administration of justice. The issue of legality is dealt with more constitutionally in terms of what decision has been taken, whether that particular person has traversed the rule of law in coming to that decision.
Well, I have difficulty understanding that, Advocate Ali, but I will leave it there, CJ. Thank you very much.
Thank you, Prof. Thank you very much, Advocate Ali. We've reached the end of your interview.
Thank you, Chief Justice.
Good morning, Prof.
Good morning, Chief Justice.
How are you?
I said this morning to my husband, I'm appropriately nervous for the importance of this day, but I'm very happy and honored to be here. Thank you.
Good. It's good to have those butterflies. They keep you on your toes. You hold 3 degrees from Stellenbosch, BA International Studies,
That's right.
an LLB,
Yes,
and an LLD
that's right.
on expropriation of property under the South African Constitution.
Yes, compensation for expropriation under the
Yes.
Constitution, yes.
And you say your doctoral thesis for this degree was the first extensive contribution in the country on the subject.
That's right. I thought at the time I have to finish quickly because it's going to become irrelevant.
Yeah.
And that was not the case.
So you started out as a postdoctoral research fellow in 2009
That's correct.
at Stellenbosch.
Again, yes.
Then you worked your way up through various universities. You became a senior lecturer at UJ, associate professor at Northwest University, then professor of law, Northwest University. But there is a question I have for you. You are now a professor of law at which university?
At the University of Pretoria.
Oh, your form says University of President, and I thought there's a new
Oh dear.
university of which I'm not aware.
My CV is correct, but my form might be incorrect. I do apologize.
No, these things happen. All right. You're an academic. You've not practiced either as an attorney or advocate.
No, I have not.
But you've done a lot of work in the world of academia. You've edited books. You've contributed book chapters in various books in your area of specialty.
Yes.
Do you think, let me just ask this question at the outset, should it be a disadvantage that you have not practiced?
Chief Justice, I must say, when I started to act, I thought that the procedural part of practice would hinder me. But I think within the 49 weeks that I have acted, I have shown that I could master that. I don't think it is a hindrance for me to be appointed to the bar, to the bench, not having practice. I think actually as an academic one brings a different background to the bench to diversify the bench, and it can be of a benefit to the bench to have people from different backgrounds on the bench, especially if they have shown in 49 weeks that they are able to do the job, which I think from the feedback we have received from all the legal bodies, I have done.
Yeah.
Yes.
And during those weeks at the High Court, you've sat in a wide variety of matters.
Yes, I
and
have. And
wrote judgments.
I did. I wrote 101 judgments. I wrote 91. I sent an amended form yesterday to the JP just to include the 10 judgments where I sat with colleagues. Of course, I'm also the author in a sense of those judgments, so I've just included them to be complete. 101 judgments, 3 of them, I found another one reported yesterday when I've just made sure, and there should be another one on the way to be reported. I don't know where in the process it is. You might know sometimes you mark something as reportable, they send it to the publishers, and the publishers themselves decide whether it is indeed reportable, so I'm waiting still to see if there's another reported judgment. But yes, so I think I've wrote on a wide variety.
Yes.
I've sat in the criminal court as well for a term, so I've covered all the courts.
That is prolific.
Yes, thank you.
And you were able to produce all these judgments within
3 months.
3 months of the
3
hearing of the
months,
matters.
Yes.
Well, I suppose that's the advantage of coming from that disciplined world.
Yes, so
Writing comes naturally to you.
Yes, I had to get used to the style of writing. I see that the one comment, I think it was from the General Bar Council, is that sometimes my judgments are too long, and I take that on board. But I think as I progress through the writing, it will get better or shorter. But it definitely does come easy.
And well, I'll leave it to JP Mlambo to take you through the paces on how long you acted there and the
Yes.
kind of work you did. But I was just a bit concerned about the area of criminal law, which is very important.
Yes.
But you do say that you spent 9 weeks in the criminal court.
Yes, I acted a full term in the criminal court. I finished all my cases that were allocated to me during that term, which I think is sometimes unusual, but I had amazing counsel on both sides there, and we could ensure that we could finalize all the criminal cases in that one term. It was, as I must say, the first acting term was a 90-degree learning experience for me, and also when I went to the criminal court, that was also a great learning experience for me. But I am very great. I told the JP when he said to me, I must stand, I must make myself available. I said to him, I can only make myself available if I have done criminal work, and I was very grateful for him to put me in the criminal court for a term.
Yeah. And what kind of criminal cases did you deal with? Did you do appeals, trial?
Yes. So, of course, if you're in the criminal court and the high court, you do the matters that come before you are serious matters. So I've done all the serious matters. During that time, I did also appeals from the magistrate courts, those automatic appeals, and bail appeal I've also done, and of course then a full court appeal where I sat with 2 senior judges. Yes.
All right. And it went well?
It went very well, yes.
All right. And in the midst of all this, you are raising 4 young children.
Yes, that's correct.
And how do you juggle?
I must say, it's amazing children. I can spend the whole interview talking about them, but I won't. I always think back on that saying, what we say, it takes a whole village to raise a child. So I've got my village. I've got a very supportive partner. I've got people that help me at home with the children. And I think, yes, so I've managed not only acting, but also I think it might be unusual for this commission to have an academic, but just to also explain, while I act, I also have academic obligations that I have to fulfill, like postgraduate students, the chapters that I have to read, must make sure that they finalize their studies. So it is a heavy workload, but I think my village stand by me. And I've listened to your conversation yesterday, was it with Advocate Tikela from KwaZulu-Natal, and I could really identify and with what she was saying.
Yeah.
And we make it work, I think.
Yeah, look, all working mothers,
Yes.
wherever you find them, can identify with this. It's a working mother's life.
And it's an issue that I feel very strongly about, I must say, to make space for carers to also have a career.
Yeah.
Yes.
All right, thank you, Professor
Thank
de
you.
Villiers. I'll hand over to Judge President Mlambo to put questions to you.
Thank you very much, Chief Justice. Good morning, Prof.
Good morning, JP.
Just before I go on to the business of the day, just to deal with that part of you raising young children.
Yes.
You and I have had, I think, the 2 meetings face to face
Yes.
to look at your readiness
Yes.
and candidature.
Yes.
And in one of those meetings, I think it was the first one, when you said, it was over a year ago, when we decided that you're not ready yet, continue acting, and let's see what comes out of the wash. You remember that discussion?
Vaguely, but yes.
No, but the comment you made when I said, but you've got young children,
Yes.
you made a comment to me about the role of your husband.
Yes.
Do you remember what you said, or should I tell the commission? Because that's stuck in my head.
I hope my husband is not watching the interview, but you can review
You
my
said,
words.
you said he was part of the deal, so he must also play mommy duties.
I'm sure I didn't say that, but I do have a very supportive husband.
Well, because he's watching, you'll deny it. Anyway, in terms of your spreadsheet, I think
Yes.
Mine misses a week. You say 49 weeks, and I take your word for it.
Yes, the spreadsheet, I must just bring it to your attention perhaps. The one that I've just received is different
Yeah,
from the one that I've sent you.
yeah.
I know you don't want to believe me that in the third term of 2023, you gave me 3 urgent weeks, but you did give me 3 urgent weeks in that one term. And I do want to point that out.
Because as I say, I take your word for
Yes.
it. Which year and which term?
The third term of 2023.
I see. So that ups your agent court weeks to 6?
4.
To 4.
Yes, so I did 3 in that term, and then I did 1 in the third term.
Okay. So you
Which
did
is
4
passed,
agent weeks.
yes.
Thank you very much for that correction. And that's one of the heavy duty areas.
Yes.
You agree with that? And the norm is you don't get, because there's 2 judges there.
Yes.
We're only starting this term that we're putting 3
yes.
judges because it's quite heavy.
Yes.
But you acted when there were 2 judges, and the norm is you get something like 30 or so
Yes.
opposed agent applications to deal with. Is it?
So I didn't get quite 30. The first urgent court was during the recess.
Yes.
That was with Judge Sinyati. And I was told that was quite a calm, urgent week. I got big cases, but not many cases.
Does recess, yeah.
Yes, and then I did, now I must remember, then I did another urgent in Pretoria with Judge Adams, so he did the urgent in Pretoria.
During term.
And there I got about 22.
Yeah.
And then I did another urgent in Johannesburg with Judge Opperman, and I think she was taking care of me in not giving me a too heavy workload, but she gave me very interesting cases, and I think that was about 15 cases, yes.
But anyway, I think the story is, the bottom line is you were able to handle all those cases.
I was, yes.
And then my spreadsheet suggests you did 2 special motion weeks.
Yes, I did.
And those judgments, how long do they take you to produce?
So the first special motion was the first big motion case that I heard. I think that was one of the judgments that was quite lengthy because it was my first judgment that I really spent time on. That took me less than 3 months. It initially took me 2 months, and then I lost the file, and then I had to type it from the...
But it took you not more than 3 months. And then you've done 4 opposed motion weeks.
Yes.
Yeah.
5.
Is it 5? Okay,
5,
sorry,
yes.
I'm shortchanging you.
You are shortchanging me, JP.
And the full court appeals, my spreadsheet mentions 3. That should be correct.
The civil full court, mine is 2.
The civil appeals is 2. I'm talking about the full court appeals where there's 3 judges.
Yes, 2.
3.
Yes, where there are 3 judges, I did 2. I did 1 in June this year and 1 in July.
Did you scribe any of those judgments?
I scribed in the June one, I scribed 1 with Judge Wilson and Judge Crutchfield.
Yeah.
When I sent the draft, I did not receive substantive comments. It was more about style and grammar and so on.
Yeah.
That was delivered, I think, within 2 months. The July one, I sat with Judge Leepenen and Judge Bally, and again there I only received typographical type of
That's
comments.
fine. So coming to your judgments,
Yes.
you mentioned 101 that you've set in, but those that you've scribed,
Yes.
your own judgments,
91.
91, over a 49-week
Yes.
acting stint. And I see you're one of those candidates, you don't list judgments. You do now and then list leave to appeal judgments.
Yes, so
No, you don't have to explain anything. I'm just pointing it out to you. But looking at this list, do you confirm that none of these judgments took you longer than 3 months?
I do confirm, yes.
Right. And then the CJ touched on you doing criminal work. She asked you what type of work you did. I think you missed it because she wanted to know whether you did trials.
Oh, yes.
You did trials.
I did trials. I did, I think, 4 trials.
And you finalized all of them.
I finalized all of them before the term ended.
Let me just say this. It's quite a feat to sit in criminal trial role in Gauteng and finish the term without apartheid. Because that's why we have a backlog there.
Yes.
There are all sorts of things at play in that role.
I think I was lucky in that I, in most instances, only had 1 accused. I think the problem often comes in if you have more accused with more
Yes.
legal representatives. Yes.
So the reason you were put in criminal trial role, which a lot of people don't want to or are scared of, was to give me confidence that you can stay in my acting judge pool for the future, remember?
Yes.
And for you to be exposed to that work area.
Yes.
Thank you.
Thank
And in addition to the trials, you also sat in appeal, criminal appeals.
Yes, I
Okay.
think, yes, I can show you where on the page.
No, you don't have
Okay,
to.
all right.
We don't have to. I mean, if commissioners want to confirm that with you, they will ask you.
Thank you.
So I was saying to the other candidate that I have my own scoring matrix. Out of 5, how much would you score yourself regarding reserve judgment, delivering reserve judgment? And let me tell you, if you didn't take longer than 3 months, I give you the total. If you delivered after 3 months, but not beyond 6 months, I give you 4.
Yes.
And then if the scoring reduces, the longer it takes for you to hand down judgments.
So if that's the scoring matrix, I would give myself a 5.
I see.
Yes.
And then in terms of exposure to complex work,
Yes.
it's also out of, that one is out of 7.
Out of 7.
How much would you score yourself? That is urgent court,
Yes.
motions, opposed motions, special motions, those 3 in particular.
I just want to say I'm somebody that's very hard on myself. So these questions, I don't know if I will answer them truthfully to myself.
No, well,
Yes.
that doesn't bind anyone. I just want,
And
because you
I
tells
think-
us how
yes,
confident you
I
are.
think they were quite complex matters, not necessarily in terms of the law, but in terms of, for instance, I handed down a judgment about a month ago of a matter that it was an application, there was a counter application, and then there was an intervening party.
Yes.
And those things become complex, not necessarily because of the law, but because you have to concentrate to see what fits in where and what is the relief sought and what is
Yes.
the relief that you can grant. So I've done a few of them. I've done not a tax, I don't know if customs fall under tax, but I've done a customs, that was the one special motion that I had. I've done many insolvency type cases, which can become complex at stages. Yes, and Paja is always...
No, look, I don't want you to
Yes.
try and justify
Oh,
anything.
I must give you a score,
I'm,
sorry.
I'm giving
yeah.
it 7 because it's a heavily weighted area.
Yes.
Because that's the area where judges get reserved judgments,
Yes.
and their performance in this complex area
Yes.
tells me that they deserve a higher scoring or a lower scoring, depending on how they perform. So I'm asking you, out of 7, how much would you score yourself?
6.
6.
Yes.
Okay. Thank you very much. CJ, thank you very much.
Thank you.
Thank you, JP. Premier?
Thanks so much, CJ. I don't have questions that I need to pose to the candidate. Thank you.
Thank you.
Thank you, Premier. Judge President Tlaletse?
Oh, thank you.
Thank you, Professor.
Thank you.
I have looked at your rich experience in the academic field,
Yes.
and it's quite impressive.
Thank you.
And just want to get it from you, to understand from you, given that you have gone through acting stints in the High Court, would you say they were quite beneficial for the person in your position to go through these ranks to gain the relevant practical experience and have the feel of adjudicating cases in the actual courts. And rather than seeing yourself as, given my experience, I'd rather go to the Constitutional Court as an example. And if you've got anything to say about that, I would ask for your comment, please.
Okay, can I just understand the question? So as an academic, having acted in Johannesburg, whether I think I have gained the necessary experience to continue in the High Court?
No, that is it advisable for at least someone to go through the ranks of the High
okay,
Court so
yes,
that when
I
you do the
understand that.
adjudicative
Yes,
work,
okay.
you've got the actual feel
Yes.
of what happens in the
Okay,
court.
now I understand the question. Thank you. So I think I was thinking about this question a lot after the previous round of interviews in April, and we have the 17th constitutional amendment that broadened the jurisdiction of the Constitutional Court to not only be restricted to constitutional matters. So the matters that serve before the Constitutional Court at the moment are really vast. They're not just focusing on, and I have also listened to Commissioner Nkaitoge's questions earlier this week about whether all matters are not constitutional matters, so I'm going to pause that just there. But the point is, it's difficult to be an academic that knows everything that will enable them to go directly to the Constitutional Court, I think. And that is because when you are in academia, you have a very specialized field of law, and you're not exposed to all areas of law. And I think that 17th constitutional amendment of the Constitution made it difficult to find an academic that can go directly from academia into the Constitutional Court without having any court experience whatsoever. I don't think it's impossible, but I think it is very difficult.
Yes.
Because the matters that I am faced with at the High Court are things that I don't do on an everyday basis in academia. I love it because it's new and it's challenging and I love the law. But I think it would be quite daunting to sit in the Constitutional Court coming out of academia and now having to be faced with matters that I'm not familiar with. But as I said, I don't think it's impossible. I just think it would be very, very difficult.
Yes. If you may comment, would you say it may also apply to practitioners like senior advocates and the others that at least to go through there and have a feel rather than go directly, given the kind of work that you're exposed to and that they may not be exposed to in their practices?
Yes, I think it will depend on the practice of the practitioners. Some practitioners have a broad practice and they practice in everything, and it's again a little bit different than coming from academia where you try and specialize in the field. But I think it will depend on the person. Again, it's not completely impossible, but I think it's difficult. Yes.
Thank you, Prof. Thank you, Chief Justice.
Thank you, JP. Commissioner Pillay.
Thank you, Chief Justice. Good morning, Prof. Duplessis.
Good morning, Advocate Pillay.
May I begin by commending you on your judgments? They were a real pleasure to read. They're well-structured, well-reasoned. There is one judgment I do want to raise with you, though.
Yes.
And I'm not sure how to refer to it. It's the ICMGDG matter.
Yes.
The one involving the relocation of 3 children to Belgium.
Yes.
Now, you did something quite unique in that judgment.
Yes.
At the end of it, you included an addendum.
Yes.
Addressed to the 3 children.
Yes.
Now, when I read the addendum as a mother,
yes,
I found it so beautiful.
Yeah. Thank you.
Because I could see what your intention was.
Yes.
But when I reflected on it as a practitioner,
yes,
a few concerns started developing, you know,
Yes.
and I wanted to raise those with you. Firstly, I was debating with myself whether when you include an addendum to a judgment, what the status of the addendum is. Does it form part of your reasons? And if so, is that where litigants would look for some of the reasons for your judgment? And would that inform then an application for leave to appeal? Just want to get your sense on that.
Yes, thank you. So you will see on my CV, I'm just going to say how I got to do that. I know it's unusual in the South African law context, but on my CV, I wrote a book review on the art and craft of judgment writing by Max Barrett. He's an Irish judge. And I was asked to write the review for the Journal of the South African chapter of International Association of Women Judges. And in that book, he has a whole chapter about this issue of addendums. And that is something that he does quite often, and that happens also in the English courts. For instance, in issues of immigration, where people might not be well versed with English, those type of matters. And the reasoning for attaching the addendum is to explain to the people affected by the judgment why you came to the reasons that you came to, in a way that makes the law accessible. And I think I did it from that perspective. I feel very strongly that law must be accessible to everyone, and also to those 3 children who had to move because of my order. I thought this is a chapter in their lives, and they need to understand how the judge came to that judgment. So what I did is I first wrote the judgment in the normal legal form, and then I just wrote that addendum based on the judgment. So what's in the addendum should also be in the judgment. So I think that then addresses your question, whether those are reasons. If they are reasons, to the extent that they are reasons, it's the same reasons that were given in the judgment.
And if you find in the addendum that you go beyond what is in the judgment, what happens there?
So my understanding again, and now I go back on what was written in the, I also read academic articles on this issue before I wrote that addendum, I should add, that the addendum does not form part of the judgment. So the status of that is just explanatory. Sometimes people write letters, and obviously that does not form part of the reasons or yes, I think.
And just lastly, in those jurisdictions, was there a particular legal framework which permitted the addenda to judgments?
No,
And I just want to check whether we needed a similar kind of system here. And that would, because if I was a litigant at the receiving end of a judgment and an addendum, and if I wanted to punch holes in the judgment, I would certainly argue that the addendum is part of the judgment and use that as a basis to attack the judgment as well.
Yes, I understand your question. I must say I haven't thoroughly thought about that. I understand from what I've read, as I said, in that book on judgment writing and how to make law accessible to people, that it's merely an explanatory of the judgment to the people who are affected by the judgment. So there's no specific legal framework. I think it's about the personality of the judge and what they seek to achieve with their judgments.
Thank you, Prof. Thank you, CJ.
Just to follow up on Commissioner Pilay's last question, and I ask you this question mindful of the dangers of arguing by way of analogy. Is a document of the nature of this revolutionary addendum any different from a media summary that would be issued by the court to explain the contents of the judgment, as long as it does not stray beyond what is actually contained in the judgment?
Thank you. I think that's a good analogy, except the media summary is written for the media, while this addendum is specifically written for the people who are affected by the outcome of the judgment. But I think as long as you don't stray from what is written in the judgment, it serves as a very good analogy. Thank you.
Well, the media summary is not just for the media, it's meant for the public's consumption ultimately.
Yes, but I mean, to the extent that the audience for that is different.
Yes. No, I take your point. Commissioner Nyukaitop, is there a follow-up question?
No, it's a different question, so I'll be happy to wait my turn.
Then you must wait your turn. Commissioner Moiman? Is there a follow-up question, Commissioner Trolley? Okay. Go ahead, Commissioner Moiman.
Thank you, Chief Justice. Good morning to yourself and fellow commissioners. Good morning, Prof.
Good morning.
Just one question from myself. emanating from your article, Rethinking Public Expropriation.
Yes.
The question that I want to pose is, what is the role of expropriation in a typical post-apartheid transformative South Africa? And the current legislation, section 25(1) and 2, and the Expropriation Act 63 of 1976, is it adequate enough to drive that agenda? Thank you, Justice. Thank you, Prof.
Thank you. Can I just get the last sentence? Is it adequate enough to?
Whether is it adequate enough to empower the expropriating authority to expropriate constitutionally?
Yes, thank you. That is, I just have to warn you, that was the topic of my doctorate, and I can speak also the whole day about that, but I won't, so I'm going to answer you hopefully shortly. I think people, no, I'm not going to go that way. So the role of expropriation in the transformation, no, I have to go that way. I think sometimes when people speak about expropriation, there's no clarity where in the land reform process it fits in. And I'm not saying it's true for you, but that's the feeling that I get when one speaks about expropriation. So expropriation is a method to acquire the land, and once the land is acquired, then it is distributed or returned, or whatever the case might be. So in as far as it plays a role in that process, it plays the role in how the land will be acquired, and if that land is acquired, what type of compensation would be paid. And I think that then gets us to Section 25(1) and then the Expropriation Act of 1975. And I understand also there's an expropriation bill in the pipeline. I think the Expropriation Act gives the authorities the power to expropriate, and the conclusion of my doctorate was basically we do need an act that is updated because of the reasons when that expropriation bill, the Expropriation Act, that's the 75 Act, was enacted. Market value compensation was the, now the word, the be all and end all, the word will come, standard of compensation. And of course, now in terms of the Constitution, Section 25(3), the compensation standard is just an equitable compensation. So there's a disjunction there. And then also the issue of public purpose. Public purpose is in the Expropriation Act of 75, and the Constitution speaks of public purpose and public interest, where public interest includes the nation's commitment to land reform. Do I think the 75 Act necessarily stands in the way? No, I don't. But you will need to interpret it in terms of Section 39(2) of the Constitution, in light of the Constitution. So you will have to give it a specific interpretation. And I'm not always sure if that is ideal. So that's why I think the expropriation bill that came from 2013, 2015, 2018, and currently I'm not sure about the status of the bill, I haven't checked yesterday, but that bill tries and encompassing all these things, including Section 33 of the Constitution, which is also very important in expropriation and making sure that it is a just administrative action, that administrative justice is adhered to during the expropriation process. Yes.
Thank you, Prof. I was not only just referring to land, I was referring to constitutional property, which includes right to minerals, limited real rights, and unjustified enrichment. So I just needed to allay your fears.
I'm not scared to talk about this. Thank you.
Thank you, CJ.
Commissioner Gauteng?
Chief Justice, can I just follow up on this, and I'll let go of my...
Yes, Commissioner Mungeni?
Yes. Good morning, Prof.
Good morning.
Thanks for the beautiful answer in relation to Section 25(3). And I see you have also written an article on the conflation between value and compensation.
Yes.
Applying the principle of equity, is it possible to expropriate and compensate at a zero, at a nil?
Yes. So I think what I've always said is that Section 25(3) of the Constitution says compensation must be just and equitable, taking into account the circumstances of the case. And so it will depend on the circumstances of the case. If it is a case where if you take into account all the interests involved and you do the weighing up process that is required in terms of Section 25, it might be possible that during that weighing up process, the compensation amount might fall on R0 or no, but that will depend on specific facts. So it's difficult to say definitely yes or no, but there's a weighing up process that needs to take place, and in that weighing up process, it might be, and I think the expropriation bill in clause 12 also clarify that by saying there might be instances where no compensation may be paid. So it's all about that weighing up process.
Thank you, Prof. Thank you, Chief Justice.
Commissioner Gotsa.
Thank you, Chief Justice, and good morning,
Good morning.
Professor. With reference to news reports recently that in one of Gauteng's courts, if you have a civil claim, you will only be heard in 2028.
Yes.
It was also reported...
29, actually.
Well, 29. It was recently reported that legal professionals are at their wits' end over the longest backlog in history, and I quote there. What, in your view, is a judge's role in ensuring the expedience in the administration of justice?
Yes, thank you, Commissioner Gotsa. I think, and I'm sure you know how the allocation work in the High Court. You get your role in the beginning of the term, and if you are in the Civil Trials Court, you get allocated civil trials. So I think your first obligation is to make sure that if you are allocated cases, that you see them through if possible. There are fewer delays in the civil trial court than there is in the criminal trial court, but I think for one, when a case is allocated to me and it is possible to keep the case and to see to its end, I do that because I don't see the sense in the parties re-enrolling that matter. So that might be one. Of course, case management comes in as important as well, but often also as judges, when you have a role, say you have a special motion role, and your special motion becomes settled and your week is cleared because you don't have any hearings. What judges then do is they go to the DJP in wherever they sit and to say, I'm available to hear civil cases, and then they get allocated civil matters. And that is something that I've done before, that when my role finished before the end of the week and I didn't have pressing outstanding judgments, but even if I had outstanding judgments, I would still go to the DJP and say, I am open to be allocated with matters. So I think that is the extent of what judges can do. Other than I know Advocate Ali spoke about the appointment of pro bono judges and so on, but that's, I think, a different matter than what I can do if I am a judge in that circumstance.
Thank you.
Thank you.
Commissioner Nqaito.
Thank you, Chief Justice. Good morning, Professor du Plessis.
Good morning, Commissioner.
Like Commissioner Pillay, I must commend you on the lucidity of your judgments.
Thank you.
It's been a pleasure to read some of them.
Thank you.
One of them is a very promising one about challenging property.
Yes.
You remember the judgment?
Yes.
In the context, I think, of
family homes.
Of a family house,
yes.
Juxtaposing customary law and common law property.
Yes.
But let's take the debate forward
yes.
outside of custom.
Yes.
The problem, of course, is the right to property itself.
Yes.
And the debate was always, well, does the Constitution, in fact, embed the right to property? in the negative expression in section 25(1? Or is the Constitution really intended to rethink the notion itself of property? Now, three of the passages in your judgment point to the problem of private property and the constitutional setting, that property by definition is exclusionary, whereas the Constitution has a more substantive understanding of this idea of the relationship, let's put this, the relationship to property.
Yes.
I want to just get a sense, because I have no doubt of your commitment to the values of the Constitution. You live them, you write about them, you are now about to apply them as a judge. Whether or not you doubt if the Constitution embraces an unbridled form of property, and whether what we can expect from you is actually a challenge to the notion itself.
Thank you very much. I think that's a difficult question, so let me just readjust myself. I think for the first question, whether the Constitution protects the notion of private property, I'm paraphrasing you now and
Yes.
not very eloquently so. I think if you look at the history of the making of Section 25, you will be well aware that Section 28 of the Constitution mimicked the German Constitution, in that Section 28(1) stated clearly property is guaranteed.
That's the interim constitution.
Yes, that's the interim constitution. And I think it's quite telling that that Section 28(1) did not make it to the final constitution after the deliberations in the Constitutional Assembly. And from what I understand, I've read last year, I've read all the notes on the deliberation of Section 25 in that Constitutional Assembly. That was done on purpose. And if you also read, there's a book by Justice Albie Sachs, Oliver Tambo's Dream, I think. In there, he spoke about that issue where he said that was deliberately left open not to solidify private property in the Constitution, because that was seen to be a political contestation in a sense. So that's the answer there. But I do understand when people criticize the Constitution by saying, well, Section 25(1) says that the state cannot interfere in, nobody may be deprived of property unless, arbitrarily deprived of property unless in terms of a law of general application. And in that sense, it might be interpreted that it does solidify private property. So I think that answers that question. But I think what is more important is if we think about property in terms of the Constitution, and that's certainly something that I have written about academically. I've recently also written in an eviction case about that. That idea that property can only mean ownership, and that ownership can only mean ownership to the exclusion of everyone else. That is what we are challenged to interrogate under the Constitution. I know Professor Andre van der Walt wrote this article where he said that notion that we have this hierarchy of rights with ownership at the top and all the other rights at the bottom, it was used by the apartheid government to protect white ownership of land. And what we now need to do is we need to open up that, so that in some instances, right in property that might not be ownership can challenge those notions of ownership. And we already see that in eviction law, for instance. There are some instances where the owner of the land cannot evict somebody who has the right to not be evicted if it's equitable to do so. And that brings in a challenge in the property law sphere. And I think those are the type of instances that one can explore on various fronts. And I think that's what I'm trying to do in some of these judgments. And that's certainly what I did in that family home judgment, where I said there are certain rights in a house. If you have a right in the family house, it should be that in some instances that right should be able to trump the person who is the title deed holder for various reasons. And of course, there's a very fine line that the judge must walk in that regard, because it might be more of a policy or political issue. But I think one can challenge those notions if the facts of the case before you allow for that. And I think, yeah, I'm quite excited about that, as you can see.
Yes, no,
Yes.
thank you. No,
Thank
it excited me too because we've lived for 30 years in a straitjacket of the common law of property. And with judges reinforcing
Yes.
the straitjacket. With your judgment, there were other judgments we were debating earlier from Judge Cowen that are beginning to actually open up the space so that the Constitution means something.
Thank
So it's an exciting start. So, but my understanding of your answer is that you will continue to entrench that
I'm glad
vein
it's
of
visible.
thinking.
I'm glad that effort is visible. Thank you.
Yes. Now, the second thing, you know, it's around expropriation.
Yes.
You know, the people talk of market value in an expropriation. Now, I've argued that it is a total fiction.
Yes.
Because there is no market in an expropriation. There's a state is trying to acquire land for redistribution. Market value itself is also a fiction because it presupposes a willing seller with a willing buyer, and both of them are ignorant as to the real price. But we know that doesn't actually exist. But do you also agree, or do you have a different view about the utility, maybe futility really, of applying market value in expropriations? That was a fundamental mistake committed by the early constitutional court in thinking that market value could be a starting point when it specifically deals with land reform, and whether you think actually land reform should be thought differently than any other forms of property because it's about addressing the original sin, and whether there are constitutional ways that you've thought about that we can actually start to challenge. It's also another straitjacket that has constrained proper land reform.
Yes, again, that was exactly what my doctorate was about. I'm not going to repeat that. And I think the position I held then was, I was also saddened, it was a Du Toit judgment, which was incidentally not a land reform judgment, that said we start with market value. And again, that then places market value at the center of the inquiry. But I have since developed a more nuanced approach because I do understand that when you do come to court and you want to argue about compensation, in the end, the court must give
a number.
Give a number.
Yes.
And
But I mean, Judge Cowen says that's not the case. You don't always have to give a number. And even if you do have to give a number, you can start with current use of the property and try to give a number to that.
Yes, I think where I want to get at is you will see there was a later article on the disjunction between value and compensation.
Yes.
Because it becomes more complicated when you start to ask the question, who's got the authority to make that determination? And you will know from the Malmuth judgment where the OVG said that the Land Claims Commission in that case is bound by her determination. And the Land Claims Commissioner wanted to have some leeway to be able to negotiate. Then that issue of value and compensation comes in. So what I want to say is I've moved a little bit to a more nuanced approach where I said, okay, I understand why you have to give a certain value. It does not have to be market value. We have to have a certain value to work from. And so in my writings, I say that should be the job of the valuers and the OVG. But in doing that job, they must say these are all the factors that we could see on the ground that might influence the decision maker in coming to a compensation amount, because a compensation amount must be just and equitable. And justice and equity, and there I then totally agree with Judge Cohen, and I think you've made similar points, that it's justice and equity that informs compensation. But if you can keep these two things separate to an extent without placing value in the center, but understanding that value needs to form part of all those factors that you take into account by coming to a compensation amount, and that compensation must be just and equitable, so it's justice and equity that inform that amount, then I think we are moving.
So that's also part of the philosophy you're bringing into the system.
Yes, I hope
Well,
so.
both of those answers are excellent and music to my ears. I hope, long may they continue to percolate.
Thank
Are you going to act in the land claims court if invited?
Advocate
Oh, sorry,
Noba, I
Chief
thought
Justice. Yeah.
it is a critical and gripping subject. We acknowledge that, but let's wrap it up. There are 7 other candidates still to be
Yes,
interviewed.
no, it was
And
just to ask.
I would ask our expert to please keep your answers as concise as
I'll
possible.
try. Don't ask me expropriation questions. I've got much to say.
No, it's just to ask her whether, if appointed, she would make herself available to the land claims court.
You may ask that question.
All right. Well, you've heard the question, Professor.
Yes, I'm willing to make myself available to the land claims court. I'm already with my academic hat on, helping with that historical cases project. So I'll be more than willing to continue with that. Thank you.
Okay. Commissioner Trollip?
Thank you, Chief Justice. Professor Duplessis, I'm largely covered by your responses to Advocate Mukaitobi.
Thank you.
When the Chief Justice asked you about your studies, you said something about, you wanted to finish in a hurry because you didn't think they'd be relevant for much longer. Could you just expand briefly on that? And then while you're doing that, could you explain, I understand that the market value concept is outdated. It was relevant to a 1975 Act and all of your responses thereto. Can you explain the difference between market value and current use value and attaching a numerical number to current land use?
Okay. The question about outdated was the market value. Can I just answer just the market value question now and the current use?
You've already answered the market value one,
yes,
as far as I'm concerned.
Yes, okay.
The new parlance is current use.
Yes.
Can you just explain the difference between the two?
I hope I'm going to remember the nuances, because you've got the expropriation, the Property Valuation Act, and in terms of the Property Valuation Act, there were regulations published that looks at the current use value. And that was the subject in the Moloto judgment that was also spoken about earlier this week with Judge Cohen. And I agree with Judge Cohen in what she wrote there in that judgment. But the problem in that judgment links with the regulations in that it's very technical, so I hope I remember how that current use value is explained in the regulations. But the way that the current use value is set out in the regulations, I'm just going to leave it at that, is problematic. And I think the nuances of all that came out in the Moloto judgment, and I fully agree with Judge Cohen's judgment there. So I think that would be my short answer in the interest of time.
Chief Justice, just to follow up, and your short answer about hurrying up your studies because they wouldn't be relevant for much longer.
Oh, that was. So in 2008, there was an expropriation bill, and I finished my doctorate at the end of 2008, and I was afraid that that bill will be passed before my doctorate is finished, but that bill was then shelved eventually, and then there was 2013, and then for a long time I did not do any research on expropriation because it seemed to be dormant. And then, of course, as we all know, in 2018 that changed. So it's just the nature of academia. You try and contribute with your research. Yes.
Thank you, Chief Justice.
Thank you.
Commissioner Marumagai? Professor? Commissioner Breitenbach? It's not frozen or anything like that, is it? Okay. I'll take that to mean they no longer have need to ask you questions, Professor de Villiers. Was there another hand? What did I call her? Oh my goodness.
Well, maybe. Well, let me not say what I wanted to say. Commissioner Mangia?
A short one. Professor, I see you wrote an article on the meaning of a home in the context of Section 26(3) of the Constitution.
Yes.
And you also wrote a commentary on a SCA judgment of Ngomane versus City of Joburg.
Yes.
The unanimous judgment that was penned by the CJ. And you were critical of the meaning of the word home as defined in the approach that was taken by the SCA. And you would know that subsequently and recently, the SCA, in the case of students, I'm trying to recall, stay at South Point Property versus Mkulwana, a judgment of Judge Antahalter. The CA said that the residents where students stay for the duration of the academic year, it's not a home. And given the fact that you were free to comment as an academic, now that you are going to be a judge, how would you navigate academic freedom with the principle of precedence, stare decisis or stare decisis, whatever they call it?
Thank you. That's a wonderful question. I've asked myself that many times during my acting stints, because now already I was wearing two hats and I had to be careful. I just want to clarify that chapter that I wrote on the meaning of home was in 2015, and it's only later that the Ngomane judgment came out. So I just said that the work that I did in my academia was relevant for us to understand the Constitution, for example, and then I gave that example. So I was not referring to that judgment in my academic work. But I take the point that you say, and it is, of course, a little bit of a mind shift that I have to make when I am an academic. I can engage with judgments critically, and I can express my opinion respectfully. So I hope I've always done that respectfully, to show where there's room for development. But I accept that when I am a judge in the High Court of Johannesburg, that I'm bound by the president, by the judgments of the courts above me. So I did judicial training as well, and that question came up in a exercise that we had to do, and I didn't agree with the reasoning in a constitutional court. I agreed with the outcome, but not with the reasoning. And in that training session, I asked the constitutional court judges, what should I as a high court judge do in instances like that, where I don't fully agree with the reasoning in the constitutional court, and I understand from the answer I'm bound by it. Some constitutional court judges said you can mention it, but you remain bound by it. So I know that there's a nuance, and I know that I will have to, in some instances, make that mind shift, but I think I do so fully aware of what is expected from me. Thank you.
Thank you, Chief Justice.
Thank you, Commissioner Mangen. Professor du Plessis, there are no more questions for you.
Thank you.
Unless there's anything you wish to raise with us, you may be excused.
Nothing to raise. Thank you very much for the opportunity. Thank you, commissioners.
I think the questions about the backlog 2029 and whatever can be answered by candidates or by myself as a head of court. But I refrain from raising it with this candidate because the short answer is, Commissioner Gottsel, is judges in the civil trial role are no longer not more than 10 per day. And the allocation there is 50 matters in Pretoria and 20 in Joburg. Naturally,
Good morning, Advocate Lapuskarne.
Good morning, CJ.
How are you?
I'm very well, thank you. And yourself?
I'm fine, thank you. You hold 4 degrees, all which you obtained cum laude.
I must confess the last one was the upper second. That wasn't cum laude, that was in Cambridge. But the
Now I
others were
feel
cum laude.
better. Okay. Or a BCL, a BA honors, an LLB, and the LLM, for which you did not get the honors. Okay. You did articles successfully, but then chose not to join the sidebar.
That's correct.
You started practicing as an advocate in 1988 already,
That's correct.
and you've been at the bar since.
That's correct. So for the year that I went to Cambridge.
Yes. Is that the Johannesburg bar?
No, Pretoria.
Sorry, Pretoria, yes. Okay. You explain in your application form that your practice or your junior practice included matrimonial law, criminal law, labor law, personal injury law, and the spectrum of commercial law, including, and I'll just mention the ones that interest me, banking, insurance, and construction law, and intellectual property law.
That's correct.
And you've done pretty much everything, I take it. And you've also sat in arbitrations.
I appeared in arbitrations and I've sat as the arbitrator as well.
When did you take silk?
2006.
Okay. You mentioned that you also sat as a member of the Labour Appeal Court prior the Labour Relations Act.
That's right, yes.
Was that frequent?
A few times, yes. I was doing quite a lot of labor at that time.
Okay. Well, you are credited for leading the transformation initiative of bringing in Black junior counsel into your chambers, and not ending it there, but mentoring many Black junior advocates in Pretoria. Is that so?
That is correct.
Mm-hmm. And you have participated in the pupil training committee as well?
That's correct.
Okay. You also lectured at the University of Pretoria.
Yes, that was...
That was before, was that before you served articles?
Yes, it was while I was doing my LLB. I was doing a BA Honours in Latin at the same time, and I was a junior lecturer in Latin at that time, when Latin was still a compulsory subject for LLB as well.
Yep. So you've practiced for 36 years?
Yes.
And for how long did you act as a judge? Have you acted as a judge?
Yes, it's 19 weeks.
19 weeks, which is
Yes.
not a long time.
It's almost 5 months, yes.
Yeah. But what kind of work did you do during that? Was it one acting stint or a collection?
No, it was spread over a number of stints. And there is a breakdown which the JP has provided of what I've done. The only aspects which I haven't been involved in as a judge is as in respect of the tax court and also the criminal trials themselves. I've done a few stints in the appeals of criminal matters.
But no criminal trial as yet.
No trial. Yes, as junior counsel, I have appeared in criminal matters representing defendants, but I haven't presided.
Okay. And you claim to have written about 50 judgments during those stints.
That's correct, yes.
Okay. Any of those reported?
Not that I'm aware of. I find most of them on Safely. I haven't checked whether they've been. They're in the law reports that I couldn't do.
And you don't have any reserved judgments?
None.
Okay. All right. I'm going to hand over to Judge President Mlambo to take you through the paces about the rest.
Thank you, CJ.
Thank you very much, Chief Justice. Good morning, Advocate Labuskachne.
Good morning. Good morning, JP.
Then let's just place on record that you are also here because of discussions between yourself and myself in the last 2 years.
That is correct.
When you raised your hand then that you'd like to become permanent, and then I said to you, I will give you the nod when I think the time is right for you to come and face this body.
That is correct.
Right. My spreadsheet that I've given to the commission misses 5 weeks. You say you've done 19 weeks, and I apologize for that.
Yes. 2006, in the year in which I took Silk, I did 2 weeks, and then again in 2008. There's another 2 weeks.
Those are the two. That's 2. That takes it to 18.
There's a week missing which I can't find.
Okay. Well, 2006, 2008, I was a puny judge, so I don't know what happened then. But anyway, sorry about it.
Yes.
The moral of why I'm asking this is, in my spreadsheet, you've done 3 agent court weeks.
That's correct.
That was in Pretoria.
Yes.
Was it during term or during recess?
They were during term.
So you would have faced the full load of the agent allocation.
Yes, I was there at the time when there were only 2 judges.
Yeah. And then, well, the commission knows the average allocation load in the agent court. And then you've done 2 special motions.
Special motions, yes, I've done 2. That's right.
Yeah. If you think you've done more, you must tell me, because
yes. Well, those were where I was on the roll, the duty roll for that week. I might just mention, JP, that as far as criminal appeals are concerned, the spreadsheet misses 1 term in 2021 and another one in 2023. I did 2 stints criminal appeals.
Thank you very much. And then in terms of opposed motions, I've got 3 weeks here.
That's correct, yes.
Yeah. Now, what you said to me when we spoke about your availability, I said, my preference in giving the nod to candidates to avail themselves for judicial appointment is that in the sunset period of your acting, I would like you to do a full term.
Yes.
You remember, and you told me that it would be difficult for you to give me a full term because of your practice.
Yes, I have a very busy practice, and the overheads are such that to be away for 3 months casts a shadow of another 3 months. It's effectively being out of private practice for 6 months. It's just too expensive.
Yeah, but I think what you said, which I think is justified, you said what compensates for not doing a full term is that your practice is predominantly, if not entirely, high court practice.
That's correct, yes.
Right. Thank you very much. And in terms of the judgments you've written, the spreadsheet I have, or the document I have, does not indicate the periods, But I think in one of the answers you gave to the CJ is that you give judgments timelessly. But have you given, or let me ask you this, have I ever confronted you about reserve judgment?
No, JP, my judgments are done by the time my acting stint is over.
I see. So all of them within 3 months?
Yes.
You've never had occasion to go beyond 3 months?
Well, a few days perhaps afterwards, if applications for leave to appeal would come in, that I would hear later, yes. But I've made a point of being prompt.
The judgments themselves?
The judgments are finalized.
Within 3 months. I know there's one leave to appeal that you did when you were somewhere in the US. Was it the
No,
US or what?
that was correct, yes. It's the first matter I was referring to. It's the United States Polo Association. It was a fight between trademark competitors, and the one was contending that the other's goods in the harbor are counterfeit.
Yeah.
And 3 judgments flowed from that. One on the merits, a leave to appeal, and also a Section 18(3) application. That's the one on which I was overturned in an automatic appeal.
Yeah, and that's the beauty of virtual hearings and case lines.
That's correct, yes.
Thank you. Well, yesterday, Durban Council was singing the praises of case lines. I wonder why Gauteng Council are so muted about the system, because it kept their bank balances okay during COVID, you know.
Yes, case lines is a lifesaver. I would advocate its rollout countrywide.
Yeah. So it may sound repetitive and annoying to some commissioners, but I have a scoring matrix.
Yes.
In terms of how I score candidates. One of them is how the interview itself goes, but in terms of your exposure to complex work, like the special motions, the opposed motions, as well as the urgent court.
Yes.
Right? As well as how you handle the work and turn around in terms of judgments.
Yes.
I've weighted that one heavily. It's got a scoring of 7.
Yes.
How much would you score yourself?
JP, it's a subjective thing. I think I did well.
You think, okay, that's fine.
I would certainly not go less than what you've suggested. I might suggest more. But that's me, my objective opinion. Oh, I'm just joking.
Okay.
No.
Thank you very much.
No.
Thank you, CJ. No further questions.
Thanks, JP. Premier?
Thanks so much, Chief Justice. Good morning, Advocate.
Good morning,
Lavas
Premier.
Kachni. You responded in the positive when Chief Justice said you are a champion of transformation in some of the legal work that you've done. I need to get outside that if we have ever promoted any form of transformation and where outside your workspace.
Outside of the?
Workspace.
Look, I've been involved in as a pro bono advisor to indigent people in the city centre for more than 10 years on a regular basis. That was aimed at assisting people who can't afford legal help, who are destitute and desperate. So I was involved in that for many years. Was also involved in training. I helped the asset forfeiture unit to get their advocates ready for court appearances and to teach them courtcraft in advancing their own applications. And as far as training is concerned, it's something that I enjoy. And whenever I've worked with juniors and young advocates, not even where they are my juniors, even where they just ask advice, I'm known to have an open door policy, and there's a steady stream of youngsters who tap into my experience and my willingness to assist. And many, if not most of them, are black.
No, thank you. In the questionnaire for candidates, you proudly stipulate that the DA was your client to secure the release of the former public protector's report. But you further indicate that you represented a formation that you don't declare in the diplomatic immunity case against Ms. Grace Mugabe. Why you are proud to declare the representation of your client in the form of the DA, but on the Grace Mugabe case, you are not declaring who's your client?
Yes. Could I just correct, when I state that I acted for the DA, it's because they instructed me. I'm not doing so as a matter of any pride. I was sitting right next to Advocate Nguka Tobe, who was representing the EFF in the same application. I think we had the same vantage point, and we were arguing the same issues. That was an interesting case where, for once, there was a unity amongst political parties who seemed to be at loggerheads on everything else. So that was an occasion when there was an alignment as far as legal approach was concerned. I happened to have been instructed by the DA. As far as the matter of Grace Mugabe was concerned, the case is cited as the DA. There were actually two applications. I was in a separate application representing the complainant, Ms. Engels, and also AfriForum, who brought a similar application. They were heard at the same time. But you will not see it in the citation. It's only for that reason that I didn't think it's necessary to.
So your client was AfriForum?
AfriForum and Ms. Engels, who was the complainant in the criminal case.
So why didn't you state it that your client is AfriForum, but when you're representing a DA, you proudly stated that you're representing the DA?
Yes, no, there's nothing sinister about that, Premier, and I've already addressed the issue whether I cite it proudly or not.
Thank you.
Commissioner Hassan?
Thank you very much, CJ. Over here, Advocate. I have two questions. I'll start with the first, relating to the UDM versus ESCOM case. And let me caveat and begin by saying, I think there's general agreement from all sides of the table that load shedding is prejudicial to the country, of course, to specific sectors of public institutions, etc. I think we're all in agreement with that. That's not where my question is situated in. I think my concern, and maybe I should also say this, CJ, that I am also on the portfolio committee for electricity and energy. Yes. So very much involved with the NERSA issues and upcoming electricity tariffs, and perhaps maybe let me say very passionate about how we bring about equitable access to electricity. CJ, my question relates to the separation of powers and to, I think, very difficult legal jurisprudence that has been developing over the last few years. And while we can agree there was a need for intervention on this particular matter, I am a little bit concerned by judgments that are handed down that are frankly impossible for the state to implement. And let me explain or expatiate a little bit. We agree that police stations, schools, hospitals, etc., should not be load shed. I don't think there's anyone who disagrees with that. Yes. But the way the grid is designed, we can't just not load shed one particular corner of a street, right? The way the grid is designed is not that. Yes. And for us to literally redesign the grid would cost us trillions of rands that we do not have in the fiscus. And yes, there's an argument to be made that we're now developing transmission, etc. But I do think that and I've read the case before coming here today. So I'm trying to separate a constitutional issue with the practicality of what is possible and is not possible. And where do we get to a point where we are handing out judgments or handing down judgments for legal jurisprudence sake vis-a-vis the actual protection of the people we're trying to look after? And I'll say this by saying, if the grid collapses, and there is a blackout in this country, forget schools and police stations, you have civil unrest. And those were the kinds of contentions that we, and let me not say we, I was not there, I was in the legislature, but that were having to be balanced out. And I do wonder, Advocate, whether those considerations played a part. And I'll say it openly, I do wonder when there is a need to overstep the separation of powers. We agree there is sometimes a need, but then the immediate pulling back. So you overstep to make a decision, yes, understandable, but then make a decision that is impossible to implement. And then again, we want to talk separation of powers. Then it's the executive that must implement a court order that is impossible to implement. So I'm just interested in the comments, CJ, and then I'll ask my second question. Thank you.
Yes. I think yes, I know which judgment you're referring to. I think one must bear in mind that if there was an overstepping of the mark by the court in granting an interdict of that nature, that there is an appellate process where corrective measures could be taken by the higher structures in assessing the reasoning of the court or quo. I'm not aware whether that matter has gone that route or not. When it comes to separation of powers, it's obviously an important consideration to ensure that there isn't judicial overreach. That does of necessity require a weighing of interests. When it comes to formulating a remedy, however, it must, I think, in principle, be capable of execution. And if it does overstep the mark, it must meet the test of being an exceptional circumstance as set out in OUTA. It cannot be a knee-jerk position to assume. It would really be exceptional. Now, I think as far as load shedding is concerned, it's been a bane of our existence for much too long. There are judgments about it, I think, in 2013 already. And the fact that it has been around for so long is really a matter of great disappointment to everybody. The solution to that, unfortunately, doesn't lie in the courts. And I think that's where courts have been trying to, I think that same judgment says the courts cannot solve load shedding. But when it comes to prioritizing who gets electricity, I think the court in that instance tried to take a position. Whether it's possible of execution, I don't know whether that was properly before the court. In the matter in which I was involved in, which was one of the related applications, we were really advancing the position of public participation in determining the allowable revenue of Eskom. And where our position was really that when NERSA itself would report 6 months before that there were billions of rands of misappropriation and within Eskom, and now has to determine allowable revenue, is it a valid question to ask whether they should be put into place precautionary measures to avoid the public purse being deprived of the benefit of public contributions? So that was a vantage point, which I think it's still to be crystallized, but our vantage point was to have the public be heard on these important issues prior to NERSA determining an allowable revenue.
Thank you, CJ. My second question, and maybe just to say that before, one of the reasons why we've put a stop or been able to put a stop to load shedding, different to load reduction, is actually, maybe it is important to say, not because of the rulings of that particular case I cited. It's fundamentally because of the ingenuity of Minister Ramokgopa and the team. And why I'm saying that is it could be conflated that the issue of load shedding now is different because of the case. But CJ, my second question relates to, and I'm looking for it here, because as you can see, I have a lot of documents to try and find it. But just to be clear, Advocate Labuschagne, did you act in any cases involving the University of Pretoria and fees must fall activists or students?
Yes, I was involved on behalf of the University of Pretoria over many years, and the Fees Must Fall campaign was part of it. Yes, that's
Thank
correct.
you, thank you, Advocate. Let me also caveat the next question by saying, which we all know, I was a foremost leader of Fees Must Fall at Wits University, a different institution, but the question is important nonetheless. Advocate, what are your views on the bullying tactics, not only by universities using top legal counsel to bully arguably a very marginalized group of people, students, who were exercising a very legitimate right to protest in view or really in finding the objective of free quality decolonized education? And I say that fundamentally because when you're a student, you have nothing. You have no money, and I'm very interested, Prof. Mr. Mangena also raised this around student housing earlier. You don't have much to leverage off with. In fact, the only thing you have to leverage off with is your potential to graduate and contribute to the economy. And I will also say that we had no money to find any sort of legal counsel. And when universities came to us, and I'll tell you an important moment during Fees Must Fall, there was a legal counsel who came to me while protesting. It's got nothing to do with you, Advocate. I'm just trying to give context. Who pointed at me and a number of other students and said, "This is the end of your legal career. We will prosecute and we will move to the very end." And there are many instances of student activists and student leaders, Kanya Seshe being one of them, Bonginkosi Kanyile, and many others who have lost every opportunity given to them because of some of the cases that emanated from those initial days. So I'm just interested, Advocate, in your thoughts around the bullying tactics of universities and council who also seek to bully the most marginalized of society.
Okay, could I address that issue from two vantage points? The first would be that in formulating applications on behalf of a university that is facing paralysis as far as lecturing is concerned and a threat to the exam program being completed, the formulation of the application and the relief sought took very careful notice of the right to protest. It's an acknowledgement. With a legitimate gripe, you have a right to protest. The question is, however, how do you exercise that right? And there, unfortunately, there were instances of criminality. There were instances, if you speak of bullying, of people walking in and hijacking classes where people were about to write their exams. Now, that type of conduct, although it makes a point, also oversteps the rights of other students to be educated. They have, after all, paid for it. So the right to protest is a right that needs to be exercised within the law. And the purpose of those applications was to ensure that that right is exercised in a way that doesn't paralyze the university, but doesn't limit their right to express whatever position they want to advance. So there was a balance involved. And I certainly don't see my own involvement as a matter of bullying. I think we were quite sensitive to the rights of students, and we were trying to balance the rights of other students and of the university to discharge its obligation of training students and affording them an opportunity to write their final exams.
I realize that I may have done you a disservice and sold you short. When you responded to my question about your acting stint that you had acted for 19 weeks, you'll recall the comment I made that that's a particularly long period of time. But then you have a vast CV, which I did not canvass. There are many aspects of it that I did not canvass with you when we spoke. And that includes features such as that in your 36 years in practice, you regularly appeared in our courts, especially the Supreme Court of Appeal and the Constitutional Court. Those are your stomping grounds.
That is correct.
And you've appeared in other courts across the borders as well on commercial matters.
That is
And your arbitration work actually straddles continents. You've worked in countries such as China, in Asia, and Europe.
That is correct.
And you are also a published author
That is
with a knack for writing children's books
I write children's books.
and a painter
That is correct.
and a
I
marriage
illustrate them.
officer. All right. Oh, I did not see that hand. JP Tlalezi?
Yeah, just one aspect here, Mr. Labuskachne.
Yes, Commissioner.
Yes, I do not know whether you have attended any of the seminars or training under the auspices of SAJE, but practice has over the years has shown that counsel who come onto the bench with such vast experience do not participate at these seminars. Most of the time is that I don't think there's anything that can I still be taught at this stage, and it's normally being done during recess, and they see their recess period being more valuable to themselves and not attending this training. And one advantage of attending these trainings is that you are able to share your best practices and experience with other colleagues who are participating or attending and not necessarily being taught. Now, I'm not sure whether will you be amenable, if appointed, that you will also make a contribution by participating and also subjecting yourself to be trained in the judicial sphere. Thank you.
Commissioner, I've always been a team player, and during my acting stints in the division in which I acted, there are about once a week there are lectures for judges during lunchtime to bring them up to speed, and I attended those during my acting stints and found them very valuable. I have no reason to doubt that if offered an opportunity to attend these type of training sessions, I will first of all make myself available to be trained. I'm not above that, and I would, in time, if my skill set is recognized, I would be able to assist when asked.
Thank you, CJ.
Thank you, JP. Hands are suddenly coming up now. Commissioner Muiman.
Thank you, CJ. CJ, just one question from my side on the greetings to yourself, advocate.
Sorry, what must I do?
I was just greeting.
Good day to you, Commissioner.
Thank you, Advocate Labuskachne. Just one question that I wanted to pose to you in relation to SAM versus Minister of Copta and Salga.
Yes.
The limitation clause.
Yes.
And the freedom to associate.
Yes.
Because I believe this was at the center of that judgment. And the Municipal Systems Act was set aside on the basis of the fact that it contravenes the right to associate, and it limits the political rights of a municipal official.
Yes.
Yes.
That matter was argued about 2 weeks ago in the Constitutional Court, and we are awaiting judgment.
Okay.
So it went further. At the time of my application, the judgment had been granted, declaring that Section 71B unconstitutional. The impact of that section is that it precludes staff members of any municipality from holding political office. And that it is that aspect of their Section 19 rights which is limited, and the argument was, can it be justified? I can go into what the counter arguments were, but the Constitutional Court will tell us in due course what the right answer is.
I'm interested in the counter arguments because there's no right that is absolute.
There's no?
There's no right that is absolute.
That is correct, yes.
Yeah, because you can imagine a municipal manager who's at the same time a regional chairperson of a particular organization, the influence that you will have over the same political office bearers that must exercise oversight over him.
There is a risk of paralysis of a municipality due to political infighting. And the purpose of that act was to depoliticize local government and to professionalize local government positions. The counter argument was that it was a sledgehammer approach to holding political office, whereas the argument in the Constitutional Court was that there's a balancing to take place. There are a few members who hold political office, and what one does by proscribing it is to remove the prospect of manipulation of the superior position they hold as against municipal managers and councillors in a manner that disrupts functioning, because that in the end affects service delivery. And we know that service delivery is a very emotive matter which can easily escalate into violence. So the argument was that for purposes, although it's a small limitation of rights, nevertheless of a right that is significant and what was won, it was hardly fought for. But the countervailing argument was that you get millions who benefit through better service delivery if the municipality is not paralyzed by infighting.
Thank you, Advocate. Thank you, CJ.
Commissioner Mkaito?
Thank you, Chief Justice. Good morning, Mr. Labuskaghni.
Good morning, Commissioner.
I just want to confirm that you and I have been on the same side and also on opposing sides.
That's correct. You want to talk about the last one?
Yes, I know. But just a general point on the discussion with the Premier.
Yes.
I mean, there are times when an advocate gets too close to the client and they lose objectivity, which is harmful to both the advocate and the client.
Yes.
But that's not the general rule. The general rule is that you are not the spokesperson of your client. You are its advocate.
That's correct.
And you are detached from the client. And if you've acted for the DA before or acted for AfriForum before, that's just part of who you are as an advocate.
Well, I might indicate that I've acted for premiers in the past as well.
Thank you.
Was it all, Commissioner?
Yes, it was all.
Sorry, CJ.
Yes, Premier?
I think Advocate Mugantobi got me wrong. I'm not questioning who Advocate Labuskaghni was representing. I was just asking disclosure. That's the only area. That in another part it was disclosed, but on the other side it was not disclosed. Representativity, I understand that fully. Yeah. I just felt let me clarify that.
Yes, well, perhaps then I should make a different follow-up. Was there any specific reason for mentioning the DA? I'm not sure if you didn't mention AfriForum, but...
So I thought the candidate answered the question. He said there was nothing sinister about his intentions. I'm not sure what...
No, then I'm happy then if that is where it ended.
Yes.
Commissioner Pillay?
As a follow-up,
yes, Commissioner Nkonyan.
I was tempted to ask. Good morning.
Good morning, Commissioner.
Advocate. As a follow-up to those questions, I was just tempted to ask you: do you belong to any political party?
I don't. I don't, and I never have.
Commissioner Pillay?
Thank you, Chief Justice. Good morning, Mr. Labuskaghni.
Good morning, Commissioner.
Mr. Mullins wrote a very interesting letter. We won't deal with much of the contents. There's one issue I do want to raise with you.
Please.
And you know that I represent the profession.
Yes.
And some of the feedback we've got from members of the profession, particularly in Pretoria, is that we should probe the commitment to transformation criterion.
Yes.
I see that Mr. Mullins says that his office is down the passage from yours, and he sees that majority of your juniors are black.
That's correct.
Do you confirm that?
Yes, yes.
And these juniors are being used in matters of substance, etc.?
Very much so. I've had the wonderful opportunity of introducing some of them to attorneys, very large firms, and they are being briefed on their own because they've turned out to be brilliant and they're doing well, and that gives me great joy.
And there would be no reason to your mind, Advocate Labuskaghni, that there should be a concern about commitment to transformation?
No. I've done that for many years without any hope of being recognized for it. I do it because I believe it's important.
Thank you. Thank you, Chief Justice.
Thank you, Commissioner Pillay. I've not seen any hands from the virtual platform. Any questions from there?
Thank you very much, CJ. Can you hear me?
Yes, we can, Commissioner Marumachai.
Yes. On the last occasion, I struggled. I think I was not audible. But anyway, good morning, Advocate Labuskaghni.
Good morning, Commissioner.
I see that you, on your questionnaire, you say that most of your work is on administrative law and by extension constitutional law.
Lately, yes, that's correct.
Yes. I just want to ask you a question that to some seems to be very clear, that our administrative law and in particular administrative action jurisprudence has developed to such an extent that we can say we now know when PAJA is applicable and when it is not applicable. But when one reads most of the judgments that are coming up, there seems to be some inconsistency on this too. I just want to get your view with regards to the development of the jurisprudence thus far. And what I think it's a triangle between PAJA, the Constitution, and then the principle of legality. In your own view, where are we as a country from a jurisprudential point of view in relation to judicial review? Do you believe that it is clear, when you are having an issue, want to review a particular administrative action, you can go one way or the other, or do we still have some challenges in terms of the clarity of the jurisprudence? Thank you, CJ.
Commissioner, if I might just deal with it from what I think is a watershed judgment, was the Gijima judgment. And in terms thereof, organs of state do not utilize PAJA for purposes of self-reviews. It is done in terms of legality. That has clarified the position as far as most organs of state are concerned. So it's a legality test. You don't have to go through all the requirements, time-wise, etc., as far as PAJA is concerned. In the field of administrative law, the development of the jurisprudence under PAJA and under Section 1C of the Constitution, the rule of law provision, has been one of the immensely interesting things. It's almost like two parallel systems, but each one has its function, and I think that Gijima judgment has indicated which one applies where.
No, thank you very much, Advocate Labuskaghni. Thank you very much, CJ.
Thank you, Commissioner. Commissioner Notius?
Yeah. Good morning, Advocate.
Good morning, Commissioner.
Look, I just want to ask you, because as a High Court judge, you will often preside over criminal cases.
Yes.
Just can you tell me, in the application of minimum sentences,
Yes.
what are the limitations of the sentencing court, if any limitations?
Yes, this is obviously an issue which would arise in the conducting of a criminal trial where the issue arises from the charges and a conviction. I've indicated that I've not presided over a criminal trial of that nature. However, as far as minimum sentences are concerned, there is always a tension between whether it is appropriate to apply it in a certain instance and whether there are considerations as to why there are mitigating considerations. And that's very much a factual consideration. The determination of whether the minimum sentence is applicable will be applied or not is dependent on a factual assessment of whether there is sufficient reason to deviate, as will be provided for in the section providing for the minimum sentence.
Is it not that the court must move on the basis that the Parliament has prescribed a sentence?
That
That
is
is, has
so.
ordained a sentence which must be imposed. And then you undergo the second part.
Obviously, the default position would be that a conviction attracts the minimum sentence. That would be so. It is a matter of legislative implementing the legislation. You are correct. Question whether it is appropriate in those circumstances is, however, part of the judicial function, because we must bear in mind that as judges, we are administering justice, and assessing the facts would be part of considering whether it is appropriate or not.
Yeah, I'm not sure about that part, but let's move. The second question relates to customary law.
Yes.
Is it competent for a court in the adjudication of a customary law dispute to invoke the principles of common law? That is, we are adjudicating a matter of concerning customary law. Is it appropriate to invoke the principles of common law in deciding that matter?
I think that the answer will lie in the provisions of Section 39 of the Constitution, which determines that when you are interpreting either common law or the customary law or statute, and they are separate areas, you have to apply the spirit, the purport, and the object of the Constitution. So I think when it comes to determining an interpretation of of customary law, one does it through the prism of the Constitution. I think it would, in principle, be incorrect to step over into the next body of law when it's not applicable, when it is a matter of customary law which needs to be determined and applied. I don't think common law, as a first comment, would find application unless there are compelling reasons. But in principle, it sounds to me that you are mixing apples and pears. You've been asked to decide a customary law issue, so do it.
Sorry, Chief Justice, can I just get clarity? I'm not sure, Mr. Labuskaghni, if I got it right. You're saying it's permissible or it's not permissible?
My vantage point was that if you are busy dealing with a customary law issue, it must be accorded the full value that the Constitution accords to it.
You've answered me. Thank you.
Yes.
Right. Well, it seems we've exhausted our questions, Advocate Labuskaghni. Unless, is there anything you wish to raise with us?
No, thank you.
All right. Well, thank you so much for making yourself available for this vacancy. And I have to make this comment that it's rare for our top lawyers, which you are, that's a fact, to make themselves available for the bench. And we know what the challenges are. So we always appreciate it when someone like you does make themselves available. And we hope this will encourage, I hope they are listening out there. It will encourage our top lawyers, especially the black ones, make themselves available for the bench. We know the pay is poor, but we are drowning. We need our good people. Thank you,
Thank you for
Advocate.
the opportunity. Thank you, CJ. Thank you, Commissioners.
We've been Good day, Advocate Mohammed.
Good day, Chief Justice.
How are you?
I'm well, thank you.
Good. Whew, you have a string of academic qualifications.
That is correct,
You
CJ.
have 3 degrees, a BA, LLB, and LLM from the University of Natal and Pretoria, Universities of Natal and Pretoria. Your LLM was in corporate law.
That's correct.
And then you have this string of diplomas and certificates on a wide range of subjects.
Yes, CJ.
You lectured, which makes sense, seeing that you love education so much.
I do, yes.
But
and
that
I
was
have-
for a brief stint.
That's correct.
How long?
CJ, I was employed as a part-time lecturer at various institutions. I was trying to fund my studies, and this was one way of doing it. So I've worked intermittently at least 2 or 3 technical colleges in those days. So one of them was the Mangosuthu Technikon in Mlazi. And I must have been employed for about 3 or 4 years on a part-time basis. These were evening studies, so I was teaching adult students.
All right. And then you decided that you wanted to practice.
I was working through to get to practice. When I was teaching, I was also a student at the time.
All right. So you did articles between 1992 and 1994, then started practicing.
That's correct, yes.
Made your way from professional assistant to partner by 1997.
Yeah, partners sounds rather impressive, but I'm afraid it didn't work out too well for us.
So you were an attorney for about 4 years.
That's correct, yes.
And then you decided to join prosecution.
Yes, I was interested in the work of public
Oh, no,
protector.
sorry. The public protector. You joined the public protector as a senior investigator.
That's correct, CJ.
How long were you there?
I was at the public protector for about 2 years, and then joined the office of the Scorpions at the time.
Yes. As a senior state advocate.
That is correct, yes.
And then you went on to Legal Aid SA as a senior attorney.
Yes, I joined the Legal Aid Board after that.
What did you do thereafter? Your questionnaire stops there.
CJ, I joined the bar after I completed my time at the Legal Aid Board. I was interested in litigation itself, doing the work myself, and I've been at the bar since 2007.
That's quite a checkered legal career.
Yes, it is.
You have acted as a judge.
I have, CJ.
Where and for how long?
CJ, I've worked in both the Pretoria and Johannesburg courts, and I've done a total of 60 weeks.
And what kind of work did you do during your acting stints?
CJ, I have worked in almost all courts across these 60 weeks, barring the tax court.
All right. So did you, I assume by everything you mean criminal and civil across the spectrum?
I've not sat in a criminal trial.
You have not?
No. But I have some criminal experience as a young attorney. A lot of my work was from the Legal Aid Board. So I have done some of that, and being part of the Scorpions, obviously I had to develop prosecution mind as well.
Yes. You attended the aspirant judges training program.
Yes.
Twice.
Yes.
Did you find it useful?
Oh, yes, it's very important to be able to extract as much information on the real life of court, and I call it getting court-wise. There's a significant difference between an academic practitioner on the other side, but being on the side of the bench and getting a sense of the atmosphere and what to expect is a very useful exercise.
Yeah. What kind of work do you do in your practice?
As an attorney?
No, as an advocate.
Oh, as counsel, I primarily was briefed with the road accident fund work, and I did some family law, and in between a few labor matters that crossed my desk.
Your last acting stint was this year in May.
Actually, the last term, CJ. I served the last term.
The whole term?
That's correct, yes.
And you've written judgments?
I've written judgments. I think I have a total of 85 judgments.
85?
That's correct.
Okay. Have any of those been reported?
I've reported one, CJ.
Okay. When you completed your application form, you listed a reserved judgment, just one.
Yes.
And you promised that it would be delivered some time back.
Yes,
Was it actually delivered?
Yes, it has been delivered.
So you don't owe anything?
I owe
there.
one from the last term.
It's
So I've
it's
just-
still from recent times?
Yes. Yes.
Okay. All right. I'm going to ask Judge President Mlambo to put questions to you if he has any.
Thank you very much, Chief Justice. Good morning, Advocate Mohammed.
Good morning, JP.
I just want to deal with your exposure to the Gauteng division work. According to the spreadsheet that should be in front of you there, you started acting in 2020, just before COVID.
That's correct. Yes, I did some pro bono service then.
Yeah. And I see you the only candidate of all of them that's done 9 full weeks in the opposed motion court.
Yes.
Throughout your acting stint.
That's correct.
Yeah. Is it an easy court to work in?
It's a highly pressurized court to work in, JP. Most of my judgments arise in the opposed court, and obviously we have to meet a deadline, and
Yes.
I've managed to do so in most of my matters.
Yes. And you've done 1 special motion week as well as 1 agent court week.
JP, I just looked through your spreadsheet, and I realized that I robbed myself of 1 week. Which, I'd forgotten about the week in the recess. So I agree with 60 weeks.
For the agent court?
No, this
Yeah.
is for the total weeks.
Okay.
As far as the urgent is concerned, you are correct.
Okay.
And as far as the special motions are concerned, I think I put one matter into a different category, but I have actually done 2 special motions.
Okay, thank you very much. That's fair. So, and let me just look at this. There's been 3 occasions, 4 actually, no 5, where you've actually come to act for a full term.
That's correct, yes.
5 full terms.
Yes.
And having done that, because that's the usual load that the permanent judge carries in Gauteng, you feel you are now ready to become permanent?
Yes, JP, I feel confident. I think I have become somewhat court-wise.
Yeah. Right, let's deal with your judgments. I've done a scan of them all. There's about 3, I think, that were just over, that were 4 months. And then there's one that was, I think, 5 months. And then there was one that was long, reserved for about 9 months.
That's correct, yes.
And I don't want to tell the commission what happened there, but can you tell the commission what happened with that matter?
So in regard to the matter that took me 9 months, the matter was set down as a trial of long duration for 15 days. It finished on 28 days.
That's what we call a special trial.
This is right, yes.
Thank you.
And I had to traverse a very, very long court record of 3,700 pages, and the evidence from 18 witnesses. The closing arguments were heard on a few days just before I commenced a full term. I couldn't find the time to work this judgment because the full term I managed to pick up about 14 reserve judgments. I prioritized those, and if you look at my list of judgments, they've been dated, so you have a sense of how regular the judgments were delivered soon after the term. And as soon as I was done with that, I commenced with the trial of long duration. In the time, JP, I would like to tell you that I had kept contact with the attorneys and advised them as to my progress in their matter. And the extension of time I had come to you to discuss this matter with you, and you were kind enough to offer me extra service if necessary. I didn't need that simply because I just had to get through the very long trial record. And it was important for me to read this trial record because the parties were very passionate about this. And I thought about the next step this judgment may take, which is probably in a senior court. And I thought for that reason, I needed to actually do a little bit of cross-referencing as well. So this took me a while, and I do my own typing. So
I think the issue is you realize that this was a complex special civil trial, and you required more time to give the judgment, but you kept the parties informed of what was happening.
Oh, yes, yes.
Because I didn't receive a single letter of complaint.
Right.
And you actually came to me as head of court to say, this is going to be beyond the allowable periods.
Yes.
These are the reasons. Please allow me the space. So that's what happened. But that's the only one. Am I correct?
Sorry?
That's the only one that took that long.
Oh, yes, yes. I
Yeah.
have delivered most of my judgments in the required 3 months.
Yeah. Okay. Now, your judgments span quite a wide spectrum, so I'm not going to go through that. But I'm sure you would have heard me say to the other candidates, I have a scoring matrix. I'll score you after this interview. I'll score you on your exposure to the complex work, and I'll score you to the time it took you to hand down your judgments, right? Do you have any comment about that? Well, maybe the direct question is, in terms of your exposure to complex work in the division, out of 7, how much would you score yourself?
JP, I've had a number of long duration trials and 2 special motions. I've dealt with them independently without any real support required. I would place myself, given the 9 months that I'd taken on one matter, fairly without necessarily overstating my case, at about 6 of 7 or 6.5 perhaps.
Okay, no problem. Thank you, Chief Justice. I've got no further questions.
Thanks, JP. Premier?
Thanks, Chief Justice. I don't have questions for this candidate. Thank you so much.
Thank you very much.
Do you have questions for the candidates, commissioners? Commissioner Gauteng?
Hi, hello.
Hello,
Advocate.
Commissioner.
How are you today?
Very well, thank you.
Good. With reference to news reports that civil claims in one of Gauteng's courts could only be heard in 2029, it was recently reported that legal professionals are at their wits' end over the longest backlog in history. That's in quotes. What, in your view, is a judge's role in ensuring the expedience of the administration of justice?
Commissioner, I think I am aware of the very long trial role and the very heavy court role itself. I am committed to having my courts attended to as soon as I can, my work as soon as I can, and certainly in terms of the delivery of judgments. I think that a judge can also develop an ability to identify delays that arise within the courtroom itself. So that is an important skill that a judge has to, and this is where I think when I speak about getting court wires, this is one of the ways in which a judge can be firm as to the pace at which matters actually proceed. I often also adopt the approach that if I had requested something, I would provide a timeline. So by then, parties are required to actually respond. And I make it even easier by ensuring that I provide what would be virtual platforms sometimes just to expedite matters.
Thank you.
Commissioner Mangen?
Thank you, Chief Justice. Good afternoon, Advocate. I'm here on your other
Thank
right.
You. Sorry, thank you.
On your other right, which is your left.
Right,
yes. Advocate Mohammed, I want to comment you on the judgment of Eva versus Eva. You
Yes.
remember that judgment?
Yes.
That judgment that you were dealing with a Rule 43 application. And one of the issues that came for adjudication by you was the respondent's duty to help the applicant in finding accommodation, because at that time the applicant had left the matrimonial home and went to stay with her parents, and the respondent refused to make contribution towards that shelter. And in the course of your judgment, you made reference to the duty of support and its connection to the right, to the constitutional right to housing and dignity. And ultimately, you arrived at a conclusion that the respondent, who was the husband, has an obligation to pay, to make a contribution towards that housing need for the applicant. Now, I thought that was brave of you, but also that was beautiful, because you were able to bring in the constitutional values required in adjudication of disputes. But secondly, it is a matter that it's affecting mostly women who are in relationships which, when divorce is looming, are preceded by what is the word? English is escaping me. Turmoil and abuse. And as an escape, they move out of the matrimonial home, take refuge either with friends and or with family. And in that instance, if the matter comes before a judge who is insensitive, or a magistrate in the regional court who is insensitive, more often than not, those kind of vulnerable people do not get the assistance that they get. What's your view on it?
Yes, I'm pleased to hear that I have a support on that aspect, Commissioner, and also that the vulnerability is on both sides of the gender base. The reality is that it is a skewed situation. And obviously, based on the economics and men in the society are better supported economically. In this instance, though, the respondent left the home from a domestic dispute where he had been unfaithful to her. And he continued to reside in the marital home. And he continued to maintain the same lifestyle, living in the marital home. And the evidence before me was that whenever he needed to pursue social, some of his hobbies, he would take loans from his businesses and build up loan accounts. And my view was, well, he has access to capital to support himself. He must find some access or some capital to contribute to what is a basic need of accommodation. And she demonstrated that she couldn't afford it because she continued to live with her mother for many years.
Thank you. Thank you, Chief Justice.
Commissioner Nonkonyan.
Thank you, Chief Justice. Good afternoon.
Good afternoon, Commissioner.
Madam. Like Commissioner Mangena before me, I'm impressed, but I'm impressed. Respect of another case. I think it's Kastler, Say, and O'Neill, the Israel applicant that he made an application to have his children travel with him to Israel.
Yes.
And I'm impressed about how you balanced the interest between these two litigants and to ensure that they're coming. But my question is, how old were these children? And bear in mind that Israel is notorious. It's not a safe place for one to go to. Isn't that context that I'm asking? Are you able to share with us how old are these children?
Yes, Commissioner, I think Israel has become part of the news after this judgment was delivered. So at the time, the children were wanting to join their father to visit their family out in Israel. They were, to answer your question, between 10 and 12 years old. And the application was simply for a removal for a limited period, and they would return once the school holidays were over. But the volatility in the area had arisen after this judgment was delivered. This judgment, I think, was delivered sometime in December of 2022.
Thank you, CJ.
Deputy President Zondi.
Thank you, Chief Justice. Good afternoon, Advocate Mohammed.
Good afternoon. Sorry, Commissioner, I don't know where you're sitting.
Oh, I'm here.
Thank you. Sorry, President.
Okay. I see that in 2006, you attended a fellowship or leadership program in the US investigating ways to develop class action litigation in South Africa. Now, that experience that you acquired in the US, have you been able to put it to use it, having regard to the socio-economic situation in South Africa, more especially for those for those employees who work in the mines and they contracted some respiratory-related diseases? Were you able to put that experience into use?
Thank you, Commissioner. I was part of the silicosis litigation against mines on behalf of mine workers. I can't say that I was part of the main litigation team, but I was included on the team. I was responsible for the discovery of documents. We had to go through not less than 1 million documents, and literally so, I'm not exaggerating. That was handed over by the defendants in the matter. And on that basis, I was able to understand the impact and the logistics that are involved in class action litigation. I have not been involved in any of the others that have arisen since then.
Thank you. Thank you, CJ. I just follow this up. Advocate Mohammed, who are you acting for? Because that case, if it was the Ngala case, that's the case that caused black advocates to protest in court because blacks were not included in the plaintiffs or the defendants' team.
Sorry, Counsel, I apologize, Commissioner. This was the silicosis litigation that was against Anglo and its partners.
Yes, but that's the one, it's Ngala, the actual designation is Ngala.
Yes, yes.
Because I seem to remember that case that we went to protest because black people were excluded. So who are you acting for?
For the plaintiff in the matter, the mine workers. And Commissioner, this was the very first matter that appeared before the court in terms of certification. So I'm not sure if that is the...
Yes, Commissioner Pillay has just shown me the list of counsel. Your name is not here.
Yes, as I said, I was part of the discovery team. I was responsible for discovery. If perhaps Advocate Moultrie was part of the team, led by, I think, counsel based in Cape Town. If I can't remember, it was...
This is the judgment of the full court with Mojapelo, DJP, Valley J, and Windell J. That's the case I remember that AFT organized the protest. And we've got the list here, and you are not here.
Well, I did, Commissioner, set out that I was not part of the main litigation team, but I was part of their team in terms of having to go through the various documents that were discovered in that matter.
All right, thank you.
Yeah, thank you, Chief Justice. Good afternoon, Ms. Mohammed.
Good afternoon, Commissioner.
Ms. Mohammed, based on what you were saying, you would have been one of the only black people involved in the matter. Did you note that there was a problem with the composition of the team?
Oh yes, definitely was very skewed, and but I can't say that I was actually the only black person. Skikakana SC was also part of the, well, he's SC now, but at the time he was part of the, we shared the covering of those documents.
And did you raise your concerns with the leadership of the team?
I did not raise my concerns as I ought to have. I was pretty new at the bar. I just joined the bar, and one has to understand the culture. It takes a while to understand the culture, and but at some point I had indicated, I think there was a limited room for a teleconference, and I offered to remove myself from that because I communicated that not much work was really being assigned to me beyond reading documents. And I must say that is as far as I had gone, and I was then replaced at some point. The management team called me to say that they needed to free up legal fees, funds, to employ other counsel.
And you offered to withdraw because you felt that you were not being effectively used?
I offered to allow another counsel or any other counsel to join this teleconference because there wasn't sufficient space for everybody. And because I really wasn't being given anything specific to or to contribute effectively to it. Yes.
And in your many years at the bar, Ms. Mohammed, have you utilized black juniors in your matters?
Commissioner, I have not, for the reason that I myself considered myself a recipient of those sorts of opportunities. I did get at them, and as I said, I pointed out that a lot of my work was road accident fund based, And anything else was really from a very small law firm. What I can tell you is that my transformation efforts are honest. I haven't recorded them. I never planned that I would necessarily have to record what I do and who I do it for. And I'm certainly very committed to creating a competitive environment. And I'm fully appreciative of the position of women at the bar, particularly Black women. So as far as including people in my teams, I am afraid I myself didn't get the sort of work that would afford any additional counsel.
So if I understand your answer, the type of briefs, the type of matches that you were receiving at the bar was not the type that would allow you to bring in juniors, whether they be black or white juniors.
Oh, yes, yes. And they were not reflective of the sort of skills that I actually brought to the bar. I joined the bar in my 40s. I developed a lot of skills over the years and joined on the basis that I know something and I could contribute, but I haven't had those opportunities.
Sorry, Chief, just two more questions. And you joined the bar having played a leadership role in the strategic litigation unit of the Legal Aid Board.
Oh yes, yes, yes. I was invited to start up the impact litigation unit for the Legal Aid Board. It was very new to the Legal Aid Board in terms of the concept itself. And I managed to effectively set up this unit. I briefed certain councils, Johannesburg, Cape Town, across the country. So yes, I did develop that kind of skill.
And coming to the bar with this level of skill, why do you think that you were not able to get the kind of work that you ought to have gotten at the bar?
Yes, it is a challenge, Commissioner, and that challenge continues. And I think we need to understand, I wish I had known the environment before I even joined it. I would never have joined it because the reason I apply here is about how effective I can be given my varied skills. And I've never had that opportunity as counsel. Whether I was sidelined for various reasons, I have no idea. But I can tell you that, having joined a group, obviously I had to submit my background, which I had. I certainly was a team player. I have no enemies. I've remained in the same group for 15 years, and I take note from one of your training sessions that I ought perhaps to have moved on, but I didn't. And as to the reasons, well, the reasons are often about dominance of certain genders, certain race groups. I know that I can say that the white female does better than the black female. They are better looked after. Perhaps not in the last 2 years, perhaps the playing fields have leveled. But I'm past the 2 years. I've been there for 15 years. So as to what is really happening on the ground, I might be a little divorced now. And I'd like you to also appreciate that at 40, you expect people to appear and address you with sincerity and as a level of professionalism, which I found to be different. So as an older person, I'm not sure about other people's experiences, but when you're older, you tend to say, all right, I can move on and do my own thing. But it is a difficult terrain. It's an extremely difficult terrain. And and I want to add, the JP has told me to keep my answers rather short, but I want to add that in the years that I've served as an acting judge, I make a concerted effort to ensure that there is fair cross-pollination of skills. So if you arrived, and this is from the very first court, the unopposed court that I run, and I've done it through all of my unopposed courts, I inform counsel who are senior and often sit in front that I'm going to be taking them through the very basics of their applications so that those who sit behind them may learn something, particularly in that whether they will get a similar brief is a big question. And when juniors do come in to introduce themselves to me, I alert them to the fact that my court is going to be a teaching court. Unfortunately, it has to be that. That is the need on the ground at the moment. The other concerted effort I make in terms of transformation is that I approach my judgment writing at a level that demystifies the law, actually, I hope, where a reader gets right into the topic, understands the area of law, because I believe also that we have just so much of reading to get through. And particularly in this division, we are so busy. So I'm hoping that through my judgment writing, as others may view it as basic, I'm willing to take that risk for now. I'm very committed that the people who appear before me, if I'm ever appointed as a full-time judge, are going to appear before me on effective arguments. And the way to do that, in my view, from the bench is offer these sorts of opportunities to grow and to build a level of confidence.
Thank you, Advocate Mohammed. Thank you, CJ.
Sorry, Chief Justice, I really do want to get clarity on this thing about the silicosis case.
Yes.
Because I'm not sure if I understand your answer. Why did you end up not being in the final list of the advocates? Because that list was all white. If you say you were involved at the beginning of the case.
Commissioner, I'm in 2007, when I joined the bar, toward the end of that year, I was contacted by counsel to, let me just take a step back. Before I joined the bar, I was the manager of the Impact Litigation Unit of the Legal Aid Board. I had read through the proposals put for funding in this matter, and I got approval to fund the matter at R1 million, which in Legal Aid Board terms was a lot of money. And I think I was remembered when I joined the bar, and on that basis was invited to cover what would be the discovery, the documents that were discovered by the defendants in the matter. I had completed that together with counsel advocate Skikakana. And after that, I think the management team decided they needed to probably bring in more people, but that's as far as I had gotten.
But what happened? Were you removed? Did you resign from the brief? I'm trying to understand whether it's part and parcel, because we, at the time, I think this was a 2013 case, 2014 case, it was the first time black advocates protested inside of court because of racism.
Yes.
And I had no idea then, even now, that you were actually in the case. So I'm trying to understand whether your removal from the case was part of a racist practice, or how it happened that a black woman was once in and then disappeared.
Commissioner, I'm not able to answer that question effectively or with any kind of commitment, other than to say that I was contacted to say, we need the funding that we have for you to employ another.
No. Chief Justice, no. May I just follow up on this? Advocate Mohammed, you were aware that you and Advocate Skakan were the only two black people working on this matter. And probably at that time, you were aware, as a member of the bar, of the discomfort that's in the corridors about lack of briefs. And when you were taken off the brief, did you accept the reason? And if not, what other steps did you take to make sure that the bad treatment that you were receiving does not continue?
Commissioner, to be honest, I had been running low on funds by that time. I was focusing on building my practice as best I could. And it's been a struggle throughout. It's just been a struggle. As to my efforts, well, I tried to support whoever my colleagues were, who may have raised issues with me. But it's been an uphill battle, and it's a huge mountain to climb, simply because there isn't also, and I'm talking way back in 2007, the terrain has improved, definitely, in the last 5 or 6 or 10 years, perhaps. But when I started as well, there were no real support mechanisms for Black Council. I think that the system was just sort of developing with the AFT, but in terms of effective support, that has grown. That definitely has grown. But at the time, I think I was also rather intimidated by all of this at 40, and I was really trying to focus on how best I can build a practice.
Did you get a sense that you were being removed and taken off the brief because you are a black woman?
Well, within the context of where I found myself, and on reflection, it may well have been one of the factors.
Thank you, Chief Justice.
Commissioner Kane?
Thank you, Chief Justice. Good morning, Ms. Mohammed.
Good morning, Ms. King.
On the last occasion that you were interviewed, I think in late 2023, I did ask you about the 2 cases that you list as being your most significant. And it's traversed in paragraph 6.3 of your application. On that occasion in 2023, you made reference to the 2 cases that you repeat in the current application. The one concerns the failure to notify a person who owned a motor vehicle that he was in arrears and that his car would be possessed. And the other concerned the failure of a medical practitioner to fill in a form properly, and it was held that the treating doctor had been in substantial compliance of filling in the form. On the last occasion, I said to you that this would evidence a lack of experience as an advocate. And I just ask you now why it would be that you come to this body on the same information with no new evidence that you have a practice that you've developed further in any way.
Well, the time period between the submission and my last interview is a year. And I have no matters that have gone into court or had any kind of, has not necessarily developed since then. And whilst I do have some matters on my desk, they're still in infancy. And the truth of the matter as well is that I'm focusing on this appointment. So I've served a lot of my weeks as well in that time away from my chamber. I've not been taking on, because it does impact, Commissioner, on one's work as well. I obviously have to be vigilant about being available for my client. And so to take on a new client would be a risk. So this has been the reason why I haven't been able to come up with anything current or since then. And in regard to what may appear to be the sale of a car, as I remember you had raised the last time, it was really about the consumer rights protection within the National Credit Act that I had identified. But perhaps I should give you what I hadn't conveyed the last time. And again, it was from simply not understanding whether these are emotional issues that one raises. But be that as it may, this matter is important to me and will continue to be important to me, because when I received it, it was a hand-over brief in an interlocutory matter. At the time, I had reached a point in my career where I thought I really had not much to offer, because the briefs were mediocre and really peripheral in practice. I had some advice work that I would do, but nothing that would take me to effective argument in the motion court. When this arrived and I identified what would be a constitutional debate, which I can assure you, the attorney who handed this matter, or my colleague who handed the matter to me would never have handed it to me if she had herself identified that this was the potential for this matter. And that is the context in which this matter will always be meaningful to me. And I stand by this, because that has been the challenge. And in many instances at the bar, this challenge continues. And the only way I think that we can overcome this is if we identify it for what it is and see how best we can address these issues. But this was my experience then. So this matter will be useful for me. I was able to identify a constitutional debate. The presiding judge was a respected judge who asked for further heads of argument. And unfortunately, I couldn't continue for two reasons. One, the attorney would, having identified the potential for this matter, had not come back to me. And subsequently, I was advised that my opponents had withdrawn the matter, which was the bank.
Thank you, Chief Justice.
Thank you, Ms. King. You have had significant acting experience since we interviewed you in October last year, don't you? I
Yes.
remember that the complaint from the professional bodies as a whole was that you did not have sufficient acting experience and you could benefit from more stints which you got.
That's correct, yes.
And I see now that all those professional bodies, including the GCB, actually think you'd have value to add. Your appointment would have value to add to the institution, the judiciary.
Yes.
All right. Okay. Are there any questions from the virtual platform?
No, thank you, Chief Justice.
None from me, Chief Justice.
Commissioner Mtweni? All right, I'll take your silence to mean that she has nothing to ask. Just one tiny detail, tiny but important detail. I raised it with you in your previous interview. The fact that you are an accredited mediator with AFSA, and you spoke passionately about that and the value it would add in the running of our courts. So I won't ask you anymore. I just want to place it on record that you also have that skill.
Oh, yes, yes, and I am still very passionate about it. And in fact, just to respond to the question as to what the courts can do to speed up matters, this is also a very important tool to dispute resolution, and we have to, as a society and certainly within the legal fraternity, take this a lot more seriously. In fact, I'm going to next week or so be preparing a program for users of mediation as part of the membership I hold with the committee.
Right. JP?
Thank you very much, CJ. I'm sorry to ask this follow-up question, but Advocate Mohammed, I would like you to allay the concerns that both Advocate Ngogaitobi and Advocate Pillay have raised about your involvement in that silicosis matter, because it's not clear. I mean, were you only brought into that matter just to deal with documents or what? Because they say your name doesn't appear.
That's correct, yes. I was given a task to deal with all of the documents that were discovered by the mining companies.
And you say you were with Advocate who? Skakane.
Yes, Sikakane was doing the reading with me.
So you would have been aware of the protest?
That happened subsequent to my removal from the...
Or subsequent to your removal?
That's
from
correct,
the
yes,
matter?
yes, yes.
Okay. But who was the leader of the legal team you were part of? Because the council at the top of the table, they do have the list. Unfortunately, they're too far from me. I'll take the list and show it to you. But it would be good to know who was leading that team.
Sorry, JB, the name escapes me, but I know that senior counsel and the lead counsel was based in Cape Town, and I think he's since passed, I'm not sure. But there were a number of other councils. I think we were about 7 or 8 on the team. And I do remember that Moultrie SC was also part of this team.
Moultrie.
That's correct, yes, yeah. As I said, JP, it's not about identifying a person. I certainly didn't have bad experiences as a part of the team, but my brief was terminated at a point.
Thank you. Thank you very much, CJ.
Thank you, JP. Thank you for making yourself available again, Ms. Mohammed.
Thank you, Chief Justice.
Is there anything you want to raise with us?
Except to congratulate you on your appointment as Chief Justice of the Republic of South Africa. And I'm looking for a lot of leadership, and I'm sure I will find it.
Thank you for that.
Thank you to the commissioners for this opportunity. And yeah, thanks.
Okay, you're excused. Shall we take lunch?
Sorry to keep you waiting, Mr. Makam. How are you?
I'm very well, and yourself, Chief Justice?
Fine, thanks.
Thanks.
You were here not very long ago, so you are familiar with the procedure.
Yes, sort of.
At least you have an idea what to expect. You would not be nervous.
Yes.
Good.
Thanks, Chief Justice.
All right. You, I recall that you have many degrees, many law degrees, 3 in all.
Yes.
Legal qualifications, rather. You did a deep juris, then did the degree, the B juris, and then you did your LLB.
Yes, and I just did not complete my LLM.
Yeah, you did mention that. You still have not done anything in that regard.
Yes, when I wanted to continue, the department closed because the professor was running it immigrated to another country.
Mm. Okay. So your career has been in public sector. You've been with the Department of Justice since you started,
Yes.
and that was in 1980
Yes, Chief Justice.
as a court interpreter.
Yes, Chief Justice.
I'm tired. Sorry. It's been a long morning. Court interpreter. Then you just went through all the ranks. Clerk of
Yes.
the court, estate clerk, and did many things. Then you went into prosecution until you became a magistrate.
Yes, Chief Justice.
And how long have you been a magistrate?
Almost 40 years now.
Yeah. And you're a regional magistrate.
Yes, Chief Justice.
As a district court magistrate, did you get a chance to do civil work?
No, Chief Justice. During those days, yes, I eventually did, but when I was still in Guyana, that was a domain which was specifically for the chief or the head of the office.
Yeah.
And not everyone else could do it. And the civil matters were very, very few. That's why they held it very close to their chest.
Yeah.
But when I became head of the office in Benoni, then I started to do civil work. I knew that I had not done much, so I started to engage myself in it, and that's where I picked up a lot of experience in civil.
Mm. Mm. And in the regional court, there is a bit of civil work there, isn't there?
Yes, we do civil and criminal and divorces.
You've acted as a judge on a few occasions.
Yes, yes, from 2016, but the majority part of it, I was seized with a matter that was very, very long, a white-collar crime, which fortunately I finalized.
Okay. So, what kind of work have you been exposed to during these acting stints?
Civil trials, opposed and unopposed motions, those were the only ones. Well, and the appeals, and mainly the criminal appeals, being on the full bench and full court.
Mm-hmm. So, would you say you've had a fair amount of exposure in civil, in the civil space?
I will say so, Chief Justice. Yes, I might not have done the agent court and other areas, but that was due to what was identified, I believe, by the judge president and the deputy judge presidents, that I was strong in criminal and in criminal law, and they did not have much experience in that regard, and they assigned me there, and I was happy to do it, and I'm still very happy to do criminal work as well. But it doesn't mean that I cannot do any other civil work.
Yeah. Have you written any judgments?
Yes,
Well, you have.
Yes, I did.
In civil and criminal law?
Yes, I did, Chief Justice.
About how many?
as an acting judge?
When I try to count, I think there are 47.
Mm-hmm.
Yes.
Have any of those reported?
Not as far as I know.
No. Uh, how old are you?
I'm 66.
67, next birthday.
Yes. Chief Justice.
I raise this because it may be an issue for in some quarters, and I want you to address it squarely while you are sitting here. If the fact that you are that age should disqualify you from being appointed.
Chief Justice, I dedicated my life to the judiciary now, and I believe I've done more than enough in the lower court, and I have already gathered a bit of experience in the High Court, and I believe that the remaining years of my life, which could be 8 years or more, I will still contribute meaningfully to the High Court bench. So instead of wasting this, my 8 years that is left, I rather be utilized effectively, especially in the higher court.
Mm. You have mentioned some health issues in the application form. Do those impede the execution of your judicial duties in any way?
I will respond in this way, that my last real sick leave was in 1999. And the next sick leave that I had was during 2021, 2020, during the COVID. Just because I tested positive for COVID, I couldn't go to work. But other than that, I am not bothered at all. It's something that I live with and is very much under control.
Yes, so you get along just fine with the rest of all of us.
Yes, yes, Chief Justice. I think I don't even know that I've got it. I just do the routine that I've been given, and I've never had an issue with it, even on a single day.
Well, it would not be fair. Well, let me just ask what you would add this time around, seeing that you've been here before and was unsuccessful. What do you have to add that you have done since October 2023 that would plump your CV up just a little bit?
Well, Chief Justice, I've done unopposed applications, I've done opposed, and with the criminal case that I was seized with, I have learned quite a lot as well, which experience I believe that it will come very handy in dealing with any other matter, especially the criminal matters. So I believe that experience that I have now will be very much beneficial to the High Court bench.
Well, the GCB has some misgivings about the quality of your reasoning and writing of judgments.
Yes, I saw that, Chief Justice. However,
how would you respond to that?
In this field, we keep on learning. And one thing certain is that you don't normally have somebody holding your hand. So these critics that I received now, because in 2022, I did not have the benefit of seeing them. And now I have seen them, I'm able to see where I am lacking. And that's exactly where I'm going to work very hard to make sure that my judgments are better. And they indicated that it seems like it's a little bit better than the previous one when they saw the current judgments. And it was without even the benefit of the critics. So now that I know those critics, then definitely I'm going to work very hard to make sure that my judgments look much better.
Have you taken advantage of the judgment writing seminars offered, for example, by the SAJA?
Yes, I have. I've attended them. The only thing is that when you attend those that are offered by SAJA, focusing on the lower court, you don't get the same quality of advice that you get when you attend the one that is provided for judges. However, when I was in Johannesburg High Court, every Thursday, or most of the Thursdays, there is training that is going on in there. And I've already since learned quite a lot. The last justice who trained us was Justice Nafsa, who gave us a lot of pointers, which I felt that they benefited me a lot. And I feel I'm still ready to continue and work very hard to get more skills in my writing. And I promise you, Chief Justice, I believe the next judgment that you'll get, because of the benefit of GCB's comments, will look extremely different from the previous ones.
Well, small credit is that they do say they discern a slight improvement. So it's not as bad as it was previously in their view.
Yeah, thank you, Chief Justice. That's why I say it was even without the benefit of the critics. Maybe they thought I saw their criticisms in 2022, and unfortunately, I had not seen them. So now that I've seen these ones, they will say something much better in case they have to see my judgments. And whenever I'm sitting in court, if they meet my judgments, they will definitely realize that there's a huge improvement. Thank you, Chief Justice.
All right, Judge President Mlam.
Thank you very much, Chief Justice. Absent Tata.
Absent, Judge President.
Minjani.
Ifukile Minjani.
Ifukile.
Isona.
I don't want us to beat about the bush. The predominant area of the High Court work area you've been allocated is criminal trials, am I correct?
Yes, JP.
And that's because of your specialization in criminal work, especially as a regional magistrate, am I correct?
Yes, JP.
Now, you've had occasions, like you've had 3 weeks in the unopposed motion courts, and that's reflected in the judgment list that you've circulated where you show draft orders and stuff. And you had 2 opposed motion weeks.
Yes.
Right.
Yes, JP.
And you've written judgments.
Yes, JP.
What I noticed in those judgments is none of them were more than 3 months.
Yes, JP.
Right. Despite the fact that you are a criminal specialist.
Yes, JP. My personal drive is that whenever I say the judgment is reserved, immediately in my own diary, I write when it's going to be delivered. Yes. And I strive to make sure that it's delivered by that day, or even earlier.
Now, you've been busy with a trial, State versus Dube. When did you get that trial and how long did it take you to run that trial?
It started on the 31st of July 2018, but in earnest, it started on the 1st of August. And I was seized with that matter, and I delivered my judgment on the 13th of November 2023, and my sentence on the 19th of April 2024.
Right. It involved something like, what is it, 11 accused?
Initially, there were 13, and then 2 became Section 204 state witnesses. And as time went on, unfortunately, 2 of the accused also passed on.
Yeah. Now, someone will ask, how does it happen that it takes you a trial from 2018 to 2024?
Whoever has dealt with a case that has got multiple accused persons and multiple counsel will know that it's not an easy sailing. One other very unfortunate thing in this matter, one accused was not in her best health when we started, and she kept on being absent because of that, and we couldn't proceed without her.
Yeah, I think what I want you to tell the commission is there are other issues that made sure the trial doesn't run, that kept on disrupting this trial, other than sickness, counsel, and yourself. You were always available, but I was tracking this matter and I issued a directive that it run until it finishes.
Yes, JP.
But I think what I want you to tell the commission are the countless applications for any conceivable issue that you had to deal with as the trial judge in that matter.
On a lighter note, I always say when I cough, there will be an application. When I sneeze, there will be an application. For every little bit of thing that happened, there were applications. I believe in this matter, there were more than 20 applications, all in all.
And when you deal with them, you stop the trial and look at the application.
Yes, there were.
And then you wrote judgments about all
Yes.
those applications.
Yes, that's exactly what was happening.
As a matter of fact, there's one application that was launched a few days ago trying to interdict you from sitting there.
Yes, I was informed that I was not supposed to be privileged and sit in front of you.
Yeah.
Because of that, but unfortunately they were unsuccessful as well.
Yeah. Were you in court when this matter was heard, or do you know what the judge said about that matter?
I only read in the media like everyone else. I have not seen the actual judgment. But what I know is that there was a scathing attack from the DJP who had the matter, because this matter was not even necessary to be brought before court, and he was even not very happy with the council who took instructions to bring the matter that is definitely not supposed to be there.
Right. My last question, in a sense, this matter it took so long, but you couldn't take any other allocation because you would be available to deal with this matter. So you had to focus on it and finish it. Am I correct?
Exactly, JP. The only time that I took some other work is last year, second term, when most of the council, because initially there were 7 council in the matter.
Yes.
And there was a complaint that they don't have an opportunity to do some of their other work and their practice were collapsing. So I accepted the work to go and do civil for the second term last year in order to accommodate them. But other than that, I've always been sitting.
Right.
And one other last thing is that there were 2 accused who were self-representing, and they were both in custody. And they brought application after application regarding the manner in which we sit, and then they are taken back to the correctional facility. And when the protocols of them being checked in are complete, it will be well over 12 midnight. And they indicated that that hampers their preparations because they need to prepare for the next day and also to be able to focus during the trial. And then there was a conscious decision that was made. We agreed with all the parties. We started at 8:30 in the morning, and at 1 o'clock, just after 1, before 2 o'clock, we'll adjourn for a day. That also contributed. Thank you, Chief.
Yeah. Just as a matter of record, your conviction and sentence of these accused has been the subject of leave to appeal to the Supreme Court of Appeal and to the CC. Am I correct?
Yes, JP.
And with what result?
They were unsuccessful, JP.
They were unsuccessful.
Yes. Even in all the applications that were brought during the trial, they were unsuccessful.
There were applications for leave to appeal on any ruling that you made.
Exactly, JP.
Thank you very much. Thank you, CJ. I've got no further questions.
Thank you, JP. Premier?
Thank you so much, CJ. I'm covered. Thank you.
Judge President Tlalitsi?
Thank you, Chief Justice. Mr. Makamu, here am I.
I'm trying to look
straight.
This room is very big.
Look straight.
Now I can see you. Thank you. Thank you, JP.
Thank you. There's no doubt that you've got extensive experience at all levels of the judiciary, from the magistrates court, regional court, and in all these courts you've played a leadership role, and also on the organized bodies of these levels of the judiciary. especially the Joasa and Masa.
Aramsa, yes. Thank you, JP.
And,
Yes,
and,
it's
and, and
true.
I can say you have seen it all.
Yes, JP.
Just from an objective point of view, I would want to get your opinion on something, and which is always being said, that there is no distinction between the work of a judge and that of a magistrate. For now, put aside the remunerative part of it, but let's look at the gist of the work, because the public have been told that there's absolutely no difference, only that the others are doing reviews and appeals. Given your experience having acted and operated at all levels, what will your view, or what would you want to share with the Commission?
JP, for one person who have never experienced the other level, will come with any kind of allegations without knowing the real situation. Yes, they say the High Court judges, they don't have much work. They are just driving around and having holidays without knowing exactly the extent of work. Definitely, there's a huge difference between a lower court and the High Court. The district court is much, much lesser. They've got a huge volume of work, which they dispose very quickly. The regional court is a little bit harder because, in essence, each and every judgment you have to write. But the quality of that work is nowhere closer to the quality that is expected in the High Court. So the research and the quality of work that you put behind that particular judgment is much higher in the High Court. So it's not exactly the same. It's not true, it's misplaced, that particular fact. Thank you, Jay.
Yes, as the heads of court and from our judicial accountability reports, we've noticed that there's a serious backlog, particularly with regard to criminal work. Given your experience and expertise in criminal work, if for the remainder of your life, I'm just making it a hypothetical example, you were to dedicate it to deal with these backlogs in the High Court criminal bench, would you be able to dent it and put much effort?
I will not have any problem at all, and the progress will be very significant and it will be there to be seen by all. I will definitely make a huge dent in that particular aspect. Because one other thing that causes the delays is the knowledge and experience of knowing how to deal with situations. And when you have control of your court, you are going to make sure that things goes very smoothly. And that will be done. And I have no doubt. I will give one very simple example. When I was in the High Court, not so long ago, where you start a criminal trial, and some counsel, they will still come with the old-fashioned thing to say, we plead not guilty, we reserve our right to remain silent, and don't want to say anything. And it's a murder case. Or they say, we dispute everything. Then the next question I will ask is, do you dispute that Semakamu was killed? He's the one who died. No, we don't dispute. Do you dispute that he had bullet wounds on his chest? We don't dispute. Then I will say to them to guide them, you must make some necessary admissions so that we may not waste time to prove that that person who died was Semakamu, and that very body had some wounds or gunshot wounds in his chest. So that in itself is one step towards trying to make sure that criminal trials are dealt with speedily. Thank you, JP.
Thank you, Mr. Makamu. Thank you, Chief Justice.
Commissioner Godsell?
Good afternoon, Mr. Makamu.
Good afternoon, Commissioner.
You are the Deputy Commissioner of the Magistrates Commission.
Yes, I'm the
Is that
Deputy
correct?
Chairperson of the Magistrates Commission, yes.
Okay. Now, in dealing with the sanction in the Hingsa matter, Mr. Hingsa was the Chief Magistrate of Bloemfontein.
Yes.
Late last year, the Commission was on the point of not removing Mr. Hingsa from office for gross misconduct. And it is said that it was done because of a view by half of the commissioners that they didn't agree with a finding on the merits by the tribunal. These charges also included sexual misconduct. Were you part of the body when it took that decision?
I was definitely part of the body.
You were. And
Yes, and I may even enlighten you in the fact that the first thing that caused a huge debate was that this matter, the allegations of rape, were reported to the local police station, and the local DPP declined to prosecute. And they escalated it to the National Director of Public Prosecutions, and they declined to prosecute. Then we, then we decided through the ethics committee to charge him with that misconduct. But then there was still a little bit of a debate that are we better investigators and prosecutors than the NPA? Are we not undermining the authority of NPA, that's a Chapter 9 institution? So that was the debate in the beginning. Then when it came to the actual hearing as well, there were few things that were questioned by the commissioners that they were not happy with in the conduct of that particular inquiry. But then at the end of the day, we sat down and we even sourced a legal opinion. And we realized that even on the part of the accused person, there were some shortcomings during the trial. For instance, he did not even testify. He closed his case without testifying. Then, without even testifying, that really leaves him with a huge task. And as a result, after that particular revelation, we unanimously decided to go with the tribunal's decision.
But can you explain to me, and that was the second part of my question, what authority the Commission has to interfere with the decision of its own tribunal? It does have the power to interfere with sanction, but does it have the power to interfere with a finding?
That's exactly what was discovered when the legal opinion was sourced. And then the whole commission relented on challenging the findings of the tribunal.
So what was the finding of the opinion, in the opinion?
Was that the Minister's Commission cannot interfere with the decision of the tribunal.
Okay, and so you confirm that you were part of the commission?
Yes,
who then
I was.
Interfered with that decision and then referred it to the minister?
Yeah, the only thing that I will not try to say now is whether I was for or against. But the fact of the matter, I was part of that commission that came to that particular decision. And at the end of the day, a recommendation was made to the minister, yes.
Because the charges were gross misconduct and they included serious allegations of sexual misconduct.
Actually, the main charges were two rape counts on one victim on different occasions. But I think the commission now is more enlightened to that, including myself, and we know exactly where we stand. Thank you.
Thank you, Chief.
Commissioner Nkaito.
Thank you, Chief Justice. Mr. Makamu, I just want to put some of the objections. The Judge President has put some of them to you, but the objections made by, I think, 3 of the accused in the trial that you ran, a lot of them do not have any substance, so we've considered and rejected them. But there is one you should probably explain where they say that you lied in your judgment when you claimed at paragraph 155 that you had already given a comprehensive judgment into the admissibility of certain of the data evidence as to whether it would be real or documentary evidence. And therefore, on that basis, you're not suitable for appointment as a judge.
Correct, Commissioner Mugaitobi. There's nowhere throughout all those multiple applications where I did not give a ruling. And initially, when they brought this particular application that I should regard the data evidence as real evidence or documentary evidence, I gave an extempore judgment, which is there in the recordings. And then at the time when they applied for my recusal from the matter, they tabulated different reasons under different headings. And one of them was that I did not rule as to whether the data evidence was real evidence or was documentary evidence. And in my judgment for recusal, I then pointed out that I have already made a decision that it was real evidence. The only thing is that it was not a 20-page reasons on that particular aspect. And the reason for that is that when you are still going to give your judgment, if you expand a lot more, you sort of trying to give away what you think the case is heading to. So I did write that judgment, and the judgment is there. Then they also applied that I should revisit my decisions. Most unfortunately, I gave an extempore judgment, which was delivered. I can't remember whether it was the 21st of October. Unfortunately, the machine malfunctioned on that particular aspect. And even my extempore judgments, they are not extempore directly from my head. I drafted those particular judgments. And I don't know what actually happened that day, because even my laptop crashed that particular time when the recording machine also malfunctioned. But the fact of the matter is, I even wrote on my bench book the order that I made on that particular day. So there was no way in which I never pronounced my decision regarding the admission of the data evidence. It is not correct what they said. It's an insult to everyone else who was there. And to try and cap it, to try and put a little bit more on it, there were 7 counsel in that particular matter. They are not just people who come from the street who don't know what they are doing. There's no one counsel who complained about that particular aspect. One of the accused, he now employed another firm of attorneys who were not part of the proceedings from the onset. But those who were available, who were part of that particular trial, they know exactly that that is not true.
Yes.
I hope I answered you.
Yes, partly. The question whether you gave a judgment or not, I think it's clear. You've given us the actual transcript on the day you gave the judgment. It's about a page. Then they go further and say, you also misled us when you said that you had given a final judgment. Your judgment was supposed to be revisited in the overall order. But when they asked you to revisit it, you refused. And you said that you had already made a final judgment, but you never made a final judgment. How do you answer that?
That is not correct, because they brought an application for my recusal after that, where I confirmed that I made that particular decision. They brought an application for me to revisit my previous rulings, and I repeated it. So it is not correct that I never made a decision.
No, whether it was final or provisional, that's really the substance of it.
Maybe.
Because I read the actual transcript you gave of the judgment.
May I have
It
some
says,
water? Yes.
yes, sorry, you want to have some water, yeah.
You may continue, Commissioner.
Yes,
Thank
so
you.
the actual transcript says, in the interim, in the meantime, it uses both of those words.
That was the initial ruling on extempore.
Yes.
When they brought the application at that particular time. But when you look at the following judgments that I wrote and the ones that I did extempore, it was emphatically stated that I regarded data evidence as a real evidence and not as documentary evidence. Maybe I should give you a little bit of meat to that.
Yes, please.
It was the data which was extracted from their electronic devices. And the Digital Forensic Laboratory, they did not just make copies of the contents, but they took pictures in the form of mirror images of those particular messages, that particular data. So that data was, some of it was even deleted. In fact, most of it was deleted. But through the forensic tool that was used, they managed to go deep and get it, that it was there and it was deleted on this particular day, on this particular time. So the accused persons, they wanted me to rule that it was documentary evidence. Because if it's documentary evidence, you have to call the author to come and confirm that this is me who wrote this particular aspect or this particular data. But then they were accused persons, and the information or the data that was being dealt with, it was something that they did or they wrote during the commission of the offense. So there was no way in which they would come and assist the state and say that we are testifying, I'm the one who
No,
wrote
I
this.
don't think there's a question about whether it was correct or not. It's really whether its status was final at the time you gave. Because my understanding of the explanation you've given in response is that you admit that you used the words in the interim or in the meantime, and you say that it should not have read in the interim because at the time you gave it, you intended it to be final.
That's very, very correct.
Yes.
But I must point out something, that during the trial, when you are listening to evidence all the time, that kind of the decision that you take or you took earlier, it might change due to the evidence that followed at the end of the day. So that's why there's a need to revisit that particular decision that you made earlier on, in case there is evidence that came later to contradict what was given there. So it's very clear that the decision was made. It was an unfortunate to have used the word in the meantime at that particular time. But if at the end of the trial, I had had different evidence that showed that that evidence was not supposed to be admitted as real evidence, I could have easily said so. So it remained real evidence through and through.
Yes. So, all right, I'm trying to make sure that I get the explanation. You're saying it's true when I gave the ruling, I said in the interim, in the meantime. But what I had in mind was that it would be a final ruling, not subject to revisitation. Because in the final judgment, you say I'm not revisiting it because I've already made a judgment on it.
Exactly. The use of the words in the meantime, it was unfortunate in that English is not my first language. Because they said this will be proven that it was not their data. Then I said, in the meantime, as we have what I have in front of me, is real evidence.
Yes, so it was just an error.
It was just an error of the language there to use the word in the meantime.
Thank you.
But it was decided, I decided at that particular time that
No,
it's
Mr.
a real
Makamu,
evidence.
you know, I was cautioning another candidate yesterday that once they've got the answer, there's a tendency to expand, and then the more you expand, the more you defeat the answer. So
Thank
I
you
think
so much.
let's leave it here. Thank you.
Thank you. Thank you so much for the advice.
Do we have questions from the virtual platform?
Yes,
Chief Justice, I'll wait.
Or Commissioner?
Good afternoon, Mr.
Not from my side, CJ, thanks.
Thank you, Commissioner Mtweni. Go ahead, Commissioner Marumachai.
Thank you very much, CJ. Mr. Makamo, I think you, in your interaction with the JP of the division, it is quite clear that criminal matters where there are multiple accused persons, they take long, particularly where frivolous applications are being brought to disturb the process. I just want to find out, given your experience in the regional court, what strategies can be used to ensure that to some extent, these kinds of practices are dealt with, and trials where there are more accused persons can actually flow without any disturbance. Yes, I take it that parties have a right to bring applications, but what can be done from the judiciary to curb some of these frivolous applications? Thank you, CJ.
Thank you, Commissioner. Thank you, Chief Justice. There's no magic wand for it. The only thing is that as a judicial officer, you must stamp your authority and not tolerate some of the things that they may be coming up with to try and sabotage the smooth progress in that particular matter. Uh, but then it depends on your experience as well. If you have dealt with these matters like I have done so many years, it's easy for me to see where they are heading to and what I will say to make sure that we continue and avoid unnecessary delays. Because even in this matter, there were delays in the beginning, but at a later stage, I stamped it out. Thank you.
Thank you, CJ.
Commissioner Breitenbach, did you say you have questions?
Chief Justice, a follow-up on the question of Mr. Gauteng. Good afternoon, sir.
Good afternoon, Commissioner.
In your reply to Commissioner Gotzel's question, I thought you said, but I may have misheard you. I thought you said the National Prosecuting Authority is a Chapter 9 institution. Did you say that?
No, I just wanted to say that it's an independent institution.
Okay, thank you. Thank you, Chief Justice.
Thank you, Commissioner Breitenbach. We've reached the end of your interview, Mr. Makamo. Unless there's anything you wish to raise with us.
The only issue that I would like to raise is to thank you for giving me an opportunity once again, to such an extent that you even remember that I was with you 2 years ago. So thank you for the opportunity. Thank you to all the commissioners.
Thank you. You're excused.
Thank you.
So we take lunch now. For how long? Half an hour. Come back at 25 to 3. 25 to 3. We come back.
And then
We clear that thing at the beginning.
Okay.
I'll clear it. Okay.
Good afternoon, Judge Mushwana.
afternoon, CJ.
How are you this afternoon?
I'm fine, but a bit exhausted. I just came off 4 appeals in the past 2 days, but it's fine.
You'll survive.
Yeah, I'm sure I will.
Yeah. You have a string of academic qualifications. I remember interviewing you before, and I just get tired looking at the list. BProc, LLB, higher diploma in labor law, a master's, a diploma in corporate law from various educational institutions, tertiary institutions in this country. What did you do before you became a judge of the labor court in 2017 in the legal sphere, briefly?
Yes. Before I got elevated as a judge, I practiced as an attorney for a period of about 22 years, if I'm not mistaken.
And you had run a practice on your own account?
Yes, I did in partnership in some instances.
Yeah. What kind of work did your practice deal with?
I would say we were general practitioners. We did almost everything that we could or is thrown on us, as particularly before the or just after the I started that firm around 95, so it was shortly after the new country. So the type of work you would do as a middle sort of law firm, it will range from your civil road accident fund, contract, and so on. But I specifically in the firm chose to specialize in labor law.
And then you developed a special interest in labor law?
Yes.
When were you appointed in that court?
That would be the 31st of May 2017.
17.
Yes.
And how have you found the experience
of being a judge.
of being a judge in that court?
Yeah, no, it's a daunting experience in a sense that, particularly the labor court in Johannesburg, it's a hectic court. But
Can imagine.
here I am 7 years later. It seems I coped.
Well, I dare say you have more than coped. You seem to be thriving, if anything.
Oh,
Here
yes.
you are co-authoring books, and how did you do that?
Okay. Yeah, co-authoring the book. It's an interesting story, but I don't want to bore the commissioners about the details. But one of the professors at the University of Namibia was apparently following some of my judgments. And he then made contact with me and said, I've read a number of your judgments. I want us to meet and share some ideas. And that would be around 2020, thereabout. Then we communicated telephonically and in some instances on WhatsApp. And then we agreed that let's put something which is a book related to the court in Namibia and the labor court in South Africa. That's how it came about, CJ.
Right. No, congratulations. That's a commendable achievement. I envy you, if anything.
Thank you, CJ.
We skipped some important steps. You served for 4 years as a CCMA commissioner.
Yes.
Before you, and you had served as an acting judge in the labor court since intermediately since 2007.
Yeah, since 2007.
Yeah.
I had acted in the labor court.
And you acted in the High Court as well.
Yes, and I'm currently acting at the High Court.
Since when?
Since the beginning of this year.
All right.
I think
So
the
that's
first time. Yeah.
So you have 3 terms in 2024.
Yes.
And
so
before
far.
that?
Before that, I acted in 2022. I think it was for a term, the 4th term.
Right. How have you found the switch to the High Court, where you do more generalist work?
Look, I don't think there was much difference, and I'll tell you why I'm saying that. In the labor court, in as much as you will deal with employment matters, you will on occasion deal with contract. On occasion, you will deal with your administrative law, and in some instances, a bit of contempt proceedings as a touch of criminal law and all that. So when I transitioned into a high court, I didn't find any difficulty, I must say, other than the fact that I'm no longer dealing with Sidumo all the time. I will be dealing with something different.
Yeah.
But nevertheless, motion is motion. Yes.
So I see that you've sat in the whole range of courts, doing civil and criminal work, full court, appeals, petitions, motions.
Yes.
The works.
Indeed. Yes.
You've written judgments.
Yes.
How many? For both both in the labor court and in the High Court?
Yeah. The last time I was here, it was you, CJ, who told me that the GCBU they were counting about 300 judgments, and
that
now
was why so that you've accumulated on that list?
Yeah, so I was given a list that has at least 40 judgments so far. So if you add that, you would be looking at about 340 if 300 was anything to work with.
All right, you're such a prolific writer. You've published other other materials. You have articles in the area of labor law, of course. Where do you find the time to write all these things?
Yeah, I think this question also arose on the last occasion. You know, I perhaps I like reading, and as I read, I want to write something. So I'll spend sometimes a lot of time in my study writing something.
Okay, Judge Mlam, Judge President Mlam, do you have questions for this?
Thank you very much,
Candidate.
Chief Justice. Thank you. Judge Mshwana, the CJ took you through your work in the High Court. Just to confirm this, my spreadsheet suggests you've done 38 weeks since you started acting in the High Court.
Yes, that appears to be correct.
But what comes out very clearly is you've dealt with 4 special motions. That would be special motions each time you've acted, as well as 4 agent courts. Roles.
Yes.
That's
Indeed.
quite heavy.
Yeah, well, coming from you, JP, is very rich to say it is heavy.
So you blame me for allocating your work to you.
Who else?
Okay. And you've done 1 week of opposed motions.
Yeah, I see it's 1 week, but my recollection is it could be more than that.
It should be more, because I think there are occasions where we would pull you from one role and put you there.
Yes,
We
I
didn't
remember
capture that.
specifically in May.
Yeah. We put you in an opposed motion in May.
In May
in
when,
Joburg.
in Johannesburg.
Yeah.
Yeah, I dealt with opposed motion.
So let's say 2 there. But the point I'm trying to make is, as a rule, if you've got a special motion week in 1 term, we would give you 1 opposed motion week. If not, we give you 1 agent court week. Because if we add those types of week, then we're killing you. You understand that?
Yes.
Yeah. So, but those are complicated work areas. But to you as a judge already, a 7-year-old judge, there was nothing new in terms of the intensity, because the labor court in Joburg is also busy.
True, I agree.
Right. And then in terms of judgments, I've given you a list of 40, but the only question I want to ask you about those judgments is, how long did it take you to write some of those judgments? Did you take more than 3 months, or what?
Well, I can just look at one here, the Ramudzuli versus Commissioner for SARS.
Yeah.
I had that matter on the 28th of February, 2024, and the judgment was written on the 26th of March. So
that's 3 months.
No, less than a month.
Yeah.
Yes.
Well, that's within the 3-month period.
Yes, within the 3 months period, sorry.
That's my assessment, having just browsed through all these judgments, that it took you less than 3 months. But can you confirm that for record purposes?
No, I can confirm that.
Right. So you've never had a problem writing judgments?
No, I never had a problem.
So you're one of those who's never received my love letter saying, where are the judgments?
Not at all. I am in the good books insofar as that is concerned.
Okay. Just stepping off that, Judge Mshwana, I think the only reason you are here, I want to think today, is because of the issue relating to your practice last year.
Yes.
Right. And can you tell the commission what the situation is? Do you still have shares in that firm? Do you have a financial interest in that firm? Are you still involved in the firm you had founded? I think just assure us the commission here, because JP Wegley has also written here.
Yes.
But that's why we are here today. Can you tell us what's the situation?
Okay, thank you very much, JP. Obviously, I did not know on the last occasion what could have caused my not being recommended, but I suspect that that was the issue. So I'm just going to make 2 points because I had read the transcript of the last occasion, and the 2 points I want to make is, and the first one very emphatically, I have no interest and I have no financial interest in that practice. It's been 7 years that I have been out of practice, so there is no interest at all, if that was the concern. And secondly, you do mention that my JP had written, I don't know what he had written to the JSC, but I did express the same sentiments to him that I have not, and I will make it clear if I am called again, that no financial interest at all. The practice as we speak, I think I left about 2 partners or 3 partners. They changed the different partners now. Yes, I think that's what I can tell at this point in time. I don't know whether that answers your question.
No, it does. Thank you very much, Ashmshwana. Thank you, CJ.
Thank you, JP. Premier?
Just 2 questions, maybe to follow up on this, what JP have just asked. In the last time when we were here, the matter that JP has just raised was really a serious matter, where it was not explicit that your involvement in that practice cannot be traced back and cannot be confirmed that you are no longer part. I'm glad now you're emphasizing that indeed explicitly that you are no longer part. Did you take any additional steps or decisions immediately after your last appearance about this matter, or it remained as it was? Maybe it was a misunderstanding from our side.
Yeah, look, it remained as it was, and as I say, I don't want to rehash the debate we had, but the issue was centered around what is being owed, and that was it. And I think there was a confusion, thinking that what is being owed is amounting to some financial interest. So the situation is as is, or as it was rather.
The last question, Chief Justice, is from my selfish interest. Why this floor crossing from Methodist Church to Baptist Church?
Premier, you call it floor crossing, and of course it's a language that belongs to another area. But for me, I want to serve the judiciary to the best of my ability. And if I remain in the labor court, I might not have an opportunity to serve the judiciary to the best of my ability. I would have been confined, I said when I started, to the Sidumo situation. But at the High Court, I'm exposed to many other areas of the law. And I feel that my skills, if at all I have skills, are better placed at the place like the High Court.
Commissioner Trolley?
Just a
Oh,
follow-up
sorry,
question.
sorry.
I didn't get the candidate answering the question. The question had nothing to do with Labour and High Court. It had to do with different churches.
Oh, okay. No, maybe I misunderstood. Yes, no. Please repeat the question.
I'm saying
The churches.
You are a staunch member of the Methodists. You
Yes.
just moved to the Baptist church. I'm trying to
Oh.
understand.
No,
And I'm just saying it had nothing to do with this. Just my
Oh, yes.
selfish interest.
Well,
And why is open Baptist? Is there closed Baptist?
no. Some years back, I used to live in Midrand. So the church I would attend there was the Methodist church. Now, then I moved to Hartbeespoort. So I couldn't find a Methodist church close by, and the Open Baptist was the closest church to the Methodist church. Sorry, I didn't understand the question earlier. Yes.
Deputy, I'm sorry, I didn't realize that you are acting as the president. Acting president, Zondi. I'm sorry. Okay.
Sorry. Hi, good afternoon. Sorry,
Yeah.
I just want to refer you to page 9
of
paginated
okay.
bundle. That's your questionnaire. Paragraph 16.3 and paragraph 16.4.
16 point. Yes.
Now, the questionnaire asks you to list cases in which you gave judgment that were unsuccessfully appealed against, and the 16.4 question asks you to list cases in which you gave judgment that were successfully appealed against. Now, but you said refer to 2023 questionnaire. But now, unfortunately, some of us were not here in 2023, and I'm not sure if even those that were here are still keeping the 2023 questionnaire.
Yeah. No, thank you very much. Yes, I referred to that because at that time, and this was my thinking, it was too soon after the 2023 interviews, and not much had changed. But I picked up from the GCB that they did pick up those judgments, because for me it would have just been a repetition of what I had said at the time, because there was nothing new that was taken on appeal or overturned on appeal. So that's why I chose that route.
Okay. Thank you.
Thank you, AP. Any questions, colleagues? Commissioner Gauteng?
Yes. Judge Mshwana, I just want to put some of the objections that have been made against you. This one is not an objection, but it's a comment flowing from what the JP put to you. You said you didn't know what Judge President Wegley said. Is that correct?
The JP, Commissioner Ngugaitobi, mentioned a letter. So I'm not, that's why I'm saying I don't know what the JP Wegley said.
All right. Yes,
So
that's what
I
I
was
wanted
referring
to
to
assist.
that.
Yeah, no, that's what I want to assist you with.
Yes.
We had resolved at the JSC that he would follow it up with you to clarify the issue of your apparent ongoing financial interest in your former law firm.
Yes.
And then he wrote to us in October last year, in which he said that you were either on long leave or busy with your doctorate. But basically, the gist of it was that he felt it was inopportune to invite you to chambers. And then he gave up and said, let the JSC deal with it directly with you. So the impression one gains from it is that there was some sort of lack of communication between you and him. Is it fair to say that you did not cooperate with him, or do you think that's unfair?
Yeah, it will be unfair. Why I say so? Shortly after the interview, JP Wegley, me and him, we come a long way. And he called me and told me about this meeting that you're mentioning. And he said that, can you write something for me to explain the position so that I can pass it over to the JSC? And my recollection is that I did write him an email in response to the issue that he say was raised with the JSC in his presence and in my absence.
You should have that email, I suppose.
I beg your pardon?
You should have that email you sent to him, I suppose.
Well, if I go to my records, I seem to recall that would have shared it with the JP Mlambo as well, but it's been a long time since.
Yes. No, the
that
only
email.
concern is not the financial issue, but it's your failure to cooperate with the JP, who's been mandated by the JSC to engage with you.
That's why I said to you it will be an unfair statement, because I did, and that's why I emphasize that me and JP Wegley worked well together. We've known each other for many years, so he had informed me, and I wrote an email, which I didn't know that this issue would arise. Had I known, I would have brought the email with me.
Yes. The next one is an objection by a Mr. Zulu, who seems to have been a litigant in front of you in respect of a matter that you gave a judgment on the 1st of June 2023 without reasons. He wanted to appeal. He asked for the reasons on the 7th of August 2023, and you did not give him the reasons. Instead, what you did, you asked him to look for the transcript. What do you say to that?
Yeah, I think, Commissioner, that issue, as far as I can recall, has been before the conduct committee of the JSC, and
Yes,
they
but
have
there's an appeal.
they have reached a ruling, and there's an appeal process. But in short, I gave an extempore judgment, and when the litigant wanted reasons, and I recall my secretary wrote a letter to the litigant and referred to a provision in the practice manual that when there are extempore judgments and you want the reasons, you have the responsibility to transcribe those reasons.
Who has the responsibility?
According to the practice manual,
it's the litigant.
The litigant, yes.
So your point is you acknowledge everything, but it was up to the litigant to get the transcript.
Yes. Now, I think 2 points I'm making. One is that it has been raised with the Judicial Conduct Committee, and I gave the same explanation, and they ruled that there was nothing untoward. And I understand now, last week or so, I was told that there is an appeal by the litigant against the ruling.
No, I mean, this is not a misconduct inquiry. It's an assessment of your fitness for appointment. So this question is relevant despite the JCC ruling.
All right.
Yes. So, but what is your answer? Your answer is that you told them that they can get the reasons from the registrar's office.
Yes, that's what the practice manual of the labor court says.
Yes. Then there is a third one, which is from Mr. Makatu, who says that you failed to disclose a conflict of interest in a matter of South African custodial management versus, is it APSCO, in which you were a judge?
Yes, I recall that one. That very point was raised up to the Constitutional Court, and the Constitutional Court dismissed the application because that was the basis for seeking to appeal my judgment. But nevertheless, the transcript of those proceedings. It's one matter that I had virtually. I stated, and it was on record, and for that reason, the Constitutional Court ended up mulcting those applicants with costs, punitive costs, because it was there in the record.
What was in the record?
The disclosure.
Yes, yes. So you're saying factually it's wrong, you made the disclosure.
Exactly.
Thank you. That will be all, Chief Justice.
Thank you, Commissioner Ngaitwa. Commissioner King?
Thank you, Chief Justice. Good afternoon.
Afternoon, Commissioner.
Good afternoon to you. I want to take up something that Acting President Zondi raised with you, and it pertains to the references to the judgments in your previous application. Your answer was that you gathered that the GCB had managed to access them. May I refer you to paragraph 7.1 of that GCB review, and just I could just let you know what they say. They say they didn't have access to...
What page?
It's at page 2 of the GCB review, paragraph 7.1.
On the paginated documents that I have, if I may be directed to the page.
I'm afraid I'm working off an electronic database.
Oh, okay.
I wonder, have you got the GCB review perhaps?
Not in front of me.
I think you're being assisted, so we'll just...
Yeah, no, let's
we'll
wait
just,
for it.
wait a moment.
Yes. What paragraph?
Thank you. Paragraph 7.1.
Yes.
You'll see that they say that you referred to your previous application to which the current reviewing team does not have access. However, the following appears from the review of that previous application. So in other words, the GCB looked at the last time it reviewed you and uplifted some comments from its previous review, but they too didn't have access to your previous judgments. Had you read this report before you came here?
Which report?
The GCB.
No, indeed I did. That's what I was referring to.
Yes.
What they ended up doing was to review the very cases that were disclosed on the previous application. That's why I was referring to.
Oh, I see. Thank you for that clarification. Now, on the real-time investment decision, you were criticized because you awarded relief which hadn't been sought by the one party, and so the other party had not even been given notice of that relief. Could you just give us your impression of whether that's a fair criticism and what you would do about such a situation at this stage?
All right. Thank you very much. Obviously, the LAC considered the matter and took a view that because reinstatement was not specifically asked for, then I, as the Kotako, ought not to have ordered reinstatement. Now, it's debatable in my view, and for the following reasons. There are authorities of the Labour Appeal Court, including the Constitutional Court, that says reinstatement is a primary remedy. And the only time that reinstatement may be excluded as a primary remedy is when the provisions set out in 1932 are present. Now, those authorities go further and say those circumstances would depend on the evidence that the employer would present. Now, in this matter, I had no evidence from the employer, and the finding I reached was that the dismissal was both substantively and procedurally unfair. And the primary remedy, which was available to the litigant, would have been reinstatement. That's why I went for reinstatement. But obviously, the Labour Appeal Court looked at it from a different perspective.
Yes, so in the same situation, you would do the same again.
I would say, look, given this judgment on application of the stare decisis principle, I am bound by this judgment, except if perhaps I happen to sit in another higher court, in which event I would somewhat express the views that I just expressed. But if I were to return to the labor court and be faced with a particular situation, I'm bound by this judgment.
May I ask you also then on the next criticism of Solomon's case, the next
Yes.
paragraph, if I could just ask you a question about that criticism. Maybe the easiest way to deal with this is just to ask you the difference between a dismissal of an application for relief and an application for relief being struck off the roll.
All right. Thank you, Commissioner. Section 138(5) of the Labor Relations Act provides that where the applicant had referred a dispute and that applicant is absent, then the commissioner is entitled or empowered rather to dismiss the referral. Now that's the statutory provision. The CCMA rules repeat the same thing that is stated in the Act. So to a point that where a matter, if it was in the labor court, for instance, or in the high court, where an applicant doesn't appear in court, ordinarily the application would be struck off due to non-appearance. Now, in the Solomon judgment, or perhaps before we get to the Solomon judgment, that is my differentiation. Dismissal is dismissing the action, and striking off is simply, for lack of a better word, removing it from the roll of matters that were to be entertained on that particular day.
Any questions, colleagues?
Oh.
Do we have questions from the virtual platform?
None from my side, CJ.
No, thank you, Chief Justice.
Thank you. Judge Mushwana,
Yes, CJ?
the interview is done.
Is
There are
it
no more
done?
questions for you.
Okay, thank you very much. Thank you,
Thank you
commissioners, for this
applying for
opportunity.
this vacancy. Good afternoon, Professor.
Good afternoon, Madam Chief Justice, and good afternoon to the commissioners.
I'm not even going to ask how you are after the hug. I saw you exchange with Judge President Mlambo. You should be fine.
I'm very well, Madam Chief Justice. Thank you.
Good. You from Matatiele?
That's correct, Madam Chief Justice, in the village of Ramuhlagwan.
Do you still go back?
I always go home, will always be home, Madam Chief Justice.
That's good to hear. You have listed 4 academic qualifications under your belt: a diploma in human rights, an LLB, an LLM, and an LLD.
That's correct, Madam Chief Justice.
Where did you obtain these qualifications?
The diploma in human rights, CJ, I obtained it from now the Northwest University, Mafikeng. Then it was the University of the North.
Yeah.
Then the LLB, I also obtained it from the same institution. I obtained my master's in international human rights law from the University of Notre Dame in the United States. And my PhD, I obtained it from UNISA.
All right. You have a very interesting CV. Your employment record starts with you being a security officer in
That's
2002.
Correct. That's correct, Madam Chief Justice.
How long were you, did you do this job? No, not for long.
I did the job for about 6 months before I found out about the Northwest University. I was in Rustenburg there.
Then you ended up doing articles
at the Legal Resources Center in Durban.
in Durban.
That's correct.
And you clerked at the Constitutional Court at some stage.
That's correct, Madam Chief Justice, between 2009 and 10.
For Justice Yacob.
That's correct, and we are still in contact.
How did you find that experience?
It was a stimulating experience, Chief Justice, and I think I grew significantly, especially in terms of dealing with legal issues. And I think to a certain extent, that experience happened to carry me through my acting stints, but it was a worthwhile experience.
So you decided to carve your career path in the academic world?
Madam Chief Justice, it was not by choice. I struggled with a module called bookkeeping. So I realized at the same time I was good in academia. So to me, given some other family responsibilities, I couldn't afford to pursue or rather persevere as a candidate attorney and try to pass the boards. Life had to go on, and I ventured into academia.
So you've built your way from assistant lecturer in January 2004 to professor and director in 2024.
That's correct, Madam Chief Justice, although it took me longer than necessary.
But you took 20 years. But that's not too long. You are a professor of law at the University of Fort Hare.
That's correct, Madam Chief Justice.
And your directorship is in the
UNESCO Oliver Tambo Chair of Human Rights.
Yeah. You are also a non-judge member of the Electoral Court.
That's correct, Madam Chief Justice.
I remember that you were part of a panel in a judgment that occupied our minds not so long ago from the Electoral Court.
Indeed,
in
Chief
the
Justice.
vexed matter of the Electoral Commission versus Mkhondo Party.
That's correct, Chief Justice.
I won't go into the merits of that judgment and what finding was made in respect of your majority judgment.
I respect your view, Chief Justice.
All right. So you have acted as a judge in the High Court now.
That's correct, Chief Justice.
For how long and where?
I was particularly based in the Gauteng Division, Pretoria. I started acting in 2022. I think I did 2 terms. Sorry, it might confuse me in terms of the actual dates, Madam Chief Justice. But to be
Judge President
precise,
Lambo will take us through that. That's his forte. But
that's
my calculations are that you have totaled up about 43
44 weeks.
44 weeks.
Yes, Chief Justice.
And in which courts did you sit? What cases were you adjudicating?
Chief Justice, I sat in motion court, opposed motions, unopposed. I did civil appeals. I did criminal law appeals. I did special trials.
What are special trials?
Those are the ones, Chief CJ, maybe you are located, it will run for a duration of 5 days or 3 days, depending on the dates that have been assigned to that particular matter.
So did you conduct any trials at all, civil or criminal?
I have conducted civil trials, Chief Justice.
Not criminal?
Not criminal, only criminal appeals. Full bench, yes, Madam Chief Justice. And I've written judgments in that regard.
You mentioned somewhere in your application form that you were admitted as an advocate.
That's correct, Madam Chief Justice. Under the old dispensation. But when the new dispensation came into effect, I did not do anything. I left it as is.
You mentioned that you occasionally did criminal work involving bail applications and trials related to excessive speeding.
That's correct, Madam Chief Justice. That was a very brief period post my admission, and it did not last that long. Hence, I used the word occasionally because I would not go every day.
All right. Well, you wouldn't have become a professor if you didn't publish extensively. So we won't deal with your academic publications. I'm more interested in your court judgments. You've had occasion to produce judgments during
That's
your
correct,
acting stints.
Chief Justice.
How many would you say you have produced?
I've produced 46 judgments, Chief Justice.
Have any of those been reported?
Yes, Chief Justice, I have 2 reported judgments, and one of those judgments was confirmed by the Supreme Court of Appeal. One of the judgments was overturned.
Well, I'm going to leave it to the representatives of the General Council of the Bar to raise the GCB's concerns with the quality of your judgments. They have a lot to say about that. Are you convinced that you're ready for permanent appointment as a judge? You're ready to become a judge?
That is the reason I'm here, Madam Chief Justice. I am ready.
And what would you say to anyone who says you are not ready and might perhaps benefit for more acting experience, as some of the professional bodies have said?
Madam Chief Justice, let me first acknowledge the constructive criticism that comes from the General Counsel of the Bar. The answer, Chief Justice, would be that out of all these 3 reports, or rather comments, there is a general trend. That trend is that I produce well-reasoned judgments. I produce judgments timeously. I'm able to conduct the court efficiently and that I am independent. The only concerns, Madam Chief Justice, are related. In particular, this comment comes from the General Counsel of the Bar. It's in relation to my orders. And they rely at least, I think, on 2 judgments. Madam Justice, when J.P. Mlambo identified me as a raw diamond from the village of Matatiele, he threw me in the High Court in the deep end. The basis for that process was that I undergo through a rigorous process so that I can be familiar with the art of writing judgment. Try to convert my academic writing into well-reasoned and sound judgments, which I have mastered. There is always an area for improvement. Having gone through that process of drilling, here is the shining diamond in front of you, Madam Chief Justice. The judgments that I have presented before this commission, it shows significant improvement on how I craft my orders. To that effect, there is none of the concern raised with the judgments that I have submitted, especially insofar as it relates to orders. Madam Justice, I believe that this commission, respectfully so, should adopt a holistic approach. I bring in a triangular experience. That is my academic background, my acting stints, and my experience as a non-judge member of the Electoral Court. I believe that the entire experience has sufficiently prepared me to undertake and discharge duties as a judge of the High Court. Those are my submissions, Madam Chief Justice.
You were a legal editor with the public protector for a spell.
Yes, Madam Chief Justice, there initially when we were appointed, our duty was sort of editorial. But as time commenced, we were actually involved in the drafting of the reports. And in this regard, one of the reports that comes into my mind is the report titled Secure in Comfort. I produced the draft of that report, then you would send them to the Office of the Public Protector. I was then reporting under Professor Tulima Donsela. Then they would finalize the reports. So even in that capacity, I produce some of the reports. Madam Chief Justice, I hasten to mention that the reports that I worked on whilst at the Public Protector, none of them were taken on review successfully.
Right. All right. I'll hand you over to J.P. Mlambo.
Thank you, CJ.
Good afternoon, Prof.
Good afternoon, JP Mlambo.
Are you good?
I'm very good, JP. Thank you, and yourself?
I'm fine. I just want to confirm that I identified your CV. You had not applied to Gauteng. Some years ago, before I invited you, I think you had applied for a post in the Eastern Cape, if I'm not mistaken. Correct me.
It was the Land Claims Court.
Yeah, the Land Claims Court. So I saw your CV and I said, no, I must invite this person to come and act in Gauteng. You remember the discussion we had?
I remember them very well.
And that's how our relationship started.
Thank you, JP.
Now, You've acted in the High Court, mostly in Pretoria, but I'm sure you did some work in Joburg, or was it mostly in Pretoria?
Only in Joburg under the Electoral Court, JP, not
Yeah,
in Joburg.
not in the High Court, but the High Court in Pretoria.
Yes, yes, JP.
Yeah. And the report you have in front of you shows the work areas you've acted in. You've confirmed you haven't done any work in criminal trials, but you've sat in criminal appeals, both full benches and full court appeals. Am I correct?
That's correct, JP.
And you've
Sorry.
written some of them.
Yes, sorry, JP, if I may identify something. I
Yes.
think there was a confusion with the spreadsheet, JP. In 2024, I also sat in an agent court. I think it was from 12 until 15 up until 19 January.
Yes. In fact, I was coming to that. The spreadsheet lists something like 4 weeks in one term, which is an impossibility. We can't put a judge to do 4 weeks of agent court in one term. Never.
I get it, JP.
So my office has just confirmed that you actually did 2 weeks of agent court throughout your acting stints. You confirm that?
Yes, JP.
The one you mentioned and another one in last year, I think second term last year.
Yes, JP.
Yeah, so that's 2 weeks in agent court.
Thank you, JP.
And you've done 3 weeks of opposed motions, is that correct?
That's correct, JP.
And 2 weeks of special motions.
That's correct, JP.
I mentioned these because these are the heavy work areas where judges accumulate reserve judgments. You confirm that?
I confirm that, JP.
Now, how did you find acting in the agent court in particular?
JP, must admit that it is very challenging.
Yeah.
It's challenging in the sense that you get an agent application on top of an agent application. In other words, you need to be always on your toes. I remember at times I conducted some of the agent court matters during the weekend. But overall, it was a worthwhile experience, JP, and I think I have risen to the occasion.
No, you have, no doubt about it. And in the opposed motion weeks, how did you find that? There you get your files 2 weeks before, you hear them, even though you have other work, but you have the files so that you start preparing. How did you find those allocations?
JP, that was also good, but at times, in fact, my first acting stint there was that I felt that I was thrown into the deep end. I thought that you had mistaken me perhaps with someone who's from practice.
Yes.
But with the preparation and using some of my notes that I obtained from former colleagues, to this instant, I think Judge Stuart Wilson, whom I worked with at Seri,
yes,
he had prepared me a sort of a starter pack. So I was able to survive JP, but also got the shock when I realized that I had almost 10 reserved judgments when I left. But with the preparation of counsels, then the work also becomes a little bit busy, but at times demands more research, because when you adjourn, both counsels have to a large extent convinced you, and you have now to come to your own conclusion as to which one is more probable and so on.
Yeah.
But it was a good experience, JP. Thank you.
Yeah. I think what is impressive about you, although you had a bit of practice, most academics struggle in the unopposed motion court, those who've never practiced, because that one requires a lot of knowledge of procedural law. But you've a whopping 13 weeks that you did in that court. And that tells me that you had a good handle of the work.
I am humbled, JP.
Now, in terms of your reserve judgments, you've just mentioned them. I did a quick scan. You record that you did a total of some 46 judgments. That's the list I have.
That's correct, JP.
Right. And some of them took you longer than 3 months, I can point them out to you if you want.
I
but
still remember them.
You
in my
remember
hand,
them,
JP.
yeah. I think only one took you 5 months. The others were 4 months, 4 months, 4 months.
That's correct, JP.
Yes, so you didn't have any that went over 6 months.
Yes, JP. And if I may expand on the ones that were slightly above 3 months, JP.
Yes, yes.
Those were matters that you find that are matters that are joined and they are heard together on the same day.
Yes.
Although the aspect of the facts to a large extent are similar, but the relief sought is separate. In other words, it's two applications at once.
Yeah. Yeah. No, there's just one, the one that took you 4 months. That's the Arrojo versus Greche matter.
Those were the matters, JP. It was a review application as well as a recusal application.
Yes.
If I may also mention, JP, the DB matter.
Yes.
That matter, JP, is the matter that involves RAF. Without going much, JP, the challenges faced by the Road Accident Fund need not be elaborated on.
Yeah.
But when that matter was assigned to me, the actuary report was outstanding. And already there were suggestions to request for postponement. But I stood my feet and said that this matter has been allocated for these particular dates, and with or without the actual report, the matter is proceeding. Unfortunately, the actual report was there on the trial day, but we proceeded a JP. At the conclusion of the matter, Council was given specific time frames on which to submit the report. However, Council still failed. It was only when I said, I am delivering my judgment with or without the report because I have given you ample opportunity. Hence, it took longer.
No, thank you for that. I have my own scoring metrics as to how I score candidates. And I want you to comment. You've said in almost all the work areas, except for criminal trials, but you've done criminal appeals. Taking account of the number of weeks you spent in the urgent court week, in the opposed motions and in special motions in particular, and not having acted in criminal trials per se, out of 7, how would you score yourself? It's a subjective thing. I'm just putting it to you to think about, you know?
Yes, JP.
Yeah.
JP, I would go for 5.5.
5.5, okay. Thank you very much. And in terms of, well, reserve judgment, it's a simple one. If you've delivered all your judgments before 3 months, out of 5, I give you the whole 5. But if there are some that went over the 3 months, but less than the 6 months, then you lose 1 point up to 4. So I think that would be a fair score, do you think?
I will sit at 4, JP.
That's what I'm saying.
That is fair enough, JP.
Yeah. Now, you are one of those applicants who didn't discuss their candidature for coming here with me. And I want it to be understood that I don't play a gatekeeping role. But it helps bite myself and candidates when they say to me, look, I have a nomination, do I accept it? And then we sit and talk. And the first port of call I do with candidates who come to me like that, I say, let's look at your acting allocations, right? And then let's look at your list of judgments. But more at that time, it's just your acting allocations. And I look at them and I say to you, realistically speaking, as head of court, I would not think you are ready to go. And I would point out why. There are a number of people who've gone through that process. But I say, However, should you disagree with me, you're welcome to apply, but I will put these concerns that I have with you during the interview. You understand? So I don't prevent anyone from applying, but I just advise them that I think you are ready, or I think you'll be ready after acting in this area, in this area, in this area. You understand what I do? So you haven't had that engagement with me.
Sorry, JP, if I may come in.
Yes.
JP, I would like to refresh your memory.
Mm.
JP, at some time I wasn't acting, and I think we met in one of the official functions. And you said I should come over, and we happened to meet.
Mm.
When we met, JP, on that, I was sitting at 39 weeks. And you said, I'm ready to go, JP. You are comfortable with 39 weeks.
Yes.
Yes, JP.
Yeah. Well, I won't dispute it. I don't remember that
Yes,
conversation.
otherwise I would have not come here without your approval, JP.
Yes. Yes. No, I don't blame you. I'm 60-something year old, so, you know. Yeah. I mean, under normal circumstances, I don't hold that conversation that way. As I say, we sit, we look at what's before us, and we convince both of us, say, well, are you ready? It's 39 weeks, but where? I can give one example with one judge who's in Joburg now. She'd acted for 3 years in the criminal trial courts, right? And when I took over in 2012, I said, I'm not going to recommend you because you are in a court that does a lot of commercial work. I want you to act in the other civil work areas, especially commercial work areas. She listened, and she's a judge now. She's one of the senior judges. So it helps to have that engagement, right? I don't dispute what you say may have happened.
Sorry, JP, I don't mean to exchange words, JP. And if you may recall, JP, my spreadsheet was one of the first probably candidates, which to me helped me to complete, and we emailed it to you in that regard.
Yes, but I do that so that every time you act, it gets updated, isn't it?
That's correct, JP.
Yes. So the fact that Tumi did it and emailed it is not of no moment. All it means is this a candidate who wants to become permanent. So we need to track his or her acting periods and in what areas, isn't it?
I appreciate it, JP.
Yes, that's why. So there are two other issues that I want to mention. And I want to assure you, I have no interest in the merits. That is your UJE issue. I have no interest in the merits as to what happened, who's right, who's not right.
Yes, JP.
My issue is when this litigation happened, you had already started acting.
No, JP, I hadn't started acting, JP. If I may refresh JP's memory, JP, at one stage, I think I phoned you, it was in the evening, just briefing you that, JP, I have this challenge going on, and JP, it ended there. Then I said I will keep JP in mind. But at no stage, it was during my acting stints at JP.
What is the date of the period? The order is 2023-03-22. That's the date stamp I have here. And you started acting in 2022.
20. Oh, sorry, JP. You mean the order was made before? I had already started. What happens, JP, with this matter? It comes settled. Then it resurfaces. It has its own timing. Just as it has resurfaced now. I know, JP.
I'm just interested in when it was in court. It has a 2023 case number.
Yes, JP.
You started acting in 2022.
2022.
Yes.
By then, JP, the matter wasn't there. It was resolved amongst the parties.
Right.
Fast forward, JP. I'm about to start at court. It surfaces. It dies down again as we enter the court. It's settled before that. It dies altogether, JP. Come the JP interviews, it resurfaces.
For your information, I'm the one who requested the JSC to circulate these documents to you. It's not by anyone else outside here. So, as I said, I'm not interested in any merits as to who is right, who is wrong.
Yes, JP.
All I'm saying is, here's an order against you. You had already acted, I think, in 2022.
Yes, JP.
Twice, if not mistaken.
Yes, JP.
And then here's an order, and I don't know anything about it in the sense that you didn't come to me and say, in this court, this division that I'm acting, an order of this nature has been obtained against me. And I want to understand why you didn't do that.
JP, it must have fallen through the cracks, but I remember very well, JP. I'm not sure whether JP will recall. When this matter started, I did contact JP, that JP, I have this particular matter, but we are in negotiations, JP, for settling. Perhaps from there, JP, I did not come back to you that, JP, we have now settled. And because there is this constant resurfacing of this matter, we have agreed that we are going to make this dispute an out-of-court settlement and take it to court so that going forward, no one will accuse the other. But JP, this answer forces me to go back a little bit back. When I left the University of Johannesburg, we had fought our fight, and we made an undertaking. I made an undertaking. The first one was that I'm not going to retract the statements and I'm not going to apologize because you subjected me to that, whatever behavior and so on, racism and so on. I signed an undertaking, we finished, the matter ended there. I joined Northwest University. After having joined Northwest University, the dean calls me, Pogo, there is this matter between you and JP. Then I report to the dean. Dean, as
Look, let me stop you there.
Yes,
You
sir.
can say that if you want, but that's not my intention. Like I said when I started, all I say I'm concerned about is you are acting in the Gauteng division, and there's an order that has certain implications about your behavior, especially your activities on social media, about statements you may be making against other individuals. And here's an order in which you signed an agreement of settlement to say you won't do this. And when I went into the fold down case lines, I found that you never filed any answering affidavit to answer any of the allegations they were making against you. The matter was settled on that basis. I'm saying it was brought to me fortuitously that there is this order that has been obtained against one of your acting judges. And I'm saying to myself, but this is a division you're acting in. Why don't you come and say to the JPA, JP, this has happened, isn't it? Because, you know, when you want to become a judge, we don't want any controversies around you because you're going to be sitting and dealing with a lot of serious matters involving society. So that's the only issue. I'm not interested in the history. To what prevented you from talking to me?
I appreciate the concern, JP.
Yes.
I should have updated you as that the matter was settled and that was settled, that settlement was eventually made an order of court. I should have kept you updated, not only to say it's settled, JP, but also elaborate on the nature of the settlement. I
Yes.
appreciate the concern, JP.
Yes. And then There's the letter from the University of Limpopo. I was at a funeral of a former academic of the University of Limpopo. It's a person I was at varsity with at that university. So I went to the funeral, and then there was one person from the university there who spoke to me and said, we see that one of our former professors is acting in your court. I says, yes. They said, well, you know what you're getting, do you know what you're getting into? And then they started talking. I said, look, I'm not going to accept any verbal allegations. I want things in writing. And that's why that letter came, right? Now, the letter has been availed to you. You've seen it.
That's correct, JP.
And you have your view about why those allegations are made,
That's
right?
correct.
So I'm saying to you, I have a duty as head of this court to make sure that the people I recommend to become judges permanently have no blemishes, if one may say so. I don't say you have blemishes, you've said whatever you've said, but do you want to say anything about the letter from University of Limpopo?
Thank you very much, JP. JP, I appreciate the concern raised by my colleague, Advocate Rapatsa Mashel. I know him as a brother and a scholar. JP, most of those allegations are unsubstantiated. They are baseless. It's character assassination, JP. During my tenure at the University of Limpopo, JP, I wasn't reporting to the author of the letter to disregard Advocate Rapat. I had my own direct line manager, who is my current dean, Professor Njoti. JP, when I was headhunted from UNISA to save the LLB accreditation status of the University of Limpopo, I was tasked to be the leader of the Quality Assurance Committee. There is no way that as a leader, JP, I could have absconded from important meetings. To the contrary, JP, I singularly drafted a 72 pages draft improvement plan after I was reappointed to lead the task team. And I presented that report and it was adopted. I took some of the comments from the older version of the report and incorporated them in the new report, JP. And eventually, we won the LLB accreditation of the University of Limpopo. But I must mention, JP, the Council on Higher Education was very clear in its condition of giving full accreditation at Limpopo. It said that the school was led by junior academics who have no PhD degrees, and that had to be resolved because it had an impact on the quality of education. After we had obtained the LLB status, Advocate Rapatsa Mashele was appointed, contrary to the CHE conditions for accreditation, to be the director of the law school. And he accepted, JP, that appointment, knowing exactly that he doesn't have an LLB degree. JP, at times, personal ambitions have to be subordinated
Yeah, can
to
I
the
stop you
collective
there?
good.
Can I stop you there? I think I've given you enough time to explain that background. But your departure from University of Limpopo, was it amicable?
It was amicable, JP, about a week ago. I was there. We had a conference. I went to support them.
No. All I want to know is,
JP,
was it amicable?
It was amicable, JP.
And from the University of Johannesburg?
It wasn't amicable at the University of Johannesburg,
Yes.
JP.
Okay. It, it's my duty to put this to you. You've given.
I appreciate it,
I've
JP.
gave you time to explain yourself. You have explained yourself. CJ, I will end there. Thank you.
Thank you, JP. Premier?
CJ, I'm covered, CJ. Thank you so much.
Thank you. JP Khaled?
Thank you, Chief Justice, and Professor, here am I.
Yes, Commissioner. Thank you, Commissioner.
Thank you. Just a follow-up on what Mlambo JP raised with you. It is so that you are a member of the Electoral Court. And did you disclose the existence of the litigation and its settlement with the chairperson of the Electoral Court and those who appointed you in that regard?
No, Commissioner. That has not been disclosed, Commissioner.
That was?
That wasn't disclosed, Commissioner.
I see. And any reason that you can proffer why it was not, maybe?
Commissioner, after we had made an out-of-court settlement, my understanding, Commissioner, was that this is binding upon me. And we have resolved our differences as we had agreed. And from there, Commissioner, I dusted myself and moved on. Commissioner, I appreciate the concern. I should perhaps been more delicate and not only to take it as being resolved, but brought it to the attention of my seniors. That was an oversight. Thank you, Commissioner.
Thank you for the answer. And secondly, the explanation that we've been giving regarding what's happened with the UJ, University of Limpopo, don't you think your appointment at this stage will drag the name of the judiciary into this kind of spec? Is there a way in which it can be resolved so that when you are considered and ultimately appointed, that it is clear? We don't have to see the judiciary being dragged onto the social media comments about this kind of issues. More so that without saying they are true, but that they relate to your character, there some seem to appear to be allegations of defamation.
Thank you. Thank you, Commissioner, for the question raised. I appreciate it. Commissioner, if I may go back, I understand the seriousness of this nature. Commissioner, as you would see from my questionnaire, I was born in the apartheid South Africa. And at certain stage, I was part of activists. However, I renounced my membership. As an academic commissioner, I could have chosen a route of only becoming a professor and focusing on my own personal development. However, as a young black aspiring academic, I couldn't focus only on my personal development when the injustices were occurring. I then, Commissioner, decided to be involved in issues affecting black academics. And eventually, I found myself being the center of attention, including being targeted. With that said, Commissioner, the allegations raised against me are very serious. But Commissioner, I had to come before this body to clear my name. The withdrawal of my candidature, Commissioner, would have meant that I have something to hide. Commissioner, I do not hide my academic activist. My writings, I am an academic commissioner. I express my feelings in various platforms. I have written about the Madam Chief Justice in one of my articles concerning transformation of the judiciary. I have written about the briefing patterns and produced a report. That is the commitment. And unfortunately, Commissioner, I must admit, being an activist, whilst you are pursuing your own career, it comes up with a price. It is the price, Commissioner, that I will pay. But going forward, Commissioner, I will be careful on how I conduct my activism. However, I will not subjudicate my conscience to the detrimental of the fellow black academics who are victimized and eliminated in historically white education. I appreciate your commissioner. Thank you.
Yes, and you've also written about my judgment in Kivis Kron at the Labor Appeal Court.
That's the same judgment, Commissioner, which raises the plight of black people who happen to believe in another platform of medical care. Unfortunately, Commissioner, as I said, there is a price to pay when you stand for your rights and the rights of others in the New South Africa. I appreciate your comments, Commissioner.
I must say I got more than I bargained for, but what I want to say is there a way that you can clear up these issues, not in this body, so that at least when you are appointed, we don't have to go back to these kind of issues? If it's not possible, then I would accept an answer.
Commissioner, thank you so much. Commissioner, I was under the impression all the undertakings that we have been doing, I was under the impression that we have somehow agreed. The difficulty, Commissioner, when we reached the settlement agreement, if you look at it, Commissioners, there is one condition that I'm not willing to form part of that agreement. That is to retract and apologize for sharing my lived reality as a black scholar in a historically white university. Those appears to be the main things that keep making this matter to resuscitate.
Thank you, Prof. Thank you, Chief
Thank you,
Justice.
Commissioner.
Commissioner Ngota?
Yes, thank you, Chief Justice. Professor Pogo, I just need to put some of the concerns
Yes, Commissioner.
to you. You have debated some with Judge Mlam. The first one is that there seems to be three primary objections. One is from the University of Johannesburg saga, where there was an application brought against you to interdict you from disseminating what they call were injurious falsehoods.
That's
and you
correct.
admitted that, and you entered into a court order
Yes.
in which you admitted to the interdict against you.
Sorry,
And
Commissioner.
now what we don't have are these injurious falsehoods that you allegedly disseminated.
Commissioner, may I respond?
Yes, please. That's the point of the question.
Thank you, Commissioner. The injurious statements, Commissioner, are the ones relating to my shared or my lived experience at the hands of the employees of the University of Johannesburg. I don't know whether Commissioner wants me to share that. It is now public information, Commissioner, because it is in a court file.
Yes.
However, I couldn't, out of my own volition, present it because it would somehow contravene the court order. Commissioner, I will be very brief. I will attempt to summarize this in a minute or two.
But no, don't make it a minute, make it 30 seconds.
Commissioner, what happened at the University of Johannesburg? When you have entered marks incorrectly, there is a form called a change of marks. And you complete that form so that it can be signed by your head of department and the dean. I happened to be in that situation where I incorrectly entered marks, approximately 150. I took the change of marks forms for approval and we corrected the marks. Then at a certain disciplinary hearing of a black colleague, I indicated that I also faced a similar problem of change of marks and I completed the change of marks. Out of that disciplinary hearing I was testifying, I was informed that I lied and I said I completed the change of marks. After completing the change of marks, Commissioner, you hand over to the faculty administrator, who is Miss Monica Brex, for keeping and filing. It happened that when I handed over my change of marks, Commissioner, something that I always do, I kept my own records. But when I went now to request the original files, they were nowhere to be found. Right through, Commissioner, they were nowhere to be found. I asked the chairperson of the disciplinary, not the chairperson, but the employee relations, please, there is something wrong because you cannot change the marks in the system without having completed this form. I phoned my co-lecturer who said, no, there's nothing like that you completed. My head of department and someone else, they denied the existence of the marks. I said, it's fine. It sounded like a rehearsed response. Then, Commissioner, what I did, when I arrived at home, I scanned the templates of the marks and I emailed them to the employee relations. On the following day, I
Yes, no,
received...
I understand. What I'm really looking at is, where did you publish these injurious falsehoods that they are talking about? Because that's the interdict is
yes.
against your public announcements of these
These
falsehoods.
statements, Commissioner, I published them on Facebook platforms, on Twitter platform. I sent them to media houses. However, the media houses did not respond to them. And I also emailed some of them to my colleagues. And that's how I shared that experience, Commissioner.
No, that's fine. Now, then there is a second category of complaints, which is the circumstances in which you left the University of Limpopo, basically leaving them in a lurch, not attending to classes, not attending meetings, missing 3 meetings which were crucial in the university. And you've answered some of those questions that were put to you by the JP. Is there anything you want to add?
What I would like to add there, Commissioner Mugaitobi, is that in these meetings, we sign a register. However, the author of the complaint doesn't indicate the date of the meetings I've missed. And again, he doesn't indicate that at one stage I was even the head of that. And I wasn't reporting to him, Commissioner. The second one, Commissioner, it relates to businesses that I continued to be involved in a lounge.
Well, they call it a tavern.
Yes, Commissioner.
Yes.
Commissioner, I admit that I am in business. I have a lounge, Commissioner, which is licensed. It's called A2 Lounge Matatiel. I run a B&B, Commissioner. I have a logistics company, Commissioner. I have a farming company, Commissioner. Commissioner, at no stage during my acting stints, I was actively involved in these businesses. Even if I were to be involved, I can assure you, Commissioner, the workload at the Gauteng High Court will make it impossible for you to deliver judgments on time.
Yes. No, I think what concerned me with when I saw those allegations, there is the one where they say you have a general propensity to engage in social media and slander people there. I'm not saying that's correct, but that's what they're saying, that you have this propensity for social media and slandering people. And you are also engaged in private commercial enterprises. What concerned me was not the moral judgment on those activities because I don't have the capacity for it. But it is the fact that you are already occupying a judicial role in the electoral court. And that has the implication of bringing the administration of justice into disrepute. And whether you had in fact applied your mind to that, because there is an inconsistency between holding a judicial role and being an active tutor warrior.
I appreciate that, Commissioner. Commissioner, if I may respond, the business interests, I'm no longer involved. The logistics company closed down some way back.
Now, I understand that, but I'm saying that you were holding them at the same time as you were holding a quasi-judicial role in the electoral court. That's what really worried me there. It's not whether, I mean, as an academic, you can, there's no prohibition. I'm just worried about what people will think if you are sort of two-timing them.
I appreciate the concern, Commissioner. It doesn't paint a beautiful picture.
Yes, and it's the same thing with your propensity for Twitter and Facebook. It may be that the things you're saying are correct, but the public will think differently about the judicial system if one of their number is busy fighting other battles on Twitter. Which comes back then to the point made by Justice Tlaletsi, which is whether you shouldn't actually be taking time off, the cooling off period, to, I wouldn't say mature because that's not my space, but to let these events percolate and settle, and then to come back maybe in a year or two. At the moment, it looks like the transition is too soon and too sudden. Do you have any comment on that?
I appreciate the concern, Commissioner. Being an academic activist, it comes with a price, Commissioner. And I appreciate your concerns are quite correct, Commissioner.
All right.
Chief Justice, may I follow up, please? Good afternoon, Professor Puko.
Good afternoon, Commissioner.
Professor Puko, you're aware that I have great respect for you. But I am concerned that despite what you're saying, you don't quite appreciate the severity of the concerns that have been raised with you. And can I just demonstrate one issue? You've now indicated that you've had diverse business interests ranging from a lounge to a B&B to a logistics company and to a farming company. I'm correct?
That's correct. Please proceed, Commissioner.
Can I ask you to go to your form and specifically to paragraph 1 of your form?
You may proceed, Commissioner. I have the form in my
You see,
memory.
none of this is reflected in your form.
Commissioner, it's there under AA2 Lounge. That business, all these things, they fall under it. Then the farming commissioner, it's a family business, a sort of informal, not trading and so on.
You see, Professor Puko, you disclose in paragraph 1 of section 3, you disclose the fact that you're a director in the company you list, the private company you list there.
That's
right.
They all fall under that company, Commissioner. Sorry,
But-
I wasn't clear enough.
No, I understand that, but what is required by section 1 goes further than that. It goes further than you disclosing just your directorships. It's also asking for your business interests. And so what I'm putting to you is that you had a duty to break down your business interests, to give the commission a sense of the extensiveness of your various interests.
I appreciate the concern, Commissioner. I was not clear enough. It's one company, then under that mother company, you have all these various, but they are not coming out clearly as I explained them now, Commissioner.
And you see,
I take the concern.
It gets worse, Professor Puko, and I want you to very seriously consider this. If you go further down in the form, section 4, paragraph 1,
Yes, Commissioner.
asks you, are there any circumstances, financial or otherwise, known to you which may cause embarrassment in undertaking the office of a judge? Now, you're an academic, you understand the breadth of the term embarrassment.
That's correct, Commissioner.
Your business interest, for example, in a lounge, that's something you should have disclosed under that section.
Yes, Commissioner, I appreciate. I should have elaborated more on the company because commissioners are not aware of the company.
And more importantly, Professor Puko, the settlement agreement that we were provided with after you put in your application, the settlement agreement should certainly have been disclosed in a number of sections in the form.
Commissioner, I must admit, I struggled with that one. I think somewhere it doesn't come out in my explanation in the form, but there's where I keep making reference to transformation activists and so on. But I appreciate, Commissioner, it should have came out very clear so that from the face of it, it is clear that this is a standing order.
You see, Professor Puko, this is where you and I are losing each other. For me, this has got nothing to do with transformation activism. This has got to do with the fact that you entered into a settlement agreement, which was made at order of court, and that agreement imposed certain obligations on you.
Yes, Commissioner.
And so you know that if ever you breach any of the terms of that agreement, that's a breach of a court order.
That's precisely correct, Commissioner.
And for that reason, Professor Puko, it really ought to have been disclosed under 4.1 of your form, section 4.1. It also ought to have been disclosed under section 4.2 of your form. Sorry, no, it's not a convicted of an offense, but you certainly are bound by a court order, which ought to have been disclosed in your form.
I appreciate the concern, Commissioner. I did not understand in that way, but I get it. It's clear, Commissioner.
So really, just to wrap up what I've been putting to you, it goes beyond raising concerns about your conduct generally. What I'm raising with you is material non-disclosures in your form to the JSC. And that's what I want you to address.
I appreciate the concern raised, Commissioner. I don't think I can take it further. This should have been come out clearly from the face of it, Commissioner.
Thank you, Chief Justice.
Thank you very much, Prof. Good afternoon.
Sorry, Commissioner. Yes.
It's Minister Smelan.
Thank you, Commissioner.
Have you deactivated all your social media accounts as we talk today?
As I sit here, Commissioner, I haven't deactivated anything.
When did that happen?
No, sorry, Commissioner, I'm saying I have not.
You have not?
Yes, Commissioner.
Okay. Do you understand the importance maybe of from emanating from today's discussions of possibly not having one?
I fully appreciate it is something to work on and address, Commissioner.
Thank you very much.
Chief Justice, thank you so much. Good afternoon, Prof. Poko.
Sorry, Commissioner, which side are you on?
This side.
On your right.
Commissioner Lekhanyan.
Commissioner Lekhanyan.
Yeah. Good afternoon, how are you?
Commissioner, I'm surviving under the circumstances. Thank you so much.
Thank you so much. No, it's just a follow-up to one of the statements that you made. Maybe you can help us to elaborate on it when you say academic activism comes with at a price. What do you mean by that?
Commissioner, my activism perhaps could have been approached in a different manner, especially if one is considering appointment as a judicial officer in the High Court. Perhaps the manner of approach could have been taken in another way, Commissioner. But I understand that fighting for other people doesn't necessarily justify the manner in which you engage on it. That's what I meant, Commissioner.
You want to concede that you are your approach could have been defective.
I fully appreciate, Commissioner. My approach could have been handled better, no matter how the circumstances were. Perhaps at the palms of my reaction, I just decided to act at that moment without fully appreciating the broader picture.
No, thank you so much, Chief Justice. Thank you.
Thank you, Commissioner Ikhanyane. Do you have questions from the virtual platform?
Yes, I do, Chief Justice. Thank you very much. Good afternoon, Professor Poko.
Good afternoon, Commissioner Marumwakai.
Perhaps maybe it is opportune time for one to disclose that we know each other very well and we work in the same space. I want to take you to your document, and page 112 in particular. The judgment that you penned.
Sorry, Commissioner, if you may direct me which bundle?
I would think that there is only one bundle, but where you have your decided cases, your judgment. B versus R. It is in page 112. Paginated page 112.
I'm there, Commissioner.
Yes, this is the case of B versus R, and in particular paragraph 25 of that decision. This is a case that dealt with forfeiture of benefits. Yeah. And in paragraph 25, we say that the issue of fairness also does not come into play. In other words, in the remedy of forfeiture of benefits. The question that I want to ask you, and you are quite right, by the way, but the question that I want to ask you, forfeiture of benefits is one of those common law remedies that have been codified in the Divorce Act. Is there a need to develop this particular remedy? And is it constitutionally compliant to the extent that the concept of fairness is not part of how it should be understood?
Thank you, Commissioner. Commissioner, I think if it were to be argued in that way, and particularly considering issues such as Ubuntu, compassion, and so on, one would be tempted to agree with you that the issue of fairness in the adjudication process perhaps could play a major development.
Oh, that's where you leave it. Okay. No, that's fine. CJ, let me leave it there as well.
Thank you, Prof. Yes, Acting President Zond.
All right. Yes, good afternoon, Professor Poku. I'm here.
Good afternoon,
Yeah.
DJP.
It's just my advice to you. It's just a comment. It's not a question. Based on what my colleague on my left has advised you to do, I think that the best thing for you to do is to keep away from social media, because it has got, it doesn't give one an opportunity to think and reflect. You react to something immediately before you think about the consequences of what you are going to say. So my advice to you is just, if you're really serious to progress in life generally, just stay away from social media, because it has got so much, it attracts so much negative energy, the energy that you don't need. So yeah, that's my advice to you. I wasn't aware that there were such issues, because
I was not informed. I was not told that there were, you had some challenges with your former employers. Thank you. That's all. That's my advice to you.
I fully appreciate it, Chairman of the Electoral Court. Madam Chief Justice, Commissioners, I have considered the deliberations and I have considered the engagements between you and myself. I have taken your advices on board. JP, I've taken the advices on board. With those few words, I'm going back to do a homework. And I withdraw my candidature. I thank you, Madam Chief Justice and Commissioners. Thank you.
JP Mlambo.
CJ, before the prof leaves,
Yes, JP?
I discovered you. You said that. And I've invested in you. I hope you understand that I was duty bound to the institution of the judiciary and to the court I lead that this engagement happens. Do you understand that? And I want to say, to encourage you to say, when I reach out to you to say, come, let's talk. Because I don't want my investment in you to be lost. And that you will respond. You understand that? I've got nothing against you personally. You understand that? I just wanted to say that, CJ. Thank you.
Thank you, JP.
I appreciate JP. Thank you so much. Thank you, Commissioner.
No, I've not released you yet.
Oh,
don't rush off.
my apologies, Chief Justice.
I just wanted to say that I know where you come from. I used to do circuit work when I was still in the High Court in the Transkei, in Maluti. I'm quite familiar with that area. I know that dusty, arid village from which you come, and it's quite remarkable that it's produced a professor who studied overseas, who's achieved all the things you've achieved. You described yourself as a raw but shiny diamond, and that's what you are. So what has happened here today should not discourage you. I just want to give you that caution. There's still a lot you can do, and you can still come back. But do pay attention to the advice given to you by acting President Zondi. Social media is the bane of this generation. Is the bane. Whilst the internet and all that it comes with is good, we appreciate the benefits it has brought, but it has caused huge damage to our young people for various reasons we don't have time to traverse now. So keep away from social media, young men.
Thank you very much, Chief Justice.
But
Thank
thanks
you.
for this honorable decision.
Thank you,
You're
JP.
excused.
switch it on.
I'm sorry, just bear with us for a minute. I'm waiting for the minister. Good afternoon, sir.
Good afternoon, CJ.
How do you pronounce your name? I'm avoiding mispronouncing it.
Tupayatlasi.
Tupayatlase.
Yes.
Thank
CJ.
you.
Thank you.
Tupayatlase.
I know it's always difficult. That's why they only call me TT, CJ.
I can't call you Mr. Titi now, can I?
Yeah, no, not today, not today.
You studied BU recent LLB degrees
That is correct,
at
CJ.
you obtained the BU recent that university that used to be known as UNIBO,
Yes,
and then you did the LLB through UNISA.
through UNISA, CJ.
Was that while you worked as a public prosecutor?
Yes, that is the reason I worked as a prosecutor, DJ. And
Even-
subsequently a magistrate.
Oh yeah. So you were a public prosecutor for 4 years, about 4 years.
Yeah, about 4 years, 1985 to 1989. Correct.
Then joined the magistracy,
That's correct, CJ.
and you were there for about 14, just over 14 years.
Yeah, just over 14 years until 2005, CJ. Then I resigned.
You went to work for, was that the private sector?
The Universal Service Agency, CJ, is an agency of the Department of Communication, what is now called Department of Digital Technology.
Oh.
It is created in terms of, in the Electronic Communications Act, there is a chapter that deals with universal service. So the Universal Service Agency administers the fund that is created. The Act provides that a certain percentage of every licensee is obligated by law to contribute towards that fund. That fund is called the Universal Service Fund. It is a fund that is supposed to be tapped by the same licensees, your telcos, when they go into rural areas. The idea being that with a recognition that in those areas, from a commercial and a business point of view, they may not make money. So as a result, then when they want to expand electronic or telecommunication infrastructure in those areas, then they are required, then they can tap into that fund. In addition to that, every licensee telco in the country has what we call universal service obligations. And those obligations are also then monitored by this particular agency, the Agency of Department of Communications. But it has a separate board, it has a CEO and all that. But I was only there for 18 months.
Yeah, you were in the legal and corporate affairs department.
That is correct.
Giving them legal advice.
That's correct, CJ.
Well, I doubt very much that my village has ever benefited from this body.
Yes, CJ, you know that it's one of those things that on paper they look very good, but the implementation is always a challenge.
Something else, yeah. Then you left them and joined Neotel.
Yes, Neotel at a time was just been licensed. It was envisaged that it was going to be what was then called SNU, a second national operator. And the minister licensed it, and I worked there. It also, as I've indicated, also had those obligations. So the idea was I would go there, and we started the department of community service that was to deal specifically with those universal service obligations. I was not strictly within the legal, there was a separate legal department at that time. Yes.
But then you went back to the magistracy.
CJ, yes. For the first time in my life, there was a point I was not working. What happened is that Neotel did not really get off the ground to become a successful company. And at the end of 2010, we were offered severance packages. I decided to take that, and I was home from January of that year until June when I applied and for an acting position, and I went and worked for a year in Klerksdorp. During which period permanent positions were advertised, and thereafter I applied and I was successful. I went to work in Bloemhof, so as a head of office and the only magistrate in that district, doing both Bloemhof and Christiana.
So you went back to the magistracy and never left.
And since 2012 to date, I never left again.
And you've worked your way all the way up to regional magistracy.
Yes, I must appreciate the considerations that the department gave me. I think my past experience was never ignored whenever I had applied. So as a result, I became a senior magistrate for Krugersdorp and then acted as a chief for 5 years in Randburg. And then since last year, I'm a regional court magistrate in Soweto, Protea.
So you've been a magistrate for about 27, 28 years?
That is correct, CJ.
Running the criminal and civil court?
Yes, CJ.
Various stages.
Various stages, but especially, let me say, when I worked in Harankua, at one stage, just on my own accord, I decided that I wanted to do civil work. At a time, they still had what was called Justice College when they trained, and from that moment, the bug bit me. I've been mostly in civil work, which of course then, and the experience came very handy when I was the only magistrate in Bloemhof, because then I had to do everything.
Yeah, and that experience paved the way for you to be appointed to the rules board.
Yes, CJ. Yes, CJ, to the rules board, yes.
And you list subcommittees in the small claims and magistrates court in which you've sat.
Yes, and also the cost committee, subcommittee. The rules board operates with subcommittees. Each subcommittee does a particular work, and then of course there is a meeting of the whole rules board, chaired of course by a judge from the SCA, presently Justice Ndambuza.
Yes, and you train aspirant and serving magistrates under the auspices of the SAJE.
That's correct.
You have acted as a judge?
Yes, from third term of 2021, fourth term of 2021.
2023?
2021.
Sorry, 2021.
Yes.
And for how long were... No, it was not just one stint, was it?
Yes, in 2021, I acted for a full term. In 2022, it was also for a term. And it was for 2 terms. And then in 2023, I acted also on the 4th term.
Was your last acting stint in the High Court in 2023?
2023, last term.
And you claim to have presided over civil and criminal trials, opposed and unopposed motions, family court, criminal appeals.
That's correct, CJ.
And road accident fund matters.
That's correct, CJ.
Did you produce any written judgments?
I have, I've counted about 40 judgments during the 37 weeks that I've acted.
Yeah. Have any of those been reported?
No, CJ, only published
In Safely?
in SAF, in JDR. I know the CJ will ask me why I didn't mark them reported, but in a majority of cases, the way I said, the consideration was always, I was confirming principles that higher courts or courts with more than one judge has dealt with. So I've never thought it wise that there was anything novel that any of those judgments produced.
Well, experience has shown that it is not only judgments on novel issues that may be useful, especially to the, to the lower courts.
Yes.
So if you've spent a considerable amount of time and did good research in the subject area you covered, if it's good to mark it reportable. You can sense when a judgment is reportable. Then it's up to the publishers to ignore it if they don't think it's worth publishing in their books.
I appreciate and accept that advice.
We've lost a lot of good judgments because people don't mark them reportable.
But on the same breath, with the present digital publications, much as they may not be reportable, I take that they are available to be considered.
Yeah, it is easy for people to pick them up.
Yes.
Okay, I'm going to give Judge President Mlambo a chance to ask you questions.
Thank you, Chief Justice. Good afternoon. Ntate Thupayatlase.
Good afternoon, JP.
Did I pronounce it correctly?
You have, JP.
Thank you very much. I know you told me that it's been a painful wait for you. We apologize for that.
Yes, but I also added that, it's the first time that I've been ordered food when I came to an interview. Thank you for that.
Yes, you did say that after a number of times applying. Or the first time to apply?
No, it's the first time.
First time you apply, yeah. So you must have a magic wand to apply for the first time when you are shortlisted. My spreadsheet says you've done 37 weeks totally acting.
I agree with it.
You agree with it? And all of those acting stints have been term long.
They have been term long, see.
Yeah, and the reason they've been term long, you're able to do that because you're a magistrate, you are able to arrange your life accordingly.
Yeah, especially when I worked as only the head of office, the chief magistrate of Randburg, because I was not doing full-time court work, so that became possible.
Yeah. You, in your capacity now as a regional magistrate, you do a lot more criminal work than civil, am I correct?
That's correct, CJ.
Yeah.
There is an element of civil work, but it's so little that, in fact, we have just allocated to one magistrate.
Yeah.
So the idea is that from time to time we'll just alternate, but as it stands, only one magistrate, so I do only criminal. And I can tell you it's hard in Soweto.
I know, I've been there. But here's what I want to suggest. Commissioner Gauteng has been raising the issue of the long lead times in Gauteng. You've acted in the High Court. You are aware that quite a big number of the matters that come to the High Court, especially in the unopposed motion roles, belong in the magistrates' courts.
That's correct.
Now, are you going to help us find ways of lawyers taking these matters to the magistrates' courts? Because they actually don't mind. Even if they come to the High Court, you don't give them High Court costs, they still come to the High Court.
JP, I sat with you in PEC meetings. I know the discussions, what went on. I know what motivated you, for instance, to constitute a court that ultimately produced Mokebe's decision.
Well, it produced a decision I don't like, but anyway.
Yeah, but
Yeah.
despite all the best efforts, for instance, by the South African Human Rights Commission
Yes.
to take the matter to, it was the wisdom of our highest, the apex court, that such matters can still come. I was just rereading the judgment yesterday, telling me that in fact the court, the High Court, for instance, cannot refuse a jurisdiction to entertain a matter. But having said that, the rules board, considerations are always given, for instance, around the issue of what can be done. We introduce, for the High Court, we introduced Rule 41A. I think it's a rule that needs maybe to be revisited, and maybe just to make it have teeth, because it has become apparent from me, at least, that it is just becoming a ticking box for
It's a
lawyers.
tick box.
It's a tick box. Practitioners just tick that the matter cannot be mediated, as a result of which.
No, look, you don't have to go
Yeah,
further.
thank you.
That's not why you are here.
Yeah, thank you.
Yes, this SCA and CC judges
That's there.
live in a different planet. Do you agree with me?
Oh, difficult to say.
Don't agree with me.
No, I don't.
I'm just saying that.
Yeah, no,
it's
just I want to leave it to you.
Yeah. In your acting stints in Gauteng,
Yes, JP.
you've done 3 weeks of opposed motions,
That's correct. JP.
as well as 1 week in the agent court,
That's correct. JP.
and no allocations in the special motions. Right. And those are, especially motion court, opposed motion court, it's a difficult work area. And I told you before you went there that.
You told me so, JP.
Yeah.
And in fact, it's interesting that, I started when because of the COVID restrictions, so I was essentially all by myself.
Yeah.
I had to do most matters online, but I'm happy to say I think I acquitted myself well.
No, you did. You did, yeah. And in the course of you acting, you produced some 40 judgments.
That's correct.
That's what I have here. Now, what I've noted is most of your judgments are within a month to 2, but there are a couple, I think I marked 4.
That went beyond.
That went beyond the 3 months. One is 5 months, 2 are 4 months.
Yes. In particular, the 5 months one, JP, it involved medical negligence.
Yes.
It was what we call long duration trials of 10 days, and it lasted 10 days.
Yes.
Both the plaintiff and the defendant each had 5 witnesses on each side.
Yeah.
In addition to evidence witnesses that were called. So it really needed more time for me to consider, and I considered that.
Yeah.
And that is the rest of the other cases, and I know I received a call from you on a Sunday, JP, or on a Friday, but it was on the 26th of January when you were alerting me to a judgment, a TIPCON judgment, and I said to you it was ready. And by Monday I had delivered that judgment. The idea here is that I type my own judgment, I do my own editing. So at times, maybe out of self-deprecation, I tend to take longer, maybe just to once always read. Every time I read, there's a comma that I need to add or extract. But end of the day, but the task, and I'm aware, in instances where I went beyond 3 months, I profusely apologize for that, and it is mainly because of also the work. You'll realize most of those cases are the ones that when I was now already in the regional court, and I've told you that the regional court in Soweto also breaks the back. It's like we are in Johannesburg High Court.
Yeah.
Yes, JP.
Now, we had a magistrate here, senior magistrate who appeared, who confirmed that your experience as a magistrate's court magistrate on its own does not equip you to take permanent appointment in the judiciary. He said that's correct. What's your view of that?
JP, I don't think I agree that it doesn't. Because at the end of the day,
I'm talking permanent appointment.
You mean?
Permanent appointment as a judge.
As a judge.
Yeah.
But that experience coupled with the acting.
I didn't couple with.
Or with, not coupling with.
Yeah.
Yeah, yes, if I just have to come to the magistrate's court.
Yes.
And right into the high court, I believe there could be.
You need to act.
You need to act, yes.
Now, you've had the bulk of your experience as a magistrate.
That is correct.
Senior magistrate, and you were in Randburg before you came to the what do you call it, the regional court.
Yes, yes.
But you've only been there a year, or just over a year.
The regional court.
Yes.
Yes.
Yeah. So this is a question I ask you. Why do you want to come to the High Court? You've just been there a year. What motivates you to want to then come to the High Court directly?
Oh, direct. Well, JP, the regional court is just a specialist court in terms of criminal work. The overall, to be a complete magistrate, if you're a district court magistrate, to me, makes a more complete magistrate, because all aspects of the laws or the areas of the laws, family, civil, criminal itself, are dealt with in that court. We know the history where the regional court comes from as a court, as a specialist criminal court.
No, but the regional courts have civil jurisdiction.
Yes.
Why don't they do a lot more civil work than they are doing criminal work?
JP, the reason that I can think of, and I've heard practitioners talk about,
yes,
is lack of experienced magistrates. Because when it was introduced, the bulk of the magistrates only had criminal experience. It is, of course, now that the Magistrates Commission is trying very hard to widen up the pool in terms of attracting, especially people from the members of the bar and the sidebar.
Yeah.
So.
Okay, but I'm not blaming you. I'm just saying that's the dynamic we see at PEC trials, that the work that comes to the High Court should actually be done in the regional court.
In the regional court, I agree with you entirely.
We would not have these long lead times if that was happening.
Yes, but it is one of those things that must be encouraged. But remember now, JP, the law as it stands now, the interaction is between the magistrates court and the High Court. I've tried to look both at the rules and the act itself. The only time that a matter can be transferred, for instance, from the High Court is to the magistrates court. So maybe those are, with the powers that be around this table, is something that can be legislated. And then,
no, the minister is here.
Yes, then that can be legislated. And,
yeah.
And
so, just my last question. I'll come to you about my scoring matrix. Don't you think you could have done more in the acting stints, especially in coming for more acting stints to be allocated special motions to see how you handle them before you availed yourself? No? Because you've not had a special motion allocation.
Yes, I've not had a special motion. My general experience, JP, and I know the approach that you take, that one must have been exposed to all forms of the work. But my general
the difficult work.
The areas. Difficult work. Yes. Yes, but I've handled urgent court. I've handled opposed motion. So if I have to have an opportunity of doing a special motion, I do not see how I will be unable to deal with it.
You see, because when I look at your spreadsheet,
Yes.
You've only sat in one full court appeal. I don't know whether you wrote it. And
Yeah,
then,
I wrote, yeah, it was two matters. One was written by another senior judge, and I wrote the matter. The average case matter is the one
yeah.
where I said.
And the numbers of the work you've done as an acting judge compared to other candidates who have sat there is quite low because they've acted longer. And I mean, civil trials, you've only handled 2, right? So that's why I'm asking whether you think, like in Asian court, you've only done 1 week. If you've done 3 or 4 weeks, I would understand. Understand. So that's why I'm asking whether you think you are ready, I should recommend you, or you think you could still benefit from more acting stints.
JP West said, I think I'm ready.
You? You don't agree? No, look, I'm not intimidating.
Yes. No, I agree with you, JP.
Okay. CJ, I don't have any further questions for...
Thank you, Judge President.
Yeah, thank you.
Premier?
I'm also covered, CJ. Thank you.
Thank you.
Thank you, Premier.
Any questions, commissioners? Commissioner Mugaitu?
Thank you. Mr. Tupayatlase.
Commissioner Ngogai Topi.
Yes. Okay, I think
both our surnames are
I
difficult.
should accept the punchback.
Yeah, both our surnames are difficult, Commissioner.
Yes.
Thank you.
No, I'm not sure if I heard correctly.
Mhm.
What did you say to the JP? Did you say you agree with him that you are not ready, or you disagree with him? What was the actual answer?
No, the actual answer is that I think I'm ready. I can do that.
You are ready now.
Yes, JP. I mean, if you, and this is more fortified, for instance, by the comments that I got from the GCB and other law bodies.
Yes, and how many reported judgments do you have?
Reported?
Yes.
No, I only have published.
You don't have one? Yes, and you don't think that's a problem?
Commissioner Toby, it could be.
Yes, all right. And then we've been looking at candidates who've acted for 60, 61, 62 weeks. And how do you fare on that one?
Yeah, no, I fare lower than them.
Yes. And we've also been looking at candidates who've been in practice. One of them was 36 years in practice as an advocate, particularly doing high court work, appeal court work, constitutional court work. And how do you fare on that one?
It is obvious that I fare lower.
Yes. Now, and these are the sort of core skills that this commission is looking at. And on those 3 yardsticks, you admit that you are below. But at the same time, you disagree with the JP that you are not ready. So
I'm just saying on the objective facts.
There's no problem of a self-assessment here.
Okay, no, I was just saying on the objective fact, just to say, I was heartened by the fact that for what I've done with the amount of time that I've had, I didn't have any negative comments in terms of the quality of my judgment.
I mean, and most of this can be solved because you can get more time and then come back. It's not as if they're inseparable.
I agree with you.
Yes, so that's why I was just asking about the self-assessment.
I agree with you, Commissioner.
Thank you. Acting President?
Good afternoon. Thank you very much, Chief Justice. Good afternoon, Mr. Tupayatlase.
Good afternoon, Commissioner.
There are two objections. One is from There's one from National Bar Council of South Africa. Their concern is that they don't think that you are ready because you don't have any experience in constitution litigation. Do you agree with that as statement?
From which association?
It's National Bar Council of South Africa. It's a letter that they wrote. Can't see the date here, but yeah, it's an objection that it's a concern that they've raised.
Yeah, I see that paragraph 4 of their letter.
Do you see that? Paragraph 4.
Yeah.
Do you agree with that statement?
Yeah, the constitutional litigation specifically. Yeah.
Do you agree with that statement?
Yes.
And then there is Law Society of South Africa.
Mm-hmm.
They are mentioning a complaint of bias. Did you see it?
Yes, Commissioner. And
you want to say anything about it?
After this came, and I sent this complaint was initially lodged with the DJP Sutherland, investigated the matter. He didn't find me any merit. Later, I got a call from the JP also, and I also responded. Some 2 weeks ago, I received a letter from this body, the JCC, the mini JSC, saying that the matter, the CJ referred the letter to JP Mlambo and also investigated the matter. The word used there is that he found it to be frivolous.
Sorry?
He found the complaint to be frivolous.
Oh, frivolous, so it was dismissed. Okay.
Yes. So what I'm saying is I'm the one if you look at my application, when I applied, I did when under the general heading whether there's anything that I wanted to put forward that may put the judiciary into this report. I specifically mentioned that to say, I'm aware of this complaint, the DJP had dealt with it, but at a time I had not received a feedback from the office of the JP. So that is where we are. So what happened is that on the 25th, all these remarks, 25th of September, the remarks were sent to me. But at a time, our network had crashed, so I didn't see these other complaints. But when I ultimately saw it, I sought advice from the office of this OCJ office, and I was advised that all that I did was to send the letter that had come from the JCC. So I thought that that response answered the issue that was raised.
Okay. My last question is, based on the nature and the amount of work that you have done at the Gauteng High Court.
Yes, JP.
How would you, on a scale of 1 to 10, how would you score yourself?
In a scale of 1 to 10?
Yes.
Give myself 6.
6 out of 10. Okay, thank you.
Commissioners, on the virtual platform, do you have questions for the candidate?
Yes, I do.
Yes, Prof, go
Chief
ahead.
Justice, Dumela
Dumela Maruma, Commissioner.
I just want to ask you about something that I've been thinking about in as far as civil work is concerned in magistrate courts. I've realized of late that in the regional courts where divorces are done, most of the magistrates are reluctant to deal with maintenance matters that are incorporated into the summons where the divorce is actually sought. And this is mainly because the district court has a maintenance code. I'm not sure, what is your view on that? Is this not limiting these magistrates to be able to deal holistically with family disputes at a go and limit the chances of litigants spending more money by going from one court to the next? Because what I've seen is they tend to provide or to order a token maintenance so that the parties can later on go and fight their maintenance issue at the maintenance court. I'm not sure if you are aware of that and you have any views with respect to that.
Specifically, I'm not aware of that. There could be, and I take your observation, but I also agree with you that the ordering of token maintenance, which at the end now necessitates that a party must now approach the magistrates court, really in itself has an effect of delaying justice, if any. So where I sit, and because I know I'm in a training committee of magistrates, is something that I can take up to say, encourage magistrates, that regional court magistrates who are doing civil work, that they take a holistic approach of these matters.
That will really assist. Thank you very much, CJ.
Thank you, Prof. Well, thank you very much, Ndati. I'm scared to try to say your name. I suspect I'll damage it. Thank you very much for making yourself available for the interview.
Thank you, CJ.
You're excused.
Thank you.
Good afternoon, Advocate.
Good afternoon, Chichi.
How are you?
I'm fine in you, Chichi.
Good. You studied at VETS
Yes, Chichi.
and obtained which degrees?
BA in philosophy and law, and then LLB and LLM.
An LLM in competition law and media law.
Yes, Chichi.
But before you went to university, you did a whole range of things.
Yes, Chichi. It's a
You were,
convoluted history. It's a long history.
yeah, yours is a truly remarkable story, I think. You worked as a farm worker, you were barely a man, you were just a boy, really, when you started working as a farm worker.
Yes, with CJ, I needed money to go to the to high school. I had
So you
finished
left
prime.
school before you finished your matric.
I beg your pardon, CJ.
I'm asking if you left school before you finished your matric.
Yes,
Mm-hmm.
but the farm stint was before I went to the high school, just finishing primary school.
Then you were golf caddy at some stage.
Yes.
And then you went to work in the mines.
Yes, the golf caddy was still during the time when I was still in high school.
Oh.
And then I ended up with the certificate called JC, Junior Certificate. And then I couldn't complete my matric. Then I went to work in the mines as a miner and a security guard.
How old were you then?
I was about 17 when I went to the mines.
And you worked underground,
I worked,
loading stone.
Yes, I worked underground for almost 6 months until an unfortunate incident where some of my co-workers lost their lives. Then I asked the security people to show me where the security office was, and I then asked for a job there because I was scared to go back underground.
Yeah, my goodness. How long did you work in the mines? I count, well, we say between 1981 and 1989.
Yes, I think I worked in the Barberton mines until 1989. Then I came here in Joburg in the same year, 1989, and I worked for a mine called JCI at the time in Randfontein as a security guard. Then I quit and went back to complete my matric.
That's commendable. And here you are today.
Yes,
All right. I see that you were quite active at the University of the Witwatersrand. You were a member of the SRC. You tutored undergrad law students, and you helped set up a center, the Wits Law Students Council Writing Center.
Yes.
What was that for? What did it do?
The writing center at the time, CJ, it was during the time when the LLB degree was now downgraded to the undergraduate degree. Maybe I was the last. I was in the last group to do LLB as a postgraduate. Then we realized that people who were coming straight from matric to do LLB were struggling with assignments, and we then fundraise with other core members of the Law Student Council, including Professor David Belches, who's acting in your court,
Well,
and
not
also
anymore.
and also Professor Bonita Mesfield, who's still at VETS. And with the assistance of the law firms, we then managed to establish that writing center. So how we ran it is the top student will then mentor the undergraduate students.
All right. Okay, then fast forward. You did pupillage in 2004 and directly thereafter started practicing as an advocate.
That's correct, CJ.
And you continued until you took silk in July 2020.
Yes, the recommendation was in 2020. Yes.
Mm. So, what kind of cases have you been doing at the bar?
My practice is a general practice, CJ. As you have seen in my application form, spread. Uh, I started with administrative law, mainly on mining, uh, and then competition, and then medical negligence and criminal law.
And I see that you are continuing with what you started at university. You still mentor and train pupils and young members
Yes, CJ,
of the bar.
I'm a trainer in the advocacy training that is now it's convened by Advocate Makola SC.
And you also assist with moot competitions.
Yes, CJ.
And you are a member of the Johannesburg Society of Advocates Sexual Harassment Committee. What are the responsibilities of that committee?
We are trying to assist members who have been sexually harassed by co-members internally within the Johannesburg Bar Council.
Mm.
Yes.
All right. Are there any judgments, reported judgments, um, of matters in which you participated as counsel?
Yes, yes. There is one that is reported in the Competition Appeal Court and about 3 in the Gauteng High Court.
Mm. And you started acting as a judge in the Gauteng division.
Yes, and
When?
I think in 2019, but I started doing the pro bono ones. Until last year, I did 2 full terms last year. No, this year, I did 2 full terms.
The first and the second terms.
Yes.
So that's 3 full terms then.
Yes. And
Plus the pro bono work, you can't quite.
No, I haven't done any pro bono acting stint. All of them, I did the first and second term, and the third term was not entirely the whole term, but about 2 months of that.
Are you saying you acted pro bono throughout?
No,
all right. What did you say about pro bono?
I said this year I haven't acted pro bono.
Oh, all right. I was going to ask how you, well, who am I to ask counsel, senior counsel, that kind of question. You have written judgments in the High Court.
Yes.
How many?
According to my spreadsheet, I think I've got 43.
Mm-hmm.
Yes.
All right. In what kind of matters?
They vary, CJ, commercial and criminal, and I was sitting in full court, civil appeal court, full bench, and full court.
Mm.
Yes.
Did you get to conduct any trials, civil or criminal?
Criminal, yes. During my third term, I was doing, my second term, I was doing criminal. I was in the criminal court.
How many criminal trials have you done?
5.
Mm-hmm. Completed them?
2, I've completed them. 3 are still part yet. I was dealing with one today, hearing evidence in respect of sentence. And the other one, I heard evidence in respect of sentence last week.
So you are acting at the Gauteng division of the High Court as we speak.
Yes.
All right.
And then there's one where I'm still dealing with the trial. That one is also part yet because I think I shot myself in the foot, CJ, because I exercised the court's right to call court witnesses in terms of Section 186.
Yeah.
And I still have to hear those witnesses next week.
When you submitted your application to the JSC Secretariat, you listed 8 reserve judgments, the oldest going back to September last year.
Yes, CJ, and unfortunately,
What is the status of these matters?
unfortunately, some of them were quite late, and it's regrettable, and I apologize. But one of the reasons is that I wrote those judgments, but I was waiting for my co-judge, who was not available to look at them. But as we speak, all of them have been delivered.
All 8?
All of them. The only reserve judgment that I have are the ones that I'm dealing with in my Part 8 criminal matters.
Or had you sat in were they appeals? All of them? I hear you speak of a court judge.
About 2 of them I was waiting for the court judge, and then the other one was my own delay. It was a review, but that has also been subsequently delivered.
That accounts only for 3. What about the other 5?
Let me just
In which ones did you sit alone, and in which ones did you sit with another colleague or colleagues?
Let me look at my spreadsheet.
You can just go to your bundle at page 19. That's where your application form is. Have you found the page?
Yes. The first one, I was waiting for my co-judge, and the second one.
And who was that co-judge?
I beg your pardon?
Who was the co-judge? Do you remember?
Yes.
Who was it?
Judge Kumalo. Yeah, and he was engaged in the labor court at the time when I was looking for him. He was in the agent court at the labor court.
Okay. And the second one?
Both. Then the rest are mine.
So 7 are yours?
Yes.
And why did you delay the judgments?
I think, CJ, I shot myself in the foot by acting for 2 terms consecutively, and I was not able to complete the judgment because I was also running my practice after the recess, and I postponed some of my arbitration to those dates, and I couldn't complete them on time.
In fact, you can take numbers 6 to 8 off the list because the others were reserved just on the last day of April, and the other one was reserved in June. So it's the 5 that we are worried about, really.
Yes, and that's the reason, CJ, because although I've acted for most of the time this year, I didn't close my practice, and we agreed with with JP that I shouldn't close my practice. But the price that I pay was also to juggle my practice with my acting stints, and that largely contributed to that. But as I said, CJ, it is regrettable, and I apologize.
But they've been delivered.
Yes, all of them now. As I'm sitting here, they are all have been delivered.
Okay. JP Mlambo, do you have questions for your candidate?
Thank you very much, Chief Justice. Advocate Mkabela, good afternoon.
Good afternoon, JP.
Yes, you've been taken through your cases by the CJ. Mine is to help you show the Commission what you've done and where you've acted. I focus mostly on the difficult work areas. Your spreadsheet illustrates that you've done a total of 43 weeks acting. These are all stipendiary. No, I think the first 4 were pro bono, if I'm not mistaken. Am I correct?
Yes.
Thank you. You've done 6 weeks of opposed motions. I think you're the second highest in that range. And then, but you've done 1 special motion and 4 urgent courts. Is that correct? You agree with it?
Yes.
And you also agree that urgent court work is a difficult work area in Gauteng.
Yes, indeed, JP is very difficult.
Yeah. I would imagine, because I want to move on to your judgments, having done 6 weeks in the opposed motions as well as in the urgent court, this is the reason that your reserve judgment record is not that pleasing. You agree with me?
Yes.
I can take you through. You've written, I'll tell you now, some 47 judgments.
Yes.
Yeah. And I want you to comment on this because it's only fair. You're a senior member of the bar. I've had other senior members of the bar coming to act, and they also have practices, but your record, you have, according to this, there are 5 judgments which took you 7 months to finalize. I can show them to you if you want.
No, I agree.
There is 1 that took you 9, I think there's 2 that took you 9 months. There's 1 that took 13 months. There's 1 that took 12 months. And I think another 1 that took 5 months. It's not that great. Do you agree with me?
Yes, JP.
Now, these are the questions that this body asks itself to say the problem we have with reserve judgments needs to be addressed. And especially here, when a candidate stands for judicial appointment, we check how the candidate has fared acting. You know, Judge President Mwepe used to say this body must caution against creating permanent problems. What he meant was a judge becomes permanent. And if a judge has a problem with reserve judgments, that problem is permanent until the judge retires. You understand what I'm trying to say?
Yes, JP.
So I'm raising all this in all fairness to you because I want you to tell this commission what is it that will change. Because these reserve judgments are not only in 1 term, they straddle your whole acting career from when you started till recently. You've been picking up these, and I mean, the 12 months one, the 13-month one concern me. But what is it that you think will change, and what will make it change for us not to see this problem recurring? Should you be recommended for permanent appointment?
Thank you, JP. I think what will change is that I will not be juggling my practice now with acting. It has always been a challenge if you don't close your practice and you act for quite some time.
Yes.
You still have to do your private work, and that also could take you time.
Yeah.
But if I'm appointed permanently, that problem of taking time to deliver judgment is not attributed to a lack of ability to write them, but juggling practice and acting.
Yeah. A problem that I've identified, and I think I'm just raising with you, is, and I think it applies to you as well, You don't use the researchers to help you. Is there a reason why?
Recently, I've used them. All the judgments from this year, JP.
Well, I'm happy to hear that this year you have, because some colleagues of yours who act in the High Court don't use the researchers. And when I say use the researchers, is you don't ask them to write your judgments. You ask them to assist with the research underlying your reserve judgment.
Yes.
Right. So a lot of your colleagues prefer to do their own research, when it delays things. So you say this year you've started using them.
Yes, I started using them during my second term.
Yes.
One of the senior Judge Kuvaji, even impressed on me that they are quicker to assist us, and I found them very helpful.
Yes, they are quicker and they are very good. Just that they are overworked, and the minister is here. She knows that a division as big as Gauteng with about 84 judges relies on 12 researchers. So sometimes they battle to.
Yes, and they will tell you that give me maybe another 7 days or 8 days to return your judgment, because they are not only dealing with you alone.
Yes.
Yeah, but they are helpful, JP.
Okay. So, in all fairness to you, out of 5, how would you score yourself for reserve judgment? You see, my scoring matrix is if you've delivered all your judgments before the end of 3 months, I give you the total, that's fine. If you have some that have gone over 3 months but less than 6 months, you go to 4. You go beyond 6 months to 9 months, you go to 3. Beyond 9 months over, you go to 2. The score decreases the longer you take with your judgment. Taking account of your own record, where would you score yourself?
Objectively, JP, my own record will be 5, because some of the delays I was waiting for my co-judges.
All of them?
The one that
you mentioned
longer, the one that are longer, the longest one I was waiting for my coach.
Okay, so the 2, the 12-month and 13-month one.
Yes.
Okay. But the others are yours?
Yes.
Okay. Okay, thank you very much, Chief Justice. I've got no further questions.
Thank you, JP. Premier?
Thank you so much, Chief Justice. Good afternoon, Advocate Mkavel.
Good afternoon, Premier.
I was checking with the JP, that this is the Mkavel I know, because ever since I became a member of this, I've been confronted by application. So I just want to wish you well. Thanks.
Thank you.
Oh, sorry. I'm reading emails from work. I'm juggling my constitutional court emails and this interview. Some of the things we have to do. Questions, colleagues? JP Tlaletsi?
Thank you, Chief Justice, and good afternoon, Mr. Mukabele SC.
Good afternoon.
Yeah, I just want you to clarify something, lest there be any confusion. And I do appreciate that it's quite difficult being a single practitioner or an independent practitioner to allocate such a lot of time to act, which every head of court would gladly accept and wish to have. But now please clarify, if you say you did not close your practice during the period, if I did understand, hear you well, does it mean you're also practicing? And what kind of practice, if that is the case, were you appearing in court representing clients and also being an acting judge? Just to clarify that, thank you.
Thank you, JP. No, I was not appearing in court. I was just dealing with some drafting and reading.
Thank you.
Acting President Zondi? Oh, you
Sorry,
were drawing
no, I
my
don't have
attention
a
to him.
question. Yeah, I was just drawing your attention to
No more
JP
hands
Tlaletsi.
here. Okay, thank you. Thank you, AP. Commissioner Hassan?
Thank you very much, CJ, over here, advocate. Mine is less of a question and perhaps more of a comment. Just on a maybe on a lighter note, I was also not too long ago a student at Wits University, and I quite regularly attended the law writing center. So it's on a lighter note to meet some of the people who founded that program. Sometimes it helped me, sometimes it gave me more anxiety, but not because it was inefficient, more because I was always a last minute kind of student. CJ, that was it. I'm very comfortable with the line of questioning that the JP and yourself led. Thank you.
Thank you, Commissioner.
Commissioners on the virtual platform, do you have questions for
Thank you very much, CJ. Good afternoon, Advocate Mkabela.
Good afternoon, Commissioner.
Did I hear you correctly that amongst others you also do commercial arbitrations?
Yes, that's correct.
Yes. Yes, can I please ask you, because it seems to me that a lot or some or most of the business people are choosing not to give the High Court or the courts generally an opportunity to develop jurisprudence in that area of law. And they choose to do that kind of work privately. And you find that the awards that are granted, they are shrouded with secrecy. So we don't know how actually this thing works. What do you think should be done to expand the expertise in as far as arbitration work is concerned, and ensuring that at least the courts get the bite at it, and so that the jurisprudence relating to that kind of work can actually grow? Do you think there is something that can be done under those circumstances?
Thank you, Commissioner. I think what could be done maybe to codify the jurisprudence that is developed in the context of private arbitration. Maybe if there can be our own law reports that can be accessed by law students and stakeholders, that will help. But as far as expanding arbitration is concerned, the AFSA conducts a number of training, and people are always encouraged to attend and acquire the necessary skill. And recently, the JP is on record to encourage litigants also to make use of arbitration and mediation prior to approaching our courts. So if that advice is heeded, it will go a long way.
Thank you very much, Advocate Mkabela. Thank you very much, CJ.
Thank you, Prof. No more hands? All right. Thank you, Advocate.
CJ, can I say something to the candidate?
Oh, yes.
Advocate Mkabela, your history at being a farm hand at a very early age reminds me of a very painful part of my history. My father, when he was of the age, around 7, where the farmer expects the children of the people who live on the farm to work on his land, when he was of that age, he refused to go work at the farm, and he'd heard that you can get an education. And because of that, the farmer evicted them from the farm. They spent the next 2 years being homeless. So that's the chord you touch in me. You come from those roots, and you are here today. I want to applaud you for that. Thank you, CJ.
Thank you, JP.
Okay. Well, thanks very much for making yourself available for the interview, Advocate. You're excused.
Thank you.
Okay.